totally have a reality show. I mean, I don't think you'd like want it out there if you want to run for re-election, maybe, but.
Okay.
We're about to be live.
We're about to be live.
And we're live.
Good afternoon. This is the House Judiciary Committee. It's the 23rd of February, 2021. We have a wide range of different bills today, and we're going to try and keep moving the best that we can. We have 113 or more witnesses today, so that's going to be quite a bit. We do plan on taking a break at 5 o'clock tonight. It'll either be somewhere starting at 5 to 5:30, and we will stop for an hour, and then we will complete the bills. If we can get all of them done before then, all the better. We'll try and do that too. All right, but let's start with House Bill 882, Delegate Barron. He has two people to testify. It's himself and Karen York. We'll hear from Delegate Barron for 3 minutes and then Karen York for 2. Delegate Barron, whenever you're ready.
Good afternoon. Thank you, Mr. Chair, Madam Vice Chair, members of the House Judiciary Committee. For the record, I am Delegate Eric Barron, hoping that you will support and pass through your committee House Bill 882. House Bill 882 is basically a follow-on to a bill that we passed and last session and overrode the veto. That was House Bill 1336. House Bill 1336 addressed the unit rule, at least partially. The unit rule being the rule in our statute that prevents you from expunging something that would otherwise be expungible, including a non-conviction, if it's coupled with or charged in a unit of charges that includes things that aren't expungible. House Bill 1336 from last year, and that we overrode the veto, was a bipartisan supported bill. It did three things. It added fourth-degree burglary to the list of misdemeanors eligible for expungement. It prohibits Maryland case search from having non-convictions on it. And the third thing, which this bill addresses, is the bill established a partial expungement work group to try and figure out a reasonable way to address the unit rule. The work group portion of that bill was basically made moot by virtue of the governor's veto. That work group was supposed to meet over the summer and come up with recommendations for this session. The recommendations were due, I think, January 5th or January 1st of this year. What this bill does is basically bring back that work group so that we can finish out that portion of the bill and try to address this problem of the unit rule and how to address a partial expungement. So the work group portion of that bill that we passed and overrode the veto is House Bill 882. There's an amendment that you have that addresses a correction from the Department of Legislative Services. It basically says that the judiciary member of the work group is appointed not by the governor, but by the chief judge. That was requested by the judiciary. I think that was reasonable, so I put in the amendment. The judiciary does not oppose the bill. I would ask that you pass it so that we can complete the circle, finish out the work that we did last year, and finally and completely address the issue of partial expungement. Thank you.
Great, thank you very much. Are there questions? I don't see Karen York. You don't? That's okay. I don't see Karen York. So, okay, we're going to have to keep going. Are there questions for Delegate Barron? Delegate Anderson.
Yeah, thank you, Mr. Chairman. Delegate Barron, your amendment says what again?
The amendment changes the judge's appointment from being an appointment by the governor to an appointment by the chief judge.
Okay, so on the first page of the bill, where it says The work group consists of 2 members of the Senate, 2 members of the House, the public defender or designee, and then 1 representative of the administrative office of the courts appointed by the governor. That's going to be changed to appointed by the chief judge. Okay. And the administrative office of the courts, so that's not going to be a judge, right?
You know what? I think that's probably going to be a judge, but, I think, they should be represented, and I'll leave it to them who they actually who the chief judge thinks is the right appointee.
Okay. So if you can have 2 members from the House, 2 members from the Senate, could I suggest that we have 2 members from the courts, 1 from the circuit and 1 from the district court?
I wouldn't have a problem with that amendment at all.
Okay.
Yeah.
It's just that there are differences in terms of how each court is administered right now. You have, MDEC pretty much in like 22 of the jurisdictions as far as circuit court is concerned, but then you have a consistent administration throughout all the district courts. So I just think that perhaps we would have 1 member from each court.
My assumption would be that, under the way the bill is now, that representative would be, kind of addressing the overall concerns of district and, but certainly if you and the committee think that is a better way to go, then I certainly wouldn't have a problem with that.
Okay, I'm just saying, I'm not saying it's a better way to go. I'm just saying, I'm just trying to think this through. I just read the bill a few minutes ago. I was just asking really for your opinion of it, to whether or not it might be more efficacious if we have, both courts represented and that they be judges. I'm not sure the administrative office of the courts, I guess that could be judges. Okay. All right. Thank you, Mr. Chairman.
There are further questions for this panel or the delegate? Seeing none, we thank you very much. And that concludes testimony for House Bill 882. Is Delegate Grammer back? We're going to Stephanie Smith next. We're going to House Bill 1316. Delegate Smith, joined by Michelle Wurzberger and Eric Melancon from Baltimore Police Department. We'll hear from Delegate Smith for 3 minutes. Then we'll hear from each of the 2 witnesses for 2 minutes. They're coming into the room right now. And Delegate Smith, whenever you're ready.
Thank you, Mr. Chair, and thank you, Madam Vice Chair, and all the members of Judiciary. For the record, I'm Delegate Stephanie Smith, and I'm here presenting House Bill 1316, introduced at the request of the Baltimore Police Department. And let me go quickly into the summary of the issue and what the bill is seeking to address. As you are all well aware, the DOJ report that ultimately resulted in the Baltimore Police Department and the city entering into a federal consent decree found a number of important inadequacies. One of the most damaging was the lack of close and effective supervision. To address this deficiency, BPD has been required to make systemic changes to how the department supervises its members, as well as how frontline supervisors are selected and trained. As mandated by the 3rd-year monitoring plan, the Baltimore Police Department worked with its federal consent decree monitoring team and the Department of Justice to develop the department's new policy to guide the promotional process for those seeking to ascend to the ranks of lieutenant and sergeant. So currently, this policy 1721 that we are proposing would establish a fair and equitable promotional process by ensuring that all interested members of the department are aware of potential openings and understand the criteria for promotion as well as the process for selection. Moreover, it requires a holistic review of each candidate's qualifications, including prior performance as observed by their commanders, recognitions, awards, and commendations, early intervention system data, inquiries into the nature of any complaints and or sustained disciplinary infractions, regardless of the ultimate disposition. This holistic assessment of a candidate's suitability represents a significant departure from the way that promotional selections were made in the past. The current law actually requires that although the commissioner may set certain minimum qualifications, he or she is only permitted to consider the candidate's score on the promotional exam when making appointments. The department must make appointments from those applicants who place within the top 5 positions on the active promotional list. This requirement is referred to as the Rule of 5 and does not take into account the distinct possibility that one or perhaps all of those possessing the top 5 test scores are unsuitable for supervisory positions. There have been several instances where candidates have been deemed unsuitable for promotion, but the department has been required to promote the candidate anyway because of the Rule of 5. In each of these cases, the Rule of 5 allows the department to pass over them for consideration. However, once a total of 4 unsuitable candidates have been identified, the department is now forced to authorize promotion for the next person on the list from that moment forward. So that's the current situation. We're hoping through this bill that it would enable the department to make appointments from applicants who, as drafted, would be within the top 20. But after considerations and discussions with the delegation, there will be an amendment offered to expand it to the top 25%. So instead of a straight numerical number, a percentage of applicants to empower the department with the option to strike any candidate who fails to meet the following criteria. They have been found, there have been findings of a sustained misconduct complaint, either by the Civilian Review Board or by a disciplinary review committee. And termination is a possible punishment for the allegation. So with your careful consideration, I do hope that we can gain support for House Bill 1316, and thank you for your time.
All right. We'll not go to questions just yet. We'll hear from Michelle Wurzberger from the BPD.
Good afternoon, Mr. Chair, Madam Vice Chair. My name is Michelle Wurzberger. I'm the Director of Government Affairs for the Baltimore Police Department. I think Delegate Smith gave you a really good view into how it impacts our implementation of the consent decree, but there's a couple of other things that we just kind of want to raise. First and foremost, over the last 9 months, legislatures, police departments, and communities have been really debating how we go about, making sure we have proper accountability for officers. How do we go about reducing incidents of excessive force? Even your committee is debating those types of topics right now. Another thing that they're thinking about is how do we ensure that officers are proactively developing positive relationships with the communities that they serve. And we think that this bill will allow not only the commissioner, but our promotional committee to look at sergeants and lieutenant candidates in a holistic manner. It'll allow them to consider whether or not an individual has developed meaningful relationships with the communities that they served in certain districts, and whether or not they have fully embraced the consent decree. Right now, the promotions committee and the commissioner are only permitted to look at that test score, which we believe is important, but there's other things that need to be looked at. And so just in terms of practice, so the list comes out, the top 2 scoring people on the list are great. And so they get promoted on, and then there's new vacancies. But candidates 3 and 4 are a little bit more problematic. So candidate 3 has an active investigation on a serious ethical or misconduct allegation. Candidate 4 has documented statements where he is mocking and belittling and dismissing the efforts of the consent decree, including the new use of force standards. And so we don't want those candidates to be promoted. We're pretty sure you don't either, and so while we recognize the importance of the promotional exam, we really want to make sure that we are able to promote those people who are in the right frame of mind, have the right perspective to mentor, guide, and most important, hold frontline officers accountable. And so with that, I will stop talking, but I respectfully request a favorable report.
That's fine. Thank you very much. Are there questions for this panel? Seeing none. Delegate Anderson.
Yeah, thanks, Mr. Chairman. Ms. Wurzburger, with regard to the, between the time the applicant applied for the promotion and the time that the applicant is to be selected for the promotion, a misconduct complaint for which the punishment could be termination. So does the complaint have to be already sustained, or is it just a pending complaint?
Yeah, no, that's a really good question. And I will say that the language there is a little bit wonky, and I'm going to own that. We are trying to clean it up a little bit, but it does have to be sustained.
Okay.
It does have to be sustained.
So it's not just a complaint, it's a sustained complaint.
Correct. Yes, sir.
The punishment could be termination. Now, given the fact that the board can find one way and the commissioner could take a different action, does that make any difference? Commissioner,
So in order,
go ahead.
yeah, that's a good question too. So one thing, we are going to be submitting an amendment that says either the CRB, right now the bill says references the Civilian Review Board, but we're also going to add the department's disciplinary review committee. One, it doesn't matter which one gets to it first. If either of them makes that sustained finding, then that person can be stricken. They don't have to be, but if there is a sustained finding and they could ultimately be terminated, then that gives us grounds to fire them.
Okay.
That gives us grounds to terminate or remove them from the promotion list, because we don't want that type of individual to be promoted.
Okay, and right now, if 4 people meet that particular criteria that are on a promotion list, then you just go to the next total 5, is that right?
Yeah, so we go down until we can't go any further. And there
All right.
are times when we have to promote the least worst option, which is
Okay.
not optimal.
And if you change this to a percentage,
Mhm.
25%, instead of saying the number 5, then your amendment will have to include that possibility. And I'm not sure how do you measure that in percentage at that point?
So we are working on that language. And we're real close. We're trying to get it completely right. And the reason we went from a regular number of 20 to 25% is because sometimes the list is large, sometimes the list is very, very small. And so we thought, in the interest of fairness, that we would make that number commensurate with how large or how small the list is.
Okay, because I would assume that the list for lieutenant is a lot smaller than the list for
Yes.
sergeant.
Yes, sir. You are absolutely correct.
Are those the only 2 positions being contemplated by this bill?
Yes, sir.
Sergeant, lieutenant, not because major is appointed by the commissioner. And actually, we have captains now too, don't we?
We do. We do have captains and majors. And I will point out that, again, this and the promotions of our command staff, we are approaching them very differently than we have in the past. We have policies that guide how we are to do that. There is a committee for both sets of promotions that includes our equity officer, and each individual is provided a score. Both of those policies were developed in cooperation with our monitoring team, the DOJ, members of the department, and the public, so that we would have, again, what we didn't want to do is go back to the days before where folks got promoted because maybe the commissioner liked him or someone in command liked them. We just wanted to have some fairness.
Okay,
Yes, sir.
but there's some work needs to be done on this bill.
Yes, sir. We are very close.
All right, thanks.
Yes, sir.
Delegate Deborah Davis, then McComas.
Thank you, Mr. Chair. This question is for Delegate Smith. The reason that you have to come to the legislature to make these changes is because Baltimore City doesn't have control over their own police force, or they don't have, is that what it is? And this is going to be.
Yes, I'm glad you mentioned that, because particularly some of our newer Members of the body may be wondering why I'm even here talking about a policy matter such as this. But since the late 1800s, the Baltimore City Police Force has been recognized as a state agency from the perspective of policy, even though we do pay for the police, we do have to come before the body for these types of policy questions.
Delegate McComas.
Just briefly for either Ms. Würzburg or Delegate Smith. You're saying that if someone uses abusive language, that could be, in other words, they don't do the false arrest or they don't do a forceful arrest or things like that, but they just use abusive language. Maybe they slammed the finger in the door of the police car or something, that could be potentially a reason to knock them off the list.
No, if I could just stop you right there. So it has to be, in order to be stricken from the list, it has to be a terminatable offense. That the suggestion that you just made is not a terminatable offense. However, we may want to, rate them higher or lower given the facts of that circumstance.
Okay. Well,
but they wouldn't necessarily be removed from the promotion list.
The other question I was curious about is, okay, right now you have the 5, and the 5 are because they're selected by the test. If that's not working, why haven't, in other words, we've got a bill here, okay, but why hasn't the department decided that is not workable? Originally, because they've had this for a long time, the rule of 5, correct?
So we have determined that it's unworkable, which is why we're before you today.
I understand, but how long has the rule of 5 been?
It's been in effect for quite some time.
Okay.
I'm sorry, off the top of my head, I can't remember when it was enacted, but it has been in effect for some time. And again, we have been looking at all of these processes through the lens of our consent decree, where we are required to make sure that we are providing adequate supervision at every level of the department, which is how and why we created the policies for promotion that we have discussed this afternoon.
Well, then just kind of a quick follow-up. If you have 20 people or 25 people, which you wanted amended, and let's say everybody likes John, he's kind of lower on the list, because he's just a nice guy and, he makes sure that everybody gets a Christmas present and everything. Doesn't that kind of, aren't we kind of hearkening back to before the LEOBR went in place and things like that, because the chiefs and the command staff was messing with officers, like if they didn't shine their shoes correctly or they just didn't like them, so they'd start picking at them for different minor offenses that had really nothing to do with law enforcement as far as doing the job. It was more cosmetic. So I'm kind of worried about that in other words, you expand the universe, then you can maybe move some people that you want there, as opposed to, just a select group that for the top.
Yeah, no, I think that is an excellent question. And I have a couple of responses to it. And so first and foremost, that is why we're not necessarily trying to get rid of the whole process, but say, give us some flexibility, because at this point in history, and certainly in Baltimore City history, we have to be very selective about who we are promoting into these positions, right? We need to make sure that we are promoting folks who are embracing the reform effort completely, not folks who are of the old line guard who are going to say, yeah, I know what the policy says, but this is how we really do it. Okay, so that's first and foremost. And this scenario that we have presented before you gives us that flexibility, while also giving some deference to those who score high on a test. Now, the other kind of piece, this is the accountability piece. And what I will tell you is that everything we do, literally every single thing we do, is reviewed by our monitoring team and the Department of Justice. We are audited, we are reviewed, everything is reviewed. So if we are promoting folks kind of willy-nilly and not following our policy, we will absolutely be held accountable. The other item that I want to note that I think is really important is in the policy, there is a provision where officers who feel that they may not have been scored adequately or appropriately can go to our equity officer, again, who sits on that promotional committee, to have that re-reviewed. Again, we're trying to establish some systems of checks and balances. And the whole point of having this equity officer, which we didn't have to do, but we've had for quite some time, who's doing a whole equity plan for the department, is to make sure that we're looking at those things that they talked about in the LEOBR, where maybe the agency didn't promote women or officers of color. You know, we are trying to really be fair, to try and be impartial and make sure that we are in fact promoting those people who are going to move this department into, you know, becoming the comeback story in America, the greatest comeback story in America.
Great. Are there further questions for the panel? Seeing none, thank you all very much. That concludes.
Thank you, sir.
Thank you. That concludes the testimony for House Bill 1316. We're going to go now to Delegate Alonzo Washington to House Bill 1248. It'll be Delegate Washington and Kimberly Watts testifying. Delegate Washington testifying for the bill. Kimberly Watts has indicated she's testifying in an informational capacity, so we'll see. So Delegate Washington, please, for 3 minutes.
I get 3 minutes today. Thanks. Not 2 minutes. I appreciate that. Thank you, Mr. Chairman and Madam Vice.
Now you have 2 minutes. Come on, 3 minutes. Here you go.
Thank you, sir. And good to see everybody. For the record, Delegate Alonzo Washington here to present on House Bill 1248. I think some of you know, at least I know the Vice Chair and Delegate Fisher knows that I chaired or co-chaired a Prince George's County work group on police reform that simultaneously met during the same time as the speakers work group on policing. And what we found is that the data collection on these the costs of incidents that are happening with the judgments for these for police officer incidents are not being tracked, and they're not being placed in a certain not being placed online for that's accessible. And so what I came up with in this bill, it would directly increase the level of transparency on settlements and lawsuits for departments across the entire state. I figured if we're having an issue in finding out where these numbers are and how much we're using it and the age and gender and ethnicity of everyone involved in the incident, then other jurisdictions must be having the same issues as well. And so what this bill would do is require that all agencies, including the counties, collect this information on an annual basis and provide that information to the General Assembly and post it online publicly through GOCAP or the Governor's Office of Crime Prevention, Youth and Victim Services. I think most of you already know that we have plenty of settlements or renderings that are happening in Prince George's County. We recently heard one that was for $20 million that made the news. And then there's another court case that's happening that's costing our county another $10 million. And the only reason we know that information is because it's actually because we hear it in the news, and it's not anywhere that can be tracked in any data or any place in the online where it can be found. So I'm asking for transparency in this, and I hope for and urge a favorable report on this bill that seeks to make sure that we understand how much money we're spending on police involved incidents that occurred throughout the state.
All right, thank you very much. It turns out that apparently Kimberly Watts not here to testify on Delegate Washington's bill. So Delegate Washington is the only person here to testify on his bill, and that's fine.
That is fine.
Questions for Delegate Washington? Delegate Juanita Fisher.
Thank you, Mr. Chair. Hello, Delegate Washington. I wanted to ask you to expand upon some local departments outside of our county are smaller, we've heard a lot about that in this committee. How would your bill support them in that collection of data? And I guess would the system be tracked through a state agency that they would just import it into? If you could expand upon that, that'd be great.
Oh, thank you, Delegate Fisher. That information will be housed. It will be reported to the General Assembly by every agency within the state. It will be also reported to the Governor's Office of Crime Prevention, Youth and Victim Services. We're collecting data from each agency on judgment and settlements, and we want those reports to include the age, gender, ethnicity, race of everyone involved in the incident, including the law enforcement officer, a description of the incident, including date, time, location, and what actually happened, the dates the civil action was filed and resolved, and the amount of the settlement or judgment awarded to the plaintiff. So all the information will be provided to the General Assembly, and it will be placed on it'll be collected by GoCap. I don't think they're called GoCap anymore, but that's their formal name, right?
Delegate McComas.
Thank you, Mr. Chair. Delegate Washington, I just have a question. Do you expect this data to go out to the public? And there's a reason why, if you say yes.
Yes.
Okay. What I'm concerned about is a long time ago in a galaxy far, far away, I was on the local government insurance board, that the review board for the lawsuits and everything. And I am concerned that a lot of the municipalities and some of the counties are members of the local government insurance trust, and they have really good lawyers. But this is basically, I think it's going to encourage litigation, because somebody's going to read that and say, oh, heck, the officer did blah, blah, blah. And I'm just a little kind of concerned about that, because at the end of the day, those premiums are paid by the taxpayers. So I just kind of wondered what your thoughts are on that.
Yeah, look, no, you're right. These premiums are being paid by the taxpayer. The issue that we're having right now is that we don't know how much is being paid to every settlement and every case that occurs. And I believe taxpayers need to know how much they're spending on police-involved incidents that occur throughout the state. And so as a taxpayer, I'm sure you believe this, that there should be some transparency in that for the money that I send to the state or to these local agencies, so that we know actually what's happening. And let me just say this, I sat on a committee, a task force, that looked at policing in my own county, and it took them months to get us the information that we needed to be able to review the number of how much they're spending on police-involved incidents in the county. So that's unacceptable, and we should, and our community should know how much we're spending every single year.
I appreciate that, but I'm concerned about the unintended consequences of this legislation. I think it could fuel more and more lawsuits and not less. Thank you.
Delegate Cham.
Thank you, Chairman Clippinger, and to Delegate Washington. Thank you very much. The question I had is regarding the compiling of these data and sharing them. I believe you mentioned with the General Assembly and posting it on the website. What is the purpose of the data? Is it going to be used to help solve a problem or something that's in question? Like, what is its purpose other than it just kind of being compiled and shared with certain people or entities? Thank you.
Thank you, Delegate, and nice to meet you. Congratulations.
You too. Thank you.
We haven't had an opportunity to say hi just yet. But what I wanted to say, what the first thing is that transparency, just simple transparency. I think that should be the case, because we're talking about taxpayer dollars here, and we're talking about the numbers and those incidents that occurred involving police officers. We're also looking at how, first is transparency. The next thing we want to make sure they know is if you understand the numbers, you get to the root of the issue that's occurring. So right now we don't really know what the issues are that are occurring without knowing these incidents? Do we need more insurance for the police departments? Do we need a different way of paying for these incidents? Do we need more training for our officers based on these incidents? What needs to happen so that we make sure that our taxpayer dollars aren't used for these police involved incidents? So, it's about transparency and also getting to the root of issues. We'll be able to understand it if we had all the data compiled in one place.
Okay, thank you very much.
Thank you.
Delegate Williams.
Thank you, Mr. Chair, and thank you, Delegate Washington, for bringing forth this bill. I just want to make sure I'm clear. So the reporting of these instances are going to be instances after a settlement or judgment has already been rendered. It's not going to be the reporting of instances that are pending during the course of litigation or where the settlement is currently in the negotiation phase. It's going to be at the end of the process, is the way that I'm reading the bill. And so I just want to make very clear that it's going to be at the end. Well, that's my question. Isn't that so?
That is absolutely correct. I wonder what district you're from, man.
Thank you. So
no sucking up to the other delegates, please. It's fine.
So anyway, it's already public at that point anyway. It's just compiling everything so it's at a central location, correct?
Correct. Yes, correct. So right now the information is all over the place. There's not one location for where we can find this information after the court renderings, not during while it's occurring, but after. And again, we won't know that information because the state doesn't collect it. Localities don't necessarily collect it on their own due to my own experience working with the Prince George's County Police Department. So, about having all in one location. So thank you for that question.
All right. Thank you. Thank you, Mr. Chair.
Thank you. Are there further questions for the delegate? All right, seeing Delegate Cham, I think you already asked your question, so just making sure of it. Are there any further questions? Seeing none, we thank you very much. That concludes testimony for House Bill 1248. As was a person testifying in opposition, Leon Purnell. We don't see him in the waiting room, so we're going to keep moving. Thank you very much. That concludes the testimony on that bill. We'll go to House Bill 1286 now with Delegate Grammer, who is testifying all by himself.
Mr. Chairman.
Grammer. Yes.
Leon Purnell looks like he's in opposition to 1284 and not 1248.
Okay. All right. Well, then that's fine. That makes a little more sense. I saw the address too, so that makes a little more sense. So we'll add it in there. All right, 1286 with Delegate Grammer.
Thank you, Mr. Chair. Can you hear me okay?
Yes.
Okay, excellent. For the record, House Bill, Delegate Grammer here to present House Bill 1286. I think Dylan's going to share the screen with me. I wanted to share a video if he could share the screen.
Delegate Grammer, I made you a co-host to share the video from your side.
Yeah, how do you, I figured there was a button that was going to come up, but I don't see it.
I have made you a co-host. So if you go to the screen share option down at the bottom of the Zoom window.
It's a green button that says share screen.
Oh, there we go. Here we go. I got it. One sec. All right, can you see the video?
Obviously, good idea in principle. It's my sense that it usually ends up being a little.
Can you see it and hear it okay?
Yes.
Okay.
More than a buzzword in practice. That police culture inevitably overwhelms it.
Well, that's the thing, though. I mean, I think culture, is the transmission of values, from one person to another. I don't know if it goes laterally or if it goes from, from the top down in terms of rank. You do as your commander, your captain says, you think the way he thinks. But it has to. I mean, I don't know. That's what I'm asking. Is there a path along which change can kind of travel?
What we have to do is we have to start thinking about what are we actually doing and what are our goals. So if our goals are to reduce violent crime, we have to change our metrics. So right now our metric is arrest. That's what judges and officers. So who's in charge of these metrics? It's command and it's politicians. So we have to change the metric to crime reduction, to justice, to problem solving. So that would be a continual metric where you would always have something to do, where you would always improve the community, because you should be focused on improving your post, not on locking up many of those people up on your post. Because if you're taking their freedom away, how are you not going to be their enemy?
To close out our tour, Mike took me to a part of Baltimore that was very different from everything we've seen so far. A white neighborhood on the north side of town. It's where he was transferred after about 4 years in the force. He found the contrast astonishing. He also found it difficult to make his numbers because all of a sudden he didn't have anyone to arrest. His solution? Drive 2 blocks away to a part of town where he could easily find young black men. So who would you arrest here? For what? It seems like you need a reason. You were saying earlier
But you don't. That's the thing you're not understanding. So like they were in the street.
That's it?
enough.
That's enough?
Yeah, jaywalking.
All right, I'm going to try and take my screen back. All right, I think I've done it. And I'll wrap up very quickly. This bill, House Bill 1286 requires law enforcement agencies to submit performance and evaluation metrics and performance quotas to the Maryland Police Training and Standards Commission yearly for investigation by the General Assembly. Mr. Chair, this bill's here because I still, quotas, the use of quotas in law enforcement are illegal. After we passed a bill about 10 years ago, making them illegal. I believe the use of quotas is still prevalent in many law enforcement agencies throughout Maryland. I think this is part of, the what we do in law enforcement is really what's in question. I think it bastardizes law enforcement. It's antithetical to community policing. I think the local law enforcement, the guys on the street, they hate it, but they feel stuck. And I think when it, as the video kind of illustrated there, I think it's a big reason why we see such disparate law enforcement in certain communities. I have a story, but for the sake of time, I'm not going to share that. But I'll close and hope to get a few questions, and we'd ask for a favorable report.
Are there questions for Delegate Grammer? Delegate Arakan.
Thank you, Mr. Chair. Delegate Grammer, could you tell me what the impetus for this bill was?
Yeah, I'll share the impetus, and it's something very specific. A friend of mine who's in law enforcement came to me and he shared a video with me. It was a video of a human trafficking bust that a local jurisdiction had made. And the video was the police chief in the state's attorney's office, in front of the public and talking about human trafficking, why it was terrible, and celebrating the fact that they had made this bust. And he said to me, I was told to stop working this case. And I was, that was what he did. That was what he investigated. That was what his unit did. And he said, I was advised to go work on things where I could provide demonstrable numbers to the public. And he worked this on his own time, and he ended up making, they ended up making the bust on this case. And I think what a lot of people don't realize is that bad policing is a function of bad leadership at times. I think, frankly, we ask the impossible of law enforcement, and the unwritten rules coming down on law enforcement are very political. I think the frontline guys absolutely hate it, but they feel pressured to do it. And I think frequently the results we get are a consequence of that. So I think we've made quotas illegal, but I think requiring law enforcement agencies to put it on paper to say, we don't use quotas is a step that we need to take. Also, I'd like to, when I sponsored the bill, I started having discussions with a lot of members of local law enforcement, and we had really great discussions. And, they said to me, like, if you don't actually put anything in place to require or have a punitive measure for doing something illegal, this is just this bill's is going to do the same thing as the first one did, and that's absolutely nothing. So I'd like to submit an amendment that made trying to enforce a quota the crime of misconduct in office, so that we really had some way to say, like, look, we don't want quotas, we don't want any unwritten rules, and if you try and push those on frontline law enforcement, there's going to be a penalty for it. But I appreciate you asking.
Are there further questions for Delegate Grammer? Delegate McComas?
Mr. Chair, just one quick question, Delegate Grammer. When Mayor O'Malley was the head of Baltimore City, he had, he would have the command staff come in, and I don't know if it was city stat or it was, but it dealt with everything that was happening to the different district precincts in law enforcement. And from what I gleaned, kind of third, fourth hand, was that it was very intimidating, that and it was very rough. And I would suspect that that kind of rolled downhill to the folks on the front line. And I just wondered if you wished to comment or you had any information regarding that when he was.
Yeah. So that's a lot of what the gentleman in the video spoke about. Essentially what they would do is try and have a demonstratable number. They'd come in and they'd arrest people for whatever. And in minority districts, you can do that a lot more frequently. What the bill that was actually passed by Delegate Smeagol, I believe, was passed in Martin O'Malley's tenure. And they had similar issues with law enforcement coming to them and saying, like, look, we're seeing these problems. We don't think it's right. It puts us in a terrible position. And then they banned quotas. Well, I mean, this is 2021. And, from what I'm hearing, we're still using quotas in law enforcement. And I think, a lot of what we see in the public is because the pressure that leadership puts on our frontline law enforcement. And I don't think it's right. And I think there's still more that needs to be done to fix this.
Are there further questions for Delegate Grammer? Hearing none, thank you very much. That concludes the testimony for House Bill 1286. We're going to move now to the first of two bills from Delegate Shetty, House Bill 763. Delegate Shetty is testifying by herself. Just one person. 3 minutes, please, Delegate Shetty.
Thank you, Chair Clippinger, Vice Chair Atterbury, colleagues. Really appreciate the opportunity to be before you today. For the record, Delegate Emily Shetty here to ask for your support of HB 763. This is a very simple bill. All it does is extends the deadline for the task force to study crime classification and penalties by 1 year. We had a very large job. We need 1 more year to do it. Thank you so much for allowing me to testify. Happy to answer any questions. I ask for a favorable report.
The questions for Delegate Shetty? Delegate Shetty, how many times did the task force meet since it was created?
I think we met monthly, maybe for a bit, or every other month. I mean, we met numerous times here in Annapolis and had a variety of experts come to share their views on how we could go about classifying the different crimes in Maryland. But as you know, Mr. Chair and colleagues on the committee, our criminal code in particular is very complex, and the work needs to be done, but we just need more time to do it.
Thank you. Delegate Anderson.
Yeah, thank you, Mr. Chair. 2 questions, Delegate. Number one, how often or how closely did the task force work with the Maryland Sentencing Guidelines Commission?
I can get back to you with a formal answer on that, sir. I don't recall. Maybe they're like a part of the task force. Let me, and I'll get back to you.
That's fine. And secondly, part of the bill from the last time was that this task force would send a report to the General Assembly on date. Did they do that?
No, sir. We sent a letter to the leadership of both chambers indicating that we need more time, which is the purpose of this bill, is to ask for 1 more year in order to complete the report.
Okay, thank you very much.
Yes, sir.
Thank you. Are there further questions? Seeing none, that concludes the testimony on House Bill 763. We'll go now to House Bill 240. We will have 2 panels. Delegate Shetty will get 3 minutes, along with Barry Scheck and Jeff Gillerin will each get 2 minutes. Then we'll hear from the remaining people who want to testify orally, who are all testifying favorable with amendments. So we will break it out that way into 2 panels. Delegate Shetty, you have 3 minutes.
Okay, thank you, Mr. Chairman. Thank you, colleagues. Delegate Shetty here to ask for your support of HB 240. As you may recall, this is a bill that will establish a regulatory framework for the law enforcement's use of familial DNA. I introduced this legislation last year, but withdrew the bill to improve it after request from advocates. Over the interim, the Senate convened a forensic genetic genealogy work group chaired by Senator Sidnor and myself. In the work group, we worked with advocates including the ACLU, Innocence Project, Maryland State Police, MSAA, OPD, the chiefs and sheriffs, as well as leading academic experts to craft what we believe is an incredibly strong first in the nation bill that properly balances the constitutional privacy concerns of individuals who are presumed innocent and defendants with the ability of law enforcement and prosecutors to effectively use this technology. Many of you may recall from the Judiciary Committee retreat in 2019, this is a really complicated and incredibly interesting evolving area of policy. The term familial DNA or genetic genealogy is the DNA made available through direct-to-consumer DNA companies like 23andMe and Ancestry.com, which is uploaded into open source genetic databases by the users. Many people choose to upload this information into databases like JUD in order to increase their likelihood of finding distant relatives and tracing their heritage. However, as these databases have grown and developed, they are now searchable and used by law enforcement in the pursuit of solving investigations, establishing probable cause for the issue of warrants and resulting in arrests. The most famous of these cases is the Golden State Killer case from California, which uses technology to identify the Golden State serial killer 40 years after he committed his first murders. Since the Golden State Killer case, around 70 cold cases have been solved through the use of this type of technology. There's so many legitimate public safety reasons why we want to continue to allow this technology to be used by law enforcement. However, there are also legitimate privacy and Fourth Amendment concerns that must be addressed as this technology becomes more prevalent. No one objects to the use of this technology for crimes of violence, murders, and sexual assaults, and this bill does not forbid the use of this technology for those cases. Rather, this bill simply seeks to establish a regulatory framework for its most appropriate use that balances the constitutional rights of all parties involved. Senator Sidnor, the crossfile on this bill, and I worked very closely and collaboratively with all stakeholders of the work group on both the base bill and 2 amendments that have been presented to the committee. You will hear from many of the advocates today on specific components of the bill that they advocated for and care about. I want to thank all of them for their immense contributions of their time and talent towards this very balanced and thoughtful bill. We ask that the committee please consider and favorably adopt both sets of amendments to the base bill, which adopts almost all of the feedback provided by all of the work group members. I've circulated both amendments as well as a reprint that shows the base bill with that was introduced with the amendments incorporated. Committee, you have my written testimony, which details the many elements covered by this bill. I thank you for your consideration, and I look forward to your questions and respectfully ask for a favorable report. Mr. Chairman, I would just add that those that you outlined as testifying favorable with amendment are actually testifying favorable with the amendments that I referenced as part of the bill. They may be of use to have them as part of this panel because they might be able to answer specific questions of members. It's up to
That's fine. Then let's bring in Scott Schellenberger, John Fitzgerald, Joe Riley, Richie Engelhardt, and Daniel Katz, and we'll just continue to move through the list. That's perfect.
Thank you, sir. Thank you.
All right, we'll go now. However, the next 2 people we will call for 2 minutes, Barry Scheck and Jeff Gillerin. So let's start with Barry Scheck. Now for 2 minutes, please, Mr. Scheck.
Yes, thank you very much. I want to thank very much Delegate Shetty and Senator Sidnor for putting together this blue ribbon panel. It's not every day that the ACLU, the police, prosecutors, innocence organizations, everybody, and geneticists work together and come to an agreement on a bill that protects the interests of law enforcement, and I should say innocence organizations, being able to use this technology to identify people who did commit crimes and exonerate those who didn't, who were wrongfully charged, while at the same time put in serious, meaningful protections of privacy rights for people whose genetic information may get involved because they uploaded it to some Ancestry.com or 23andMe or one of these direct consumer groups, as well as making sure that during the course of a forensic genetic genealogy search, when you start doing family trees, that the information about who is or is not your relative does not get out, because that can wreck families. And let me just finish by just pointing out, in the landmark decision of Carpenter, which dealt with digital information and the Fourth Amendment, Justice Gorsuch says that the usual doctrines from the Smith and Miller case, that is being able to get access to information that you've turned over to a third party like a bank, he says, and I'm quoting, can these cases secure your DNA from 23andMe without a warrant or probable cause? Smith and Miller say, yes, it can, at least without running afoul of cats, but that result strikes most lawyers and judges today, me included, this is Justice Gorsuch, as pretty unlikely. And what we have done in this bill is we put this genetic genealogy searching and the protection of this privacy information under judicial supervision. And that is why you see from the left and the right, Federalists, everyone can support this bill. If you pass this, it's going to immediately be a model for the nation, I guarantee you.
Thank you, Mr. Scheck. Thank you. Mr. Gillerin, please.
Good afternoon. My name is Jeff Gillerin. I'm the Chief Attorney of the Public Defender's Forensics Division. We're pleased to add our voices in support of the passage of House Bill 240. The development of forensic genetic genealogy, which couples genetic analysis with investigation of publicly available genealogy information, will transform law enforcement investigations. But with the promise of any transformative technology comes certain dangers. Without appropriate legislation, the use of FGG could lead not only to compromised cases, but also to violations of an individual's privacy and civil liberties. This bill is an important step in both protecting the genetic privacy of private citizens and the constitutional rights of individuals who may be arrested and charged based on evidence obtained through FGG. The first step to prevent the misuse of an investigative tool is transparency. And this bill ensures that all stakeholders, the public, those who are asked to contribute their DNA, and criminal defendants are provided with the appropriate information about the use of FGG. The drafters of this bill also have the foresight to include an oversight panel charged with making appropriate policy recommendations in the recognition that there may be the need to adapt this law as FGG meets the realities of law enforcement. Public defenders are honored to be included as members of this body. Under the leadership of Delegate Shetty, Senator Sidnor, Maryland is again at the forefront of crafting cutting-edge legislation that addresses the issues emerging as science continues to transform our lives. We want to again express our gratitude to Delegate Shetty and Senator Sidnor for their foresight in recognizing that FGG must be carefully and comprehensively regulated in a way that ensures policies and practices properly reflect a commitment to respect individual privacy and civil liberties. Thank you.
Thank you. Scott Schellenberger, please, for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. So just to give a little bit of history, in 2019, the first bill was an absolute ban on doing this type of research. And obviously, I came out very much opposed to that. I appreciate the work that Delegate Shetty and Senator Sidnor have done. We have come a very long way. I think almost all the parties, when you make a good compromise, are unhappy with the end product. So while I still don't know why I have to go get a court order to pull a piece of trash out of the McDonald's trash can, I'm sure there are plenty of things in here that that Mr. Scheck is not happy with. I had signed up to testify with amendments. One of them was a prohibition of phenotypic use, and I've been told that's out. One version I did see, it was out. One amendment that we had discussed that I thought was in, and I apologize to Delegate Shetty, it's hard to piece all these together, but we had always talked about this statute could not form the basis for an exclusion of evidence as long as the Fourth Amendment was adhered to. And I believe that we discussed that. Joe Riley had actually drafted language, and I believe that that needs to be in there. And finally, I'm still having a bit of a problem with the session I'm seeing, page 6, all the way down the bottom, number 2, where it says the fear that a third party will refuse informed consent may not constitute a basis for seeking covert collection of a DNA sample from a punitive person, meaning a potential defendant. I'm not really sure why we are conflating those two issues. If I go to a third party cousin for consent and they say no, suddenly I can't pick the trash up of a potential defendant. So other than those 3 places, one of which I have seen has been fixed, I have come a very long way in 3 years. And I believe if we get these couple small things done, this will be a very good bill and one that both sides can live with.
Thank you. John Fitzgerald, please.
Thank you, Mr. Chairman, Madam Vice Chair. I'm John Fitzgerald. I serve as a small town police chief in Montgomery County. In my 38th year of policing, in my 30th year as an attorney in Maryland, I'm here to represent the Maryland chiefs and sheriffs. I also applaud Delegate Shetty and Senator Sidno for putting together this very diverse group. So let me just tell you what this bill does. We are in support of this bill. As Delegate Shetty mentioned, we're in support of the bill including the amendments that have already been drafted. So assuming that all of those amendments make it into the bill, we are in support. This bill strikes a balance between this very important technology to identify people that do the very worst things to our Marylanders. Yet it balances that against the privacy concerns and the trust that we need from the public in this type of science. A couple of things, let me highlight what this bill does. It requires a judicial authorization to get started. It's not too hard to get, but it does require that. So there is some judicial oversight before we even begin. Importantly, there are use restrictions on DNA. So we don't allow DNA to be used for nefarious things and to find out health or medical conditions of people. We maintain confidentiality by law and we have to destroy it, but not too soon because we want to allow for post-conviction litigation. But what this does is criminalize bad uses and criminalizes a willful failure to destroy when it's appropriate. It requires informed consent with little exception, and that the informed consent comes with a script that notifies the person about certain things by law so that they have a full knowledge and they can make their decision with a clear head. And that script has to be either audio or video recorded, the entire transaction, by the investigator. It also requires judicial authorization before a covert sample can be collected. And it does these things to put guardrails on a very important science. So let me just close by saying, I think this is a really good effort at a very complicated topic. And I, once again, put a lot of credit on the colleagues that I worked with on this group, but also Delegate Shetty and Senator Sidno really did a good job being excellent listeners. Thank you.
Thank you very much. Joe Riley.
Thank you, Chairman Clippinger, Madam Vice Chair, distinguished members of the committee. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We are favorable with amendment, as was stated by Delegate Shetty, who I'd like to take the opportunity to thank now for this important legislation. As State's Attorney Schellenberger said, we've come a long way in some period of time. I've come a long way in probably a couple of weeks from the Senate to now. This is very novel type of legislation because it's a novel type of technology. I think you heard Delegate Shetty testify in the beginning that this was the same technology that caught the Golden State Killer. So that cleared 50 rapes and 13 murders. And it found who the perpetrator was of those crimes. So it's very powerful nature of the evidence, but we also want to seek so we want to be able to use this because it's very important cases, but we also want to strike a balance. And this work group, that was their intent, to make sure that we are protecting important privacy concerns. And I want to make sure the legislative history is clear that the purpose of the criminal penalty that we put into this legislation is the recommended sanction for what my colleague from the public defender was speaking about when we was talking about violations, that it's not to be the exclusionary rule, it's to be the criminal penalty that's described here, because who is really being harmed if this evidence is excluded? it's those rape victims, it's those families of those who are murdered. So unless there is a separate Fourth Amendment violation that can be articulated by the defense, this evidence should not be excluded. I sent an amendment at the last minute to Delegate Shetty. I hope it becomes a part of the bill to make what has been said in these work groups explicit in the law. And with that, I'll take any questions that you have.
All right, we'll go now to Richie Engelhardt, please, for 2 minutes.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. I am Richie Engelhardt. I'm the Director of Government Affairs for Ancestry. On behalf of our partners with the Coalition for Genetic Data Protection, we're pleased to be here to discuss House Bill 240 with you. We've had very productive conversations with Delegate Shetty's office and Senator Sidner, and we're hopeful we can get to a point where we can fully endorse the bill. From the outset, we agree with the bill's central policy position that consumers should at all times have control of their genetic information, the purposes for which it's used, and with whom that information is shared, including law enforcement. That's why we joined with companies in the industry to develop the privacy best practices for consumer genetic testing services, along with privacy advocates in the Future of Privacy Forum, a nonprofit that focuses on privacy thought leadership. We developed what we believe are the appropriate guidelines to ensure consumers have control over their data, are presented with easy to understand privacy policies, and are empowered to make decisions on how their data should be used. Neither Ancestry nor our coalition partner 23andMe ever share our customers' personal information with law enforcement without being presented with a valid warrant or subpoena, and neither of our companies has ever shared a consumer's genetic information with law enforcement. As HB 240 moves forward, we are seeking narrow amendments that would make it clear that companies that do not participate in law enforcement investigations are not subject to the bill's regulatory provisions. And we're also suggesting that the requirement that the Office of Healthcare Quality certify laboratories be struck, and instead that licensed genetic genealogists in the state be limited to using genetic data from tests performed in CLIA-approved labs. Additionally, we have provided our own model legislation that would go further to regulate direct-to-consumer genetic testing services, codifying into law our best practices and ensuring that consumers provide consent for how their data is used at all times, not just with law enforcement. And we realize that goes a little bit further than this bill's intention in the current session, but we're willing to work with Maryland policymakers to enact further protections in future years. And with that, I'm happy to take any questions from the committee.
All right, one last person to testify, Daniel Katz, for 2 minutes.
Chair Clippinger, Vice Chair Atterbury, members of the committee, good afternoon. My name is Dan Katz. I'm the Director of Maryland State Police Forensic Sciences Division. I was an active participant on the genetic genealogy work group that Delegate Shetty and Senator Sidner organized. And I was impressed with the efforts made to find middle ground on this controversial issue of forensic genetic genealogy. My focus in the work group was, one, to ensure that the bill did not have any unintended consequences on the existing state DNA database law or on the operations of the public forensic laboratories within the state of Maryland. And two, to ensure that the bill appropriately establishes a fair and reasonable system of oversight for this new forensic practice. I feel that the work group was successful in finding the appropriate balance that was not there in the previous versions of this bill in 2019 and 2020. All of the concerns that I had during the drafting of this bill have been addressed with the proposed amendments. Assuming that the amendments are incorporated into the final version of the bill, the Department of State Police offers a position of favorable with amendments on HB 240. Thank you.
All right, thank you very much. Are there questions now for all the panelists? And we'll start with Delegate Anderson.
Yeah, thank you, Mr. Chairman. And I'd like to thank all the panelists for being here today. My question is to Mr. Scheck. I think that you talked about, well, many of the panelists talked about that this bill would give law enforcement agencies the ability to identify bad people who do bad things. And given your background, Mr. Scheck, I was wondering if this type of genetic information has ever been successfully used to exculpate somebody from a particular crime. And if so, how often, or if you could give me a specific example.
Sure. Chris Tapp is one of our clients in Idaho who was exonerated by forensic genetic genealogy. And we have other efforts in the works to do this. And frankly, that is exactly why we were so pleased to be part of this process, because in other instances where we had moved to do genetic genealogy testing in order to try to exculpate somebody who we believe was wrongly convicted, we put the same kind of privacy restrictions into the application for judicial supervision. I think we do that in this bill. For my friend, Mr. Riley, I got your concern last night. I think your concern can be taken care of by having a right to interlocutory appeal if a judge excludes the evidence. I don't believe that you can put into legislation that a judge cannot exclude evidence if it violates the Fourth Amendment. The whole point of this exercise is that we have, through positive law, which was what Judge Gorsuch was asking for, we have taken care of the Fourth Amendment concerns by having judicial supervision. As was pointed out, there is no statutory suppression remedy, but there could be an instance where a judge suddenly says, oh, for reliability reasons, we believe that the DNA testing wasn't done correctly, et cetera. So there can be, nobody is saying you can't exclude that you can appeal the exclusion of the evidence. That's something that can't be done, but the form of the amendment that I saw, I think needs work, Mr.
Mr. Scheck, with regard to the case that you mentioned, where the person was exonerated.
Yes.
Was it initiated by the state's attorney, prosecutor, the person's attorney, or was it just, I mean, how was it found? How was he exculpated?
Well, it was plainly a false confession case, and such an obvious false confession that the victim's mother was asking the state's attorney's office to continue looking at the case. And with an improper use of genetic genealogy, just using Y-DNA, at one point they picked up somebody who was not the real perpetrator. But in fact, it was just, eventually it was at the instigation of innocence organizations and the defense that we were able to get the genetic genealogy done.
Okay, thank you.
Delegate Anderson, if I could help you a little bit. If you look at starting on page 8, that last several pages, 4 pages, are all the way Mr. Scheck could use Maryland law to help clients that he represents. So it talks about post-conviction DNA testing, and it creates a whole system in which a defendant can initiate these things either through a writ of actual innocence, post-conviction, or post-conviction DNA testing. So while we are all emphasizing what we like to emphasize, and that is finding guilty people and being able to convict them, there is an entire section that deals with those who are claiming their innocence and allows them to seek the same relief and the same evidence just the way that the state would use it.
But how would they have the access that prosecutors have now with their access to the databases? I mean, how would
number one, it tells me I have to save it. And in fact, we save on.
So this is the only case where genetic information had been used against the defendant originally.
Not necessarily. It could have been a case where no genetic information was used. And in fact, I mean, that's what happened in the most famous case, Kurt Bloodsworth. When he was convicted, the ability to test DNA didn't exist. And, 10 years later, the ability to test large amounts of DNA did, and it exonerated him. And 10 years after that, the ability to test small amounts of DNA and also having national databases found the person who did do it. And that whole scheme is laid out here that the defendant has the ability to ask the state, who is required to save this DNA, to turn it over to a lab and have this kind of work done. So it's a very balanced approach.
All right, thank you.
Are there further questions for the panel? Seeing none, we do thank you all very much. Thank you for your work on the bill. And that concludes the testimony for House Bill 240. I'm going to go now to House Bill 354 and Delegate Juanita Fisher. She has quite a few witnesses. So if I can just look at this, we'll figure out how we're going to go forward with this one. While we're still virtual, I still have to move the paper around. All right. Delegate Fisher will get 3 minutes. Gabriella Carl, and then Susanti, oh, I'm sorry, no. Gabriella Carl, Brian Saban, Emily Beckman, John Gossart, Kyria Jimenez, or Kyria Jimenez. They will speak in the first panel. So we'll let Delegate Fisher begin. And Juanica Fisher, and she will go for 3 minutes. Everybody else will get 2 minutes. Delegate Fisher.
Thank you, Mr. Chair. Can you hear me okay?
Yes.
Great. Good afternoon, Madam Chair, Mr. Chair, Madam Vice Chair, and the illustrious Judiciary Committee. I'm back again with another great bill. I'm pleased to reintroduce HB 354. Last year it was HB 213. For those of you who may be looking over your notes, it's a probation before judgment, facts justifying of guilt and suspension of sentence. As I've wanted to really lay out to you all the importance of this legislation when it comes to Marylanders that are in our criminal justice system. Currently in our state, when you elect to plead guilty and get a probation before judgment, what that is, it's a striking of the guilty finding. And so the visual for that is, imagine just the word guilty on a piece of paper and the judge is striking a line through it. And that is something that has been in our system for quite some time. And a probation before judgment is what it sounds like. It's there to really strike away the punishment on this case. It's usually there as, you know, a one-time sort of second chance for someone who's a first offender. And it's something that a judge has to be willing to give to an individual. It's not something that you can just attain in a proceeding. And usually probation before judgment is only really given in misdemeanor cases. But for folks that are either do not have US citizenship status and or are looking for opportunities and things in our federal government, the way in which our probation before judgment statute is drafted to the federal government is still seen the same way as if you pled guilty. So you obtaining that PBJ for those purposes does not shield you from the other consequences. As you all know, as a former prosecutor and a current defense attorney here in our state, I have been in courtrooms across the state and seen this used throughout all of our jurisdictions that everyone on this committee represents. And for individuals that are really facing collateral consequences, it really puts the prosecutor, the defense attorney, and that Maryland resident in a hard position. There are times when individuals either they might not feel like they might not be guilty, but due to the evidence against them and other things, choose to plead guilty. It might be something that an individual it might be an early first offense, something very small. And for those that do not have US citizenship status, and I can tell you for my own clients that I represent, this becomes a huge problem because it's not really an option, because it will adversely affect their ability to seek, a full status of citizenship later on, and adverse consequences in our immigration system as well. I would also add to this, it's not, it could be any status, whether you're here, undocumented, maybe you're here as a professor at the University of Maryland on a visa. It adversely affects anyone regardless. So you will hear today, as you have heard previously, last year when I introduced this legislation.
Delegate Fisher, we need you to start to wrap up, please.
Thank you, Mr. Chair. You will hear today from a great panel, people that have worked on this legislation. There are favorable amendments as well to this bill. Happy to work with the committee to make this possible. It is a passion of mine for all Maryland residents to have the full benefit of the PBJ here in our state. So thank you very much, and to my panel. Thank you, Mr. Chair.
Thank you. Gabriella Carl, please, for 2 minutes.
Chair, Vice Chair, committee members, my name is Gabriella Carl. On behalf of the Maryland Carey Law Immigration Clinic, I urge a favorable report on HB 354, which eliminates the unintended immigration consequences of probation before judgment. The PBJ was designed as an alternative to a conviction offered to worthy defendants with the hope that they would abide by all of the conditions of their probation meet all the requirements, be rehabilitated, and not reoffend. But for Maryland residents who are non-citizens, a PBJ plea, because it is a conviction under federal immigration law, can trigger the devastating consequences that Delegate Fisher was telling us about detention and deportation. This bill proposes an equitable solution, add an alternative process to the existing Maryland PBJ statute so that courts can find facts justifying a finding of guilt without requiring an admission of guilt from the defendants. Amendments to this bill have been developed in coalition with states' attorneys, immigration legal experts, criminal law experts to ensure that all aspects of the new PBJ comply with both Maryland constitutional and common law and will also work in the immigration context. This bill fills an important gap in Maryland law. All other dispositions, nolo contendere, not guilty, agreed statement of facts, Alford pleas, are all ruled convictions under federal immigration law. This bill does not confer additional benefits. It's not a lighter touch. The same consequences will apply in the event of a violation of probation. And this does not replace current PBJ law, it merely adds to it. All Marylanders should have the same opportunity to take responsibility for mistakes without suffering lifelong consequences. And that's what this bill ensures. Recent events have made it clear that criminal and immigration systems have been in dire need of reform for a very long time. Immigrants are still under attack from Trump policies, and it will take years to fix. This bill is an opportunity for this assembly to show Marylanders that it is committed to rectifying the inequities that unfairly harm and disadvantage immigrants now, especially Black and Brown immigrants in our state's criminal justice system, which feeds directly into our immigration system. We therefore urge a favorable report on HB 354.
Thank you. We'll go now to Brian Zaven, please. Brian Zaven.
Good afternoon. I'm Brian Zaven. I am the Deputy Chief Attorney of the Office of the Public Defender's Appellate Division. For the reasons stated in my written testimony and that I would like to address today, the Public Defender supports the bill. The General Assembly has long recognized that the mere fact that a person has violated a criminal law should not, in all cases, mean that the person will forever be branded a criminal. One way it has done this is to authorize the imposition of probation before judgment, or PBJ. Prior to 1975, the code allowed for probation without finding a verdict. The problem with the law was that it didn't specify how a court was to proceed in the event of a violation of probation. There was an attempt to fix this by having the court make the finding of guilt up front and defer disposition. But the law was still clear that a PBJ should not be considered a conviction for purposes of collateral consequences. And that should have been the end of the story. The problem was that federal law defines conviction more broadly than state law, such that a person can be subject to deportation and other immigration-related consequences if they get a PBJ. So as a result, the protections that this body has afforded to individuals who get a PBJ do not apply equally to non-citizens. But the bill before you offers a solution, and not just to the interaction between state and federal law, but also to the original issue that plagued the pre-1975 version in Maryland. The bill authorizes probation without a verdict, but now it also authorizes the court to enter a verdict in the event of a violation of probation. And this can occur because the court has already found the evidence the state would offer at trial is sufficient to find guilt, and the defendant has already agreed to let the court proceed in this fashion. We believe that the bill serves a laudable goal and that it does so in a fair and lawful manner. And for these reasons, we recommend a favorable report.
Thank you very much. Emily Beckman, please.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Emily Beckman. I'm testifying in support of HB 354. I'm a resident of Montgomery County and have been a practicing criminal defense lawyer for almost 15 years. During that time, I've been a public defender in Alexandria, Virginia, in Montgomery County, Maryland, and been in private practice. In my time as a defense lawyer, I've represented hundreds, if not thousands, of non-US citizen clients. Non-US citizen clients are often denied the benefits of alternative dispositions like the PBJ, not because of opposition on the part of the prosecution or a victim, but because federal immigration law considers a successfully completed Maryland PBJ to be a conviction, even though Maryland law does not. In Virginia, however, the PBJ equivalent is available to non-citizen clients so that when they successfully complete the program, they do not have a conviction under either state or federal immigration law. This is because non-citizens can participate in these diversion programs after a judge makes a finding of facts sufficient to support a conviction rather than after a finding of guilt. The fact sufficient finding functions in Virginia really just like a current Maryland PBJ does, but without being considered a conviction under federal immigration law. If you pass HB 354, just as defendants do all over Northern Virginia right now, a non-citizen client could plead not guilty, waive objections to proceeding in this manner, and agree not to present alternative facts or evidence or have a full-blown trial. In this way, acquiescing to a finding of facts sufficient and participation in the diversion program. If the defendant successfully completes all of the requirements imposed by the judge, the charge would be dismissed. But if the defendant failed to complete the requirements imposed by the judge, a conviction could be imposed with no further trial or evidence required. Though the change may seem like a meaningless technicality, for legal immigrants charged with minor offenses like theft under $1,000 or simple possession of a controlled substance, it can mean the difference between remaining in this country and being deported. The fact-sufficient alternative provides a necessary avenue for a non-adversarial resolution of cases against non-citizen defendants, so they may receive the same benefits of a PBJ that currently exist for U.S. citizens.
Thank you.
This bill, I'm sorry.
If you please wrap up, that'd be fine.
Yes. Thank you. I asked for your support for the bill and did submit written testimony that has just a few other points.
John Gossart.
Yes, good afternoon, and thank you for the opportunity to testify before the judiciary. My name is John F. Gossart Jr. I'm a retired United States immigration judge. I served in that capacity for 31 years on the bench in Baltimore, Maryland. And I would like to briefly share with you the story of a man named Daryl, whose case I presided over. Daryl was a lawful permanent resident, a green card holder. He was legally present in the United States and had established a full and productive life here. He was happily married to a United States citizen, and they were raising their United States citizen children. Daryl was charged with a minor offense in Maryland, and like many first-time offenders, he was given the opportunity and secured a probation before judgment. But because Daryl was not a United States citizen, I was forced to condemn him to the gravest of punishment, deportation under federal immigration law. It did not matter that Daryl had been deemed worthy of a second chance and not convicted under Maryland law. After I ordered Daryl deported, his wife, Michelle, wrote me a letter. She told me that I had ruined her life and the life of her children. And her letter concluded, "May God forgive you because I cannot." It is with Daryl and with Daryl in mind and the countless others that have faced deportation, notwithstanding a probation before judgment in Maryland, that I urge you to vote favorably for this particular bill. Daryl is one of hundreds of non-citizens who have been ordered deported under current Maryland probation before judgment, many of whom have been permanent residents. This bill will ensure the consequences of PBJ are the same for citizens and non-citizens alike, narrowing the disparity in our criminal justice and immigration systems, which disproportionately affect people of color. Virginia and New York have similar statutes, and allowing this inequity to exist from one jurisdiction to another is simply not just. Which side of the Potomac a case is heard on should not determine whether PBJ triggers federal consequences. With the arrival of a new administration, there is hope for immigration reform, but it is not likely to change the current federal definition of a conviction. It is up to the Maryland General Assembly to take action, and I would urge you to do so. And I thank you for your time and your attention.
Thank you very much. Kyria Jimenez.
Chair, Vice Chair, and committee members, my name is Kyria Jimenez, and I'm a student attorney at Maryland Carey Law Immigration Clinic and urge a favorable report of House Bill 354. I'm here on behalf of clinic client Dorothy Stewart, who asked me to address you today because she was too traumatized to do so herself. Ms. Stewart is a lawful permanent resident from Jamaica who came to the United States at the age of 10. Today, Ms. Stewart is 60 years old, a veteran, mother, and proud Maryland resident who has lived the past 31 years of her life in fear of deportation because of a PBJ. Ms. Stewart enlisted in the U.S. Army at the age of 19 in order to serve the country she thought of as her home. She served approximately 7 years, completing tours in Korea, Germany, honored with multiple medals for exceptional conduct, and served on the Prestige Honor Guard team. Ms. Stewart's military service afforded her opportunity, but also caused her unspeakable pain. While enlisted, Ms. Stewart was sexually abused by other soldiers, so she turned to controlled substance to self-medicate the debilitating symptoms of PTSD and depression triggered by the assaults. She hit bottom when she was arrested and charged with possession with intent to distribute in 1990, over 30 years ago. Ms. Stewart got clean, has no other criminal history, and thought she could finally move on, but her PBJ has held her prisoner of her past. When Ms. Stewart applied for naturalization, she learned that her PBJ, although not a conviction under Maryland state law, was considered a conviction under federal law, and not only prevented the approval of her application, but also made her deportable. Because of her PBJ, she's lived in fear of deportation, has lost job opportunities, and couldn't fulfill her mother's dying wish, which was to have Ms. Stewart return her body to Jamaica. Ms. Stewart made one mistake in her life and is still suffering the consequences today. I provide this testimony on behalf of Ms. Stewart and the hundreds of other Maryland residents that have suffered like she has because of PBJ. We support House Bill 354 because a second chance can make all the difference. Thank you.
Thank you very much. Are there questions for this panel? Delegate Bartlett, I think, was raising her hand, and then I see Delegate Griffith. We'll go Delegate Bartlett, then Delegate Griffith.
Thank you. I was trying to find the button. I'm not quite sure what the amendments were intended to do. Could somebody elaborate on that? Does anybody have that?
I'm going to direct that to Gabrielle, Mr. Chair.
Okay, thank you.
So Delegate Bartlett, last year when this bill was presented, we heard from a few different state's attorneys that they were concerned that the way the bill had been originally written, it wasn't very clear what the process would look like for entering the PBJ. So what the amendment does is very clearly lay out the process, give the court authority to make the finding of facts sufficient to support a finding of guilt, and also explains that in the event of a violation of probation, there would be immediate punishment because it has been preceded by a waiver of rights. So what the amendments do is really just spell out the intended path and make sure that all the authority is there and that it's compliant with Maryland due process and that enforceability isn't going to be an issue.
Great, thank you. Thank you, Mr. Chair. I'm sorry.
David, if he has anything to add, because he is our Maryland criminal law expert.
I don't, that's a very good summary of what the amendments are done to address from last year. There was concern that some of the concerns that plagued the pre-1975 version of the law still existed under the version that was submitted last year. So the amendments were done to correct that, but also to ensure that there was a procedure set forth that was very easy for folks to follow and understand, because this is a new procedure under Maryland law. And also to ensure that this is a probation before judgment, as with other probation before judgments in Maryland, and that it's considered the same. It's just a new type of probation before judgment.
Delegate Griffith.
Thank you, Mr. Chair. And this question's for anybody on the panel. So this would involve DUI, second degree assaults, things of that nature.
I don't know if that's for me, Delegate Griffith, but yeah.
Anybody on the panel.
Okay, well, I'll let a panelist, either Emily or Gabrielle or Brian, come after me. But yes, anything that any U.S. citizen, Maryland resident that would obtain a probation before judgment for, it would be the same. And again, in order to get a probation before judgment, it has to be something that the judge is willing to give you. It has to be granted to you. Depending on what crime it is, there's always different circumstances, and Anecdotally for me, I, always try to get the state's attorney to consent when you're asking for a probation before judgment. That usually helps with the judge granting that probation before judgment. So it is something that has to be given to you by the court. And yes, probation before judgment, as you know, in our law is only available, for example, for DUI on your first time. You have to wait 10 years before you get it a second time. There are certain, I wouldn't go through the committee with every crime, but usually low level misdemeanors. And I'll let anyone else add to that.
Nobody?
Hearing no one.
I think it doesn't change the offenses which are eligible for PBJ. It just provides a different procedure for doing PBJ for the charges that already are approved. And there are some that are not approved. There are already statutes saying a PBJ is not available in certain circumstances. Those would apply to this procedure just as much as they apply to the current PBJ. It would be the same.
So one follow-up question then, do you think it's possible or conceivable that a judge may be more willing to give a non-citizen PBJ than a citizen and able to protect them under this law?
I mean, personally, based on my experience, I certainly doubt it, but I don't know if other people have other experiences. I mean, a US citizen could also take advantage of this procedure if, for example, some people have a problem with, with respect to certain of the facts or aren't, some people have opinions about, they want to do what the state is offering them as a resolution, but they don't want to say, I plead guilty. So they might use this procedure too, potentially.
Delegate Griffin, if I may, there are.
Go ahead, I'm sorry.
I don't want to interrupt if you had a follow-up question.
No, go ahead.
I just wanted to add that there are, as Ms. Beckman points out, it's true that US citizens could benefit from this method of PBJ as well, because it doesn't require the defendant to admit guilt, to say the words not guilty, and that can often prevent them from getting certain professional licenses. I believe becoming truckers, people who would otherwise have a career as truckers would be prevented from doing that under certain circumstances with the Maryland PBJ. So there are ways in which this would benefit US citizens as well. But I don't think, in answer to your original question, that a judge would be more likely to give somebody a PBJ than not in this circumstance. I think a PBJ is something that only really first-time offenders get, regardless of what their citizenship status is. This is just about ensuring that they get the same punishment as citizens currently get, which is just probation without deportation.
You make a really good point. I mean, that's actually something that's concerning then. If a trucker could shield the fact they got a DUI while applying to be a truck driver, I think that's a serious concern.
I don't think they could shield that they got a DUI. They still would have gotten a DUI.
Sure, but if you're saying the type of protections that would protect a truck driver from I think that's a potential concern. I appreciate you pointing that out. Thank you.
Would the DUI appear on their driving record?
It would still appear. Thank you, Chair.
Okay. Are there further questions for this panel? Several of you indicated that there was some other concern that was expressed about this bill last year, and a lot of it was in a Attorney General's opinion that said that it violated due process. Has the Attorney General weighed in on this bill as amended?
Chair, we actually worked with a member of the Attorney General's office, Carrie Williams, on the bill, and she reviewed it. And we are going to get an official review from the Attorney General's office. We haven't gotten it yet, but they are aware of the changes that we've made and have looked at it, and it looked good to them, at least in those discussions, although I'm not going to tell you what their position is.
All right. Further questions? Seeing none, thank you very much. Susanti Fallingstad, Kate Sugarman, Laura Atwood, Emily Johansson, Andy Jezik, and we will stop there. And then I'll go to the final 5 people. I think it's just 5 more after that. So if we could have Susanti Fallingstad, please. Ms. Fallingstad?
Thought I'd unmuted myself, sorry.
All
Thank
right,
you, Chair
2
Clippinger. Okay.
2 minutes, go ahead.
And members of the House Judiciary Committee. My name's Susanti Fallingstead. I live in Rockville and I testify on behalf of Maryland Against ICE Detention in support of House Bill 354. We are a statewide coalition of over 60 organizations and 200,000 individuals striving to stop immigration detention as well as systems that contribute to detention and deportation. I've used PBJ, probation before judgment, in traffic court to avoid points and increased insurance rates while only paying a fine and completing the probation period successfully. I was appalled to learn that under federal law, a non-citizen could face dire consequences, including deportation, even for a similar offense to mine. Furthermore, non-citizens are often led to believe, sometimes by attorneys ignorant of how the federal law views a PBJ, that it will not have major consequences if they successfully complete the probation period. This has led to many being deported and separated from families for minor infractions. Because of this inequity, attorneys who do understand the potential consequences advise clients to take the risk of a full trial rather than rely on a PBJ. In addition to the added risks and costs for these non-citizens, this burdens the Maryland courts and prosecutors with unnecessary trials for offenses that could otherwise be assigned to PBJ. House Bill 354 will make minor changes to the law that will ensure the PBJ will no longer be considered a conviction under federal law and thus reduce the harm that ICE and the immigration system is able to inflict upon our non-citizen neighbors, while also reducing the costs and burdens on the criminal justice system. Maryland Against ICE Detention urges a favorable report on House Bill 354. Thank you.
All right, committee, I'm going to take a step back just for a moment. So I'm going to hand this over to the vice chair just briefly. The next person is Kate Sugarman, then Laura Atwood, then Emily Johansson. Sugarman, Atwood, Johansson. So Kate Sugarman for 2 minutes, please.
Okay, thank you, Chair Clippinger. I was born and raised in Baltimore City. I'm now a practicing public health physician. I live in Potomac, Maryland. I'm the co-chair of the Maryland chapter of Doctors for Camp Closure. We're part of a national group of over 2,000 physicians and healthcare professionals nationwide. And we strongly support House Bill 354. We urge the committee to report favorably on this legislation. We believe in humane treatment and we oppose inhumane detention of all immigrants. Currently, if a judge believes that a charge warrants it and the prosecution and defense agree, the judge can impose probation before judgment, PBJ, and if the defendant completes the term imposed without problems, there's no conviction in their record. Unfortunately, under federal law, this is still considered a conviction, and thus for non-citizens, including green card holders, it can result in issues ranging from citizenship denial to detention by ICE and even deportation, all related to what the justice system saw as a minor offense. As physicians, we know as eyewitnesses, there is no healthy amount of time for an immigrant to be detained. We have been inside of immigration detention centers as physicians, and we know how hazardous these places are both to the immigrants and to their families. This issue has taken on a heightened sense of urgency as we face a worsening pandemic. Serious illnesses and deaths due to COVID continue to rise inside the prisons, not only for the detained immigrant, but also for the staff at these facilities. In addition, family members suffer when their mothers and fathers, husbands and wives are deported. Families lose their wage earners and children lose their mothers and fathers. These children can no longer concentrate in school and suffer a host of psychological consequences. The emotional scarring is permanent and severe. The Maryland chapter of Doctors for Camp Closure urges a favorable report on House Bill 354. Thank you.
Thank you. Next, Laura Atwood for 2 minutes.
Yes, thank you. My name is Laura Atwood, and I'm testifying on behalf of Tacoma Park Mobilization in support of HB 354. We're a grassroots organization with 2,300 members in and around Tacoma Park, and we advocate for laws and policies to ensure equal treatment and justice for everyone at the city, county, state, and national levels. This bill would correct a problem with Maryland's law governing probation before judgment, PBJ. Virginia and New York have similar statutes, as others have explained. So essentially, under Maryland law, someone who's a first-time offender or has committed a low-level offense can waive the right to a trial and potentially get PBJ without a conviction going on record. So if a family member has a traffic violation or a college student gets an alcohol violation and nothing like that has happened before, the judge and lawyers may agree on probation before judgment, so the person goes to traffic class counseling, does community service, whatever the conditions are, demonstrates good behavior throughout probation, and then no conviction goes on the record. That would make their car insurance skyrocket or interfere with non-federal job applications, college, grad school applications. It lets people move on from a single mistake and live out their lives. This is a sensible, productive approach Maryland has taken. Now, if that same person is a non-citizen, can be a green card holder, visa holder in the asylum process, adjusting status in that process, undocumented, but Maryland's been home since childhood. Any of these cases, the immigration system does count that as a conviction, so the person suffers disproportionate consequences. This truly happens. We heard of individuals whose lives were destroyed, their families hurt. Daryl, Ms. Stewart. We could fill multiple testimonies with more names and stories. And this, we should not be a part of this in the state of Maryland. This bill would close a legal gap that interferes with uniform justice and has dire consequences for these human beings in our state. Tacoma Park Mobilization therefore urges a favorable report on HB 354. Thank you so much for your time.
Thank you. Emily Johansson.
Chair, Vice Chair, and committee members. My name is Emily Johansson, and I'm an attorney with the Capital Area Immigrants' Rights Coalition. Our organization focuses exclusively on representing immigrants in detention centers. I'm here today to discuss data that shows the harmful impact the existing PBJ system has on immigrants, particularly immigrants of color, and to urge a favorable report on HB 354. 99% of Care Coalition clients with a Maryland PBJ were Black or Brown. Of those, at least 53% were detained by ICE after having contact with the criminal justice system. These numbers exemplify the ways that our criminal system and its racial discrimination have long served as a direct funnel to the immigration legal system. Black and Brown immigrants are more likely to have encounters with law enforcement and to be charged and prosecuted for crimes which lead to deportation. While in detention, Black immigrants are 6 times more likely to be sent to solitary confinement. Overall, Black and Brown immigrants are more likely to be detained and deported. But amending the Maryland PBJ statute as proposed today will help to reduce the detention and deportation of immigrants who are disproportionately harmed by the criminal legal system. This legislation is more important than ever in the context of our global pandemic and the high prevalence of COVID-19 in immigrant detention centers. There have been several major outbreaks in our local detention centers, and in the biggest facility in which we work, last summer, almost 90% of the population tested positive for COVID-19. HB 354 promotes racial equity, fairness, and safety for all Maryland residents. For these reasons, we respectfully request a favorable report. Thank you.
Thank you. Austin Rose.
Hello, members of the committee. My name is Austin Rose. As a Maryland resident, longtime organizer with Sanctuary DMV, and a third-year law student has done considerable work at the intersection of immigration and criminal law. I wholeheartedly express my support on behalf of Sanctuary DMV for HB 354. This legislation would eliminate disparities in the treatment of citizens and non-citizens in Maryland and keep families together. So Sanctuary DMV is an all-volunteer group dedicated to working in solidarity with immigrant communities in DC, Maryland, and Virginia. Through this work, we have supported several individuals who are arrested by ICE and entered immigration proceedings through the criminal justice system in Maryland and elsewhere, resulting in their families being torn apart. Very frequently, this happens as a result of offenses for which these individuals would have otherwise served no jail time and would have had only minimal consequences for similarly situated US citizens. So we at Sanctuary DMV believe firmly that no person should be detained or deported for civil immigration violations, regardless of their involvement in the criminal justice system. Rather, non-citizens who commit criminal offenses should be treated the same as US citizens. It's very simple. And this holds especially true, I think, for something like probation before judgment. If a Maryland judge determines that an offense committed by a non-citizen is not serious enough to warrant a formal criminal conviction carrying potential jail time, then the non-citizen should be on probation just like a US citizen would be and released into the community. What happens instead is that non-citizens, as we know, who receive PBJ in Maryland, this is both undocumented people and green card holders, are still considered to have a conviction for federal immigration purposes and could therefore be taken into immigration detention and eventually deported. This, in our mind, is an arbitrary form of double punishment that frankly ignores the reasoned judgment of the Maryland judiciary and has no place in our legal system. So this legislation would make a small change to Maryland criminal law in order to eliminate this disparate treatment of citizens and non-citizens that I just described. And it would also send a clear signal that even if a person living in Maryland may not be a US citizen, they are still a Maryland citizen and deserve to be treated equally. So Sanctuary DMV urges a favorable report on this legislation. Thank you.
Thank you. And I see the chair is back. Next is Andrew Jezik, and that will be it for this panel.
Good afternoon. My name is Andrew Jezik. I'm the former president of the Maryland Criminal Defense Attorneys Association. I'm a criminal defense attorney and I was a prosecutor for 7 years. The main point I'd like to make is that this bill saves time and money in the pretrial, trial, and post-trial process. In other words, it promotes judicial economy. We have a very large amount of immigrants in our large criminal practice. We have 8 full-time criminal defense attorneys. 70% of our clients are immigrants. And I can just tell you the amount of time that prosecutors and defense attorneys take negotiating what we call a potential immigration-friendly plea is a tremendous amount of time. And sometimes it involves pretrial meetings with family and victims and police. And sometimes it just doesn't work out. And hours and hours and hours are taken up by that. Number 2, this bill will save many hours in court to prevent trials that are unnecessary. A lot of times criminal defense attorneys need to go to trial hoping for a miracle result because we know that the plea that was offered has horrible immigration consequences. So it's our duty just to throw up a Hail Mary pass and hope that we win in a trial. Whereas if we had this sort of law available to us, we wouldn't go to trial. Third, it saves tremendous amount of time post-trial. Post-conviction attorneys and quorum nobis attorneys will have a lot less to do in terms of trying to overturn convictions from years ago. And that'll save the court a lot of time. And lastly, saves a ton of time in immigration court. We have a very large immigration practice here, and the amount of time and money spent by immigrants trying to undo a very unfavorable plea that was done years ago in immigration court costs tens of thousands of dollars for the immigrant and takes up massive time for the immigration court. So in short, this bill will promote judicial economy. It'll save time for the courts and money for the clients and will benefit overall our justice system by making things much less time consuming. Thank you.
Thank you very much. Other questions for this panel? Seeing none, we'll move to the next panel. Thank you all very much. Dana Boston, Joseph Moravec, Laura Rhodes, Vania Reyna, and Aisha Braveboy, each for 2 minutes. Dana Boston, please. Dana Boston. Dana Boston.
Oh, yes, I'm sorry. Can you hear me?
Yes, we need to see you, please, as well for 2 minutes.
Sorry about that, Chairman.
Chairman, Vice Chair, I'm here, Dana Boston, testify in support of House Bill 354. I'm a public defender in Denton, Caroline County, Maryland. I've been there for the last 10 years. I represent a wide variety of clients. A lot of the clients that I represent are immigrants, both lawful permanent residents and otherwise. A lot of them are Hispanics, as well as Africans, as well as Asians, and from European countries. I can tell you, members of the committee, that the consequences to an immigrant client for a probation before judgment can be so out of the realm of what is contemplated by both the state's attorney, the defense attorney, and the judge at the time of the sentencing. It'll literally blow your mind. For these nonviolent first-time offenders, a lot of times they face consequences such as deportation, detention, ineligibility for citizenship. For minor crimes, where those who are most intimate with the facts of the case, the victims, all the parties involved, have determined and reached an agreement that that there should be no criminal conviction and that the consequences for this crime should be minimal. I think in my practice, I've reviewed the bill and the procedure by which the probation before judgment would be procured under this proposed legislation. I can tell you, I don't think that it would add any sort of onerous burden to the way that the plea is conducted in court. It's not going to take any additional resources or any additional time. I think it's a simple procedure, and it doesn't change the consequences to the Maryland resident. It just protects the Maryland resident and their families from federal agents coming in after the fact and saying, we don't care about what you've decided should be the consequences under Maryland law. We're going to go ahead and thwart the judge. We're going to go ahead and thwart the state's attorney. We're going to take you into custody and tear your family apart. It's simply just not a fair outcome. And this proposed legislation is very minimally intrusive in that it remedies
Mr. Boston?
Outcome.
All right. Thank you very much.
Your support. Thank you.
Joseph Morovec.
Good afternoon, and thank you to the Chair Clippinger and members of the Judiciary Committee for the opportunity to speak. I wholeheartedly support HB 354. I'm an immigration attorney with Fern in Columbia. Before moving to Maryland, though, I practiced immigration law in New York and focused on representing those in state and federal custody with immigration proceedings. So I have similar experience with New York's criminal procedure law, and I hope to offer that dual perspective. New York's ACD provision functions slightly differently than Maryland's probation before judgment, but the effect we hope is adopted through HB 354 is the same. In most cases, the legislature can conclude that a given offense should carry minimal punishment, but Marylanders who agree to a PBJ are still considered convicted under federal law. The New York ACD provision avoids the situation by deferring and then dismissing a case after 6 months if certain conditions are met. And those conditions are worked out in agreement with the district attorney and approved by the judge, as would be the case here. By similarly allowing Maryland prosecutors the discretion to agree to probation before judgment, where justice would not be served through a conviction, HB 354 provides an avenue to more appropriately balance the consequences of an offense with the punishment the legislature intended. I would like to offer an example of a client of mine. He's a non-citizen and he was in immigration court after a conviction for driving without a license. He was actually hit by somebody who ran a red light on his way to work. And although he was the victim in the accident, he was still charged and convicted later of driving without a license. He spent more than 6 months in immigration detention, and his biggest barrier to release was his prior conviction. My client's case is fairly representative of the power of federal immigration officials to routinely bring, even in most minor cases, extraordinary indifference to leave and hold people in detention In cases like my clients, an agreement reached for probation without a conviction could save many Marylanders from months or years separated from families, either in detention or worse, through permanent separation. HB 354.
Mr. Moravec, please.
Yep.
Finish.
It's a simple question of equity, Mr. Chair, and I hope the legislature takes the opportunity to correct it. Thank you.
Laura Rhodes, please, for 2 minutes.
Very well. Thank you, Chair Clippinger and others for listening to this today. I'm in favor of HB 354 for a number of reasons. I'm a former president of the Maryland Criminal Defense Attorneys Association, longtime criminal defense attorney starting at the Public Defender Office. And I grew up in Sudan for 5 years as a child and later in Brazil and some in Paraguay. I can relate to my clients and I feel for them, and I work hard to try to reduce the stress and the trauma in their lives. Trauma is sadly the one trait that most of our immigrant clients share. Trauma is what happens when families are split up, or families, whether they're leaving somewhere or moving because of food, shelter, or safety in many cases. Trauma, unfortunately, is what happens in our court system, even if unintentional, when unfairness or unjust or different outcomes happen to similarly situated people. I've had many, many prosecutors say to me, well, why should I cut your guy some slack and give him the second degree instead of a first degree assault or whatever it is I'm asking for, when I wouldn't do that for the US citizen? Well, I think to myself, and sometimes I say it, your US citizen client or this other defendant is not going to be banished from this country forever. And my client will be. So it's not different from a doctor who comes in with maybe a marijuana charge in the old days, who is worried about his license or her license. Okay, there are some accommodations that may occur in a prosecution. That's what the attorney's job is. But it doesn't work if the systems aren't equal. And that's what this bill is really about, is that let the immigrants have something that will not punish them for far longer than what would happen to a US citizen. I think about a kid I represented who was probably 18. His father was Serbian. His mother was from the Dominican Republic, but also Serbian. And he had grown up there, came to the US at 11 and went through—
Ms. Rhodes, I need to stop right here for a moment. And for that matter, and with not being rude.
Can I finish my sentence?
You can finish your sentence, but we're going to have to take a break here for a moment. So please,
Sure.
Rhodes.
It took the prosecutor and the court system, a very kind prosecutor, a lot of extra time to fashion a sentence that we were back in 3 years for, and different things happened just to accommodate that so he wouldn't be banished. He's now a US citizen.
Thank you very much.
Thank you.
We are going to stop for a moment. We are pausing the hearing. We will come back in, let's say at 3:50. We will come back at 3:50 and we'll continue with the testimony on this bill with Ms. Reyna. Thank you very much. We'll take a 15-minute break. Thank you.
It's done.
Kurt, you need to mute.
Okay, we are going to go ahead and get started. If everybody could come back on the screen. And if everybody, Kurt, could you please mute yourself? Delegate Anderson. Okay, next up, Vanya Reyna.
Hi, good afternoon.
Go ahead.
Thank you for having me today, Mr. Chair, Madam Vice Chair, and committee members. My name is Vanya Reyna. I'm a staff attorney at Casa de Maryland, where I provide legal services and consultations to our members who are predominantly Black and Latinx immigrants across Maryland. I'm here today in strong support of HB 354. It would make a great impact on the lives of our CASA members. One of our examples is CASA member Ryan. He pleaded to disorderly conduct where a judge gave him PBJ. Under the current structure of PBJ, he now has a guilty conviction on his record, which makes renewing his DACA application or his DACA status concerning. This charge does not make him ineligible for DACA. However, USCIS has ample discretion and a conviction can be detrimental to him and his status. Another example is CASA member Maricruz, who was given a PBJ sentence for driving without a license, which again is a conviction under federal immigration law. This is required to be disclosed on her DACA renewals, and it can also be extremely detrimental to her. Both of these members are hardworking Maryland residents, but unfortunately, laws in their state negatively impact them more than they do residents who are US citizens. DACA recipients are not the only ones negatively impacted by the current PBJ structure. Lawful permanent residents, immigrants with green cards can face severe consequences by having a PBJ on their record. They could face never being able to leave the United States because they could be found inadmissible upon re-entering, or even face the possibility of being placed in deportation proceedings. These are severe consequences that can be corrected by HB 354, which only adds a method for the judge to allow non-citizen residents to benefit from the purpose of PBJ. Thank you, Delegate Wanika Fisher, for sponsoring this bill, and we strongly urge a favorable report. Thank you for your time today.
Thank you. State's Attorney Braveboy.
Thank you so much, Madam Chair and members of the committee. For the record, my name is Aisha Braveboy, and I'm the state's attorney for Prince George's County. And I'm here to testify in support of House Bill 354 with the amendments that were mentioned earlier by the wonderful sponsor, Delegate Fisher, in her prior and in prior testimony from some of the other supporters of this important bill. We are aware of some of the legal concerns. We know that the Office of the Attorney General will be weighing in very shortly, and we are committed to continuing to work with the sponsor and all stakeholders, including this committee, so that we can get the right product out, hopefully this year, because this is such an important issue. Many years ago, the Maryland General Assembly recognized that the interest of a person or the just result of a criminal case may not be a criminal conviction. And this body codified the probation before judgment statute. For many residents, that statute has worked perfectly because it ensures that there is a just result. Many criminal defendants, while on a PBJ, they're able to get the necessary treatment that is required so that they don't reoffend. And they can do so in a way that does not adversely affect their ability to seek employment or to live freely. However, that result that we all want is not available for individuals who don't have a legal status in this country, because oftentimes the PBJ and the guilty finding that is required means that they are guilty and for federal purposes as well. And it subjects them often to deportation. This is not the harsh type of result that we want in cases where we're asking or the court to consider a PBJ. So we think that this bill is very important, and that we, again, will continue to work with all of the stakeholders. And we really support the sponsors' intent behind this bill because it gives those who've been living here and working here and have families here the opportunity, even if they make a mistake, because we all do. And even as state's attorney, I recognize that people make mistakes all the time, and we don't want it to impact the rest of their lives. We don't want separations from families or really separating people from a place that they know is their home. So we hope that you will support this bill. And again, we look forward to getting the comments from the Office of the Attorney General, working through any outstanding issues, and hopefully supporting the passage of this bill this year. Thank you very much.
And I'm back. Are there questions for this panel? Seeing no questions for the panel, we thank you all very much for your testimony today. And that concludes the testimony for those people speaking in favor of House Bill 354. We'll go to the opponents, Steve Kroll and Joe Riley. So we'll go to Steve Kroll and get him into the room right away. All right, Mr. Kroll, you have 2 minutes.
Mr. Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. And at this point, I'm opposing House Bill 354. This is the same bill that the Attorney General weighed in and had strong opinions about the due process clause. And really, the questions arise beginning in late March of last year. But the sponsor put the same bill back in despite those misgivings and those problems with it. Now we have amendments, and I'm pleased to say we're working with the sponsor and with the advocates to try to get a good bill, but we must wait until the Attorney General's opinion section weighs in to see if it's constitutional. We have to have a bill that's a good bill. We don't want an unconstitutional bill, and until there's an opinion section opinion, we can't agree to this bill, and therefore, based on that reason, we are opposed to House Bill 354, but are willing to work with the sponsor and work with the advocates to get a good bill proposed. Thank you very much.
Thank you, Joe Riley. 2 minutes, please.
Thank you, Chairman Clevenger, Madam Vice Chair, members of the committee. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland State's Attorneys Association. We are seeking an unfavorable report for this bill at this time. While we do think that it is a very admirable position that Delegate Fisher has taken, and we think she's worked very hard with the parties on crafting this bill that would seek the goals that this bill has that we share as the State's Attorneys Association. We want every person that's here legally that wants to stay here be able to stay here. We want there to be those who want to become citizens as soon as they are legally able to do so. We share the hope that with the new administration, perhaps there can be some clarification as to what a PBJ will do to immigration status. But as of right now, with the opinion from the Attorney General from last year and the statements from the Judiciary in January of this year, we simply can't support this bill until we know exactly what it's going to do.
Are there questions for this panel? All right, Delegate Cardin.
Thank you, Mr. Chair. And very just quickly to Mr. Riley, thank you again for your testimony. You guys always do a great job. Am I to understand, though, that you believe that somebody who has a probation before judgment should be able to be deported based on the fact that they have a conviction or not? From a policy perspective, not from a practical perspective, from a policy perspective. Is that what you believe?
I understand that the federal government has weighed in, and the federal government's in charge of immigration, and they have decided that a PBJ in Maryland could mean that that person has to wait a longer time to become a citizen. That person could be deported. It's not Joe Riley's decision.
Right, but I understand, but if
And they're not asking it.
I understand, but I'm asking you as a prosecutor, for the purpose of PBJs and what they're trying to do, does it concern you that our PBJ system is not working do you think it's working the way it should be, or do you not care that we have a discrepancy in the intent of the law here in Maryland?
On the federal level, Mr. Boston, who is my colleague, who I work with in Caroline County, we've had long discussions on this bill. And the second that the judiciary says it will work and the AG says it will work, we will be here in a different position.
Thank you. Thank you.
Make it any clearer than that about what my personal feelings are on the bill.
Are there further questions for the panel? Seeing none, we thank you both very much. And that concludes the testimony on House Bill 354. We're going to go to House Bill 754 now. And again, off his early victory last week, is now coming back Delegate Pippy to try and get another bill, 754. It is Delegate Pippy and Scott Schellenberger, I think, to begin. That's correct. And then we'll have those people in opposition. So Delegate Pippy for 3 minutes, please.
All right, Mr. Chairman, Madam Vice Chair, my favorite friends from the Judiciary Committee, Delegate Pippy for the record, testifying on House Bill 754. This bill deals with expungement and sexual offenses. Long and short, when you have a 4th-degree sex offense and a judge to that sex offense orders the defendant on the sex registry, there is a situation that occurs, which is if it was a probation before judgment, the defendant can actually have that probation before judgment charge expunged off their record in 3 years. The problem is that the sex offense registry requires you to be on there for 15 years. And so what this bill says is the following. If a judge for a 4th-degree sex offense requires the defendant to register on the sex registry, they cannot expunge that 4th-degree sex offense while still on the sex registry. It only applies to 4th-degree sex offenses if a judge requires a defendant to register on the sex offense registry. And I am happy to answer any questions. I'm hoping the committee for a favorable vote. Thank you.
Mr. Schellenberger, please, for 2 minutes.
Great, Mr. Chairman, Madam Vice Chair, members of the committee, thank you so much. What Delegate Pippy has done is fix a very, very small hole in our law, namely Criminal Procedure 10-105, that addresses expungement. And we're not touching null process, we're not touching not guilties, we're not touching dismissals, we're touching 2 very tiny parts. If you get a PBJ on a 4th-degree sex offense, which is the only sex offense the law allows a PBJ to be given to, the judge in that probation has discretion to give you a PBJ, but require you to register as a sex offender. And if you got a 4th degree, your registration should last for 15 years. That's how long it lasts. But if you can get that PBJ expunged, then once you get it expunged, you merely go to the sex offense registry and say, take my name off, I don't have a conviction, and they're gonna have to do it. And this actually happened in a case where a person got a PBJ in Maryland, was on the registry in West Virginia, and had their name taken off. The second part, I hope Delegate Clippinger, you remember the letter from Judge Morrissey dated January 14th, pointing out the second problem. And that is when court costs are supposed to be paid, or more importantly for me, restitution is supposed to be paid, and it's not paid when you got a PBJ and you haven't been brought back in for some type of violation, or you weren't even given a term of probation, but it was a condition to pay it. If you get that expunged, then that wipes out that restitution, and that victim loses the ability to get their restitution. So House Bill 754 fixes 2 very small problems, but I think 2 very important problems. concerning restitution and registration of sex offenders.
All right, are there questions for the panel? There are two so far. Delegate Cardin?
Thank you very much, Mr. Chair. But just very briefly, thank you, Ms. Schellenberger, for being in. No, first of all, so a fourth degree sex offense, can you just list off what that generally is?
Typically, it would be the non-consensual touching of an intimate body part. It could also be it could be sex with a person under a certain age and you're 4 or more years older. I think we had this conversation a couple of weeks ago. So say an individual is 19 and the girl is 14 and there's no force alleged, because of the age difference, it would be a fourth degree sex offense.
Okay, so is it possible that a judge is saying, yeah, I think you should be on the sex offender registry, but his intent was to have everything be able to be gone after the probation was over?
Well, the judge would have that discretion. So if a judge, it's the only place you get discretion because it's the only place where you can get a PBJ. So you can only get a PBJ for a fourth degree sex offense, and a judge has the discretion to either put you on the registry or not. So if a judge has given you probation before judgment, but thinks you should register, they're trying to spare your record for the future, but once you register.
I understand, but what I'm saying is that wouldn't it probably be the case that the judge thinks if you should be on the registry, that it should be for the term of the probation, not for the term of that the registry is supposed to be? That's the reason why he asked you to be on the registry. He doesn't have to put you in the registry, but he's going to for at least the term of the 3 years, because he believes that's the appropriate amount of time. And if he thought you should be on for longer, then he shouldn't give you the option of the PBJ.
I certainly understand your point, but my point would be the judge knows the law and that the registry requires it to be 15 years. So he must have asked you to be on it, or he could have said, you don't have to register.
Okay, Delegate Moon.
Thank you, Mr. Chair. I'm just curious more about the other part of the bill dealing with fines and fees. So to be clear, you're trying to hold up expungement for people who have outstanding fines, fees, and restitution, not for people who are necessarily sex offenders. This is for everybody, anyone that might have a fine or a fee that is outstanding and seeks an expungement. Is that correct?
Not really, because if it's a null pros, a not guilty or dismissal, you're not going to owe any fees or court costs. So you would only owe court costs and fee and restitution if you got the PBJ. So again, we're talking about the PBJ where, say, a judge has ordered you to pay court costs but doesn't think you should be on probation for more than a year. Well, if you don't pay those costs and you're not on probation, they can't bring you back for a VOP if the clerk's office has turned that amount of money you owe, either for restitution or a fine, into a judgment. If you get that conviction wiped out, then you probably will get the judgment wiped out because it doesn't exist. So it's
what are most of these cases going to be?
I would say restitution.
No. I mean, what's the nature of the crime?
Oh, it could be a simple theft or a B&E of say a shed where a homeowner lost some items or a door got broken. I mean, we're talking usually about lower level crimes where restitution has been ordered. But any kind of theft from a citizen, judges are always trying to make them whole. So we're talking about restitution.
And to your knowledge, what percentage of those kinds of cases are currently satisfied? The restitution is satisfied.
Honestly, I don't know the answer to that, Delegate. You've caught me again, but I can try to find that out. I do know that when talking about the fines and costs, I can inquire about Judge Morrissey about how that goes. The other part about restitution, I'm going to have to go to all probably, 24 jurisdictions to find out how bad that problem is. But I can take a look and see what I can find out. Maybe the Department of Parole and Probation has some kind of stat.
All right, are there further questions for this panel? Seeing none, we thank you very much, committee. That will conclude the hearing on that bill, House Bill 754. We're going to go now to House Bill 851. And I'm going to hand this over to Delegate Crutchfield, who's going to be chairing the meeting while the vice chair and I attend to another matter. There are, it looks like, 1, 2, 3, 4, 5, 6 people who are signed up favorable or favorable with amendments. So Delegate Ruth can begin, and then I'll leave it to Delegate Crutchfield to go the rest of the way through House Bill 851. So we'll do that. Delegate Ruth, for 3 minutes, please.
Thank you, Mr. Chair.
Oh, wait a minute. I'm sorry. I've just got a note. Are there further unfavorables on 754? Yes, there are. I apologize. I made a very big mistake, and I'm not going to, I have very, very, very much apologize for that. I am still going to kick it over to Delegate Crutchfield, and that's really important now because I appear to be screwing up. We have to hear the unfavorables for House Bill 754. Yeah, got a little distracted there. Christopher Sweeney, Karen York, Nicole Hansen-Mundell, Abigail Thibodeau, and Mary Denise Davis. We'll hear from them. Then we'll hear from Delegate Ruth. I apologize, Delegate Ruth. I got out in front of my skis. I see Christopher Sweeney there. And whoever I see first, we'll get them started for 2 minutes, and then I will, for the committee, thankfully hand it over to Delegate Crutchfield. All right, Mr. Sweeney, for 2 minutes, please.
Chair Clippinger, distinguished members of the committee, thank you for the opportunity to testify today. I'm Chris Sweeney. I work at Maryland Volunteer Lawyer Service as a staff attorney, and I manage the Workforce Development Project. In a typical year, I will assist around 300 Marylanders with expunging their criminal records. And because of my experience working with people in need of record expungement who are seeking jobs, I have to respectfully oppose this piece of legislation, and most specifically, my opposition is related to the provision regarding fines and fees. And I'd just like to share 2 major reasons why. One is that those who cannot afford to pay court fines and fees are the ones who are in the most need of expungement. So the prohibition on fines and fees will create a catch-22 situation where someone who cannot expunge their case without paying the fees, but doesn't have a job, they need a job to pay back the fees. They can't get a job without expunging their case. And this is, I believe, not going to be limited just to restitution, but even the smallest of court fees can prevent a person in poverty from moving forward. And my second reason is, in the past several years, this legislature has made some great strides to actually increase the eligibility of expungement for citizens of Maryland. First with expungement of non-conviction several years ago, and then the Justice Reinvestment Act expanded that to even certain convictions. So these laws increased the access to expungement and allowed thousands of people to have better access to employment. So after several years of a commitment to improving access to expungement, I think now is not the time to actually take a step backwards and make it more difficult to expunge cases. My office uses expungement software to generate court filings. This software has generated over 115,000 expungement filings since 2015. I believe every one of those filings represents an opportunity for a person to move forward and improve their life. And I think that we need more opportunities for expungement in Maryland, not less. And for these reasons, I respectfully oppose this bill and request an unfavorable report. I do truly appreciate the opportunity to testify today.
Thank you, Mr. Sweeney. Next, we'll hear from Ms. York. for 2 minutes.
Thank you, Madam Chair and members of the committee. For the record, I'm Karen York, the CEO of the Job Opportunities Task Force, and I'm here in strong opposition to House Bill 754, as it would prohibit expungement eligibility for those persons with unpaid court fines, fees, and restitution, further penalizing individuals that have interacted with the criminal justice system. In 2018, JOTF released a report on the many ways that Maryland laws serve to criminalize and penalize individuals who are poor and overwhelmingly Black. The criminalization of poverty, and by extension, race, is defined as punitive responses that criminalize and penalize individuals who cannot meet the financial demands of the law. This includes, yes, fines and fees and restitution that are levied against the persons who are least likely to be able to pay them, whether in pretrial incarceration and even in post-conviction. Additionally, the criminal record serves as a significant barrier to employment opportunities for many low-income workers, particularly Black and brown workers. Annapolis has labored over this for years. As such, JOTF and partners have practically stalked our legislative bodies to urge support for laws that restrict public access to the record. And we're still pushing for this, as evidenced by today's agenda and recent gubernatorial veto overrides. States across the country are moving expeditiously to eliminate laws that prevent individuals from voting, securing expungement, and more due to unpaid court fines, fees, and restitution. Why? The majority of these defendants are indigent. And as was stated before, criminal records block access to employment. And with that, the wages needed to actually pay the fines, fees, and restitution. House Bill 754 seeks to block expungement access for the individuals who owe these court-imposed fines, fees, or restitutions related to the charge. This bill does not take into account the defendant's ability to pay the imposed fines, fees, and restitutions, offers no payment plan, and assumes that preventing the expungement will incentivize payments. JOTF strongly opposes efforts to increase barriers to economic opportunity for Marylanders already saddled with arrest charges and convictions, fines, fees, and restitutions that quite honestly ruin employment opportunities. We urge an unfavorable report.
Thank you very much, Ms. York. Next, we will go to Abigail Thibault. Ms. Thibault?
Yes, I'm just trying to start my video. I apologize.
Great.
Hi. Oh, there we go. Perfect. Hi, my name is Abigail Thibault. I'm an assistant public defender in Maryland. I work primarily in Charles County and also sometimes in St. Mary's County, and have experience working in Calvert County as well. I am also here to testify against House Bill 754. I want to make a couple of important points and echo what my colleagues in opposition have said already. This unfairly discriminates against low-income people routinely in courts in Charles County and St. Mary's County. Fines and costs are levied against people who very clearly cannot afford to pay them. Routinely, judges, no matter what the crime is, no matter what is offered during allocution, will give $100, $150 fine. I've had cases where someone's done something like stolen a can of crab meat because they couldn't feed themselves, and then they get a $100 fine. The idea, because these fines are being levied against people no matter what, that they would be discriminated against and not be able to expunge a case simply because they can't afford to pay that fine is absolutely absurd. Expungement should not be made more easily or more accessible to people who have more money. It's simply not fair. It should not hinge on wealth. I heard one of the representatives say that, I think it was, I'm not exactly sure who it was, that it probably would get rid of a civil judgment. Well, that shouldn't be good enough. Probably, well, it sounds to me like there's a possibility that a civil judgment would be sufficient to collect that fine, or could be sufficient to collect that fine. And that should be explored if the legislature is so bent on having those fines and fees collected. There was also a lot of discussion about restitution, and I want to just urge everyone to remember that, yes, restitution may be something that pulls on your heartstrings and you're thinking about making the victim whole, but this also includes fines and fees and court costs, and those things could hold someone back, and those are certainly don't carry anywhere near the weight that restitution, some people believe restitution does. The overwhelming number of people in the criminal justice system are impoverished. I see that every day, and my office represents the vast majority of people charged with crimes.
Ms. Thibault, I'll have to ask you to wrap it up.
Okay, and then one point regarding registration. I mean, I personally am against the registry, personally for expungement.
Ms. Thibault, thank you very much.
Thank you.
Okay. All right. We had signed up 2 other people to testify, but I do not see them in the waiting room. Nicole Hanson-Mendel and also Mary Denise Davis. And so with that, let's go ahead to questions. Oh, wait a minute. Hold on. They just appeared. Okay. So do we have Nicole Henson? Okay, hold on, committee. They're coming in.
Am I going next?
Yes, you are. Is that
I apologize. I just came over from the Senate, so
okay? Well, you got 2 minutes if you don't mind. Go ahead.
okay. So I hope I'm here to testify for automatic expungement of non-convictions. Is that the bill I'm here for? So I think, you've heard so many people talk about how important access to expungement is. Access to expungement is increasingly important now, where people need these offenses off of their record because they cannot get housing, they cannot get jobs. These records are being used for life insurance, car insurance, all of these things that help everyday Americans move their life forward. And it is really mind-boggling to us that the state would not automatically expunge something that they were not found convicted of. And this is something we can do. It is not like we do not have the technical ability to do it. Other states are doing it. We have some of the most brilliant students in this state that have the technological background to get this done. And I think it's just time that we stop making excuses and we do the right thing to remove offenses that folks were not found convicted of. And for those reasons, I ask that you support the work of this bill. This has to get done.
Thank you very much. And is Ms. Davis here?
Yeah, she just came over from the Senate too.
Okay.
Hello.
All right. Great. Thank you, Ms. Davis. Come on for 2 minutes.
I'll try to be really quick. Hi, Mary Denise with the Public Defender's Office. I just want to thank Delegate Wells for sponsoring this bill once again. I think it's very important when it comes to automatic expungement. We do need automatic expungement, and it's time to look.
Delegate Davis is shaking her head.
Ms. Davis, let me make sure that you're testifying on the right bill. This is HB 754. This is Delegate Pippi's bill.
Oh, wrong testimony. I apologize. Nicole was talking about automatic and I thought that was the bill because I missed the beginning.
Yeah, I was wrong too. I'm sorry. I just came in when you came in.
Okay,
I
so
apologize.
you're signed up for testimony on this bill. So
I apologize. The Public Defender's Office is in opposition to House Bill 754. And the reason why we're in opposition, one of the reasons is because of, I don't think it's anybody intends the collateral consequences of what this will have for individuals. As I mentioned just previously in my testimony, is that the U.S. Census Bureau came out with a report that over 500,000 people in Maryland are living in poverty, 9.4% of the population. And of that, 13.6% of people of color are living in poverty. And the Justice Policy Institute in DC had a study, which they published last year, that said Maryland's prison population is double more than any other state in the country. It's 70%. So when you put those numbers together, what this unintended collateral consequence is that people that are in poverty level, that have gone to prison, that have records, that have been in contact with the police, they are the ones that are going to be hardest hit when it comes to a portion of this bill, when it talks about the fines and the fees must be paid. In addition to that, I think that the law already says that there's punishment that provides punishment for that behavior. And we don't need to add that on to the expungement bill. The expungement law has always been viewed as a way for people to move forward, to become productive members of their community. And this bill basically is going to be almost use the expungement bill laws to hold people back, to say you can't move forward. And I think that is the wrong approach when it comes to the expungement law. I do apologize that I started testifying for the wrong bill, got a little flustered there, but hopefully you understand what I'm saying. I'm sure you do. And thank you. And yes, the Public Defender's Office is not recommending a favorable report.
Okay, and thank you very much. And Ms. Hanson, would you like to actually testify on the correct bill, HB 754?
Yes, ma'am. Thank you very much.
You got it. 2 minutes, please.
I echo the very concerns that my colleague Marguerite just echoed. We cannot continue to force people into poverty. We cannot continue.
Ms. Hanson, I need you to actually turn on your video. So
I apologize. Sorry. Okay, I'm all flustered. So thank you so much, Delegate Crutchfield, and the Judiciary Committee. Again, my name is Nicole Hanson. I am the Executive Director of Out for Justice, a grassroots group that is led by formerly incarcerated people, advocating for the policy reforms that will contribute to our successful reentry. And this bill just does not do that. It does not contribute to our successful reentry. When there are offenses that are eligible for expungement, they should be expunged. We should not be continuously forced into poverty and continuously forced into holding up our successful reentry because policies seek to stop us, right? Fines and fees, we have, so as I testified in the last committee, there's a movement around fines and fees and understanding that these fines and fees, for many cases, our individuals cannot afford them. And these should not be things that hold us back and stop people from moving forward in their lives. And so for all those reasons that were identified by my other colleagues, we are in opposition of this bill.
Thank you very much. And I see one of my colleagues and other committee members, just be prepared. It's time to ask questions of this panel. So Delegate Williams, will you go ahead and start us off?
Yes, I'm not certain if Ms. Tybalt is still here. I know she got cut off. She was about to start talking about the registry, but I don't know if Ms. Davis in her stead can answer or just continue to elaborate the concerns about the registry, or I'm not certain what her thought was about, or is she still here? Oh, she's coming back. Okay.
I was just going to say, she's trying to get back in, Delegate.
Okay.
I don't know if you guys were talking about me because I just got back in. I had switched to try to get into the Senate side because I was supposed to testify there too, and they had just wrapped up.
Yes, I was just trying to follow up with your comment that you were making near the end of your testimony with regards to the registry. I think you were about to elaborate about your concerns that you have. And so I just wanted to kind of hear your thoughts about that.
I appreciate that. I really also appreciated the questions about, a judge's intent. Most judges are aware of the law. If they're going to grant a PBJ, they're going to probably intend that could potentially be expunged in 3 years. But I want to point out something too, that if there is a genuine concern, if the concern is really genuine that a person would need to be on the registry for the full 15 years, it can actually be shortened to 10 at a certain point as well if the person's successful on the registry for that period of time. But if that's the sincere reason why we're prohibiting expungement here, why not make it so that the PBJ can be expunged after the registry period is completed, 10 years or 15 years? I would certainly push for something more liberal and expansive than that personally, but I think that would be much more of, that would honor the supposed intent of the bill. Again, I think that we should bear in mind that oftentimes a 4th degree sex offense can be something as simple as inappropriate touching on a bus. I mean, it's a very low level sex offense in many cases. And the idea that someone could be penalized for the rest of their life for that is, even after successful completion of the registry requirements, which are just overwhelming, is horrifying to me.
Thank you very much. And I don't see any other questions. So let's move this along. And that ends the testimony for HB 754. So next up is HB 851 and Delegate Ruth. Thank you so much, Delegate Ruth, for standing by for this. And you will be the first up.
No problem. Thank you.
Okay, and then after that, I'll call the favorables for the rest of your testimony. So you can get started. Go ahead, Delegate
Thank you
Ruth.
so much. Thank you. My name is My name is Delegate Sheila Ruth. I'm here presenting House Bill 851. Can you hear me okay? I just got a message. My internet is unstable. Okay, thanks. House Bill 851 prohibits the use of restrictive housing for incarcerated persons with serious mental illness. Imagine being trapped in a cell the size of a parking space for 22 to 24 hours a day. Your only contact with the outside world, a small plexiglass window and a slot where your food is delivered. For any person, this would be extremely traumatic. But for a person with serious mental illness, it can be actively harmful. Restrictive housing of individuals with serious mental illness can cause depression, trauma, paranoia, anxiety, hallucinations, and/or suicidal ideation. Restrictive housing is defined in Maryland law as a form of physical separation that has not been requested by the inmate, in which the inmate is placed in a locked room or cell for approximately 22 hours or more out of a 24-hour period. Restrictive housing can be disciplinary or administrative, but mental health or suicide observation units can also be restrictive housing if the incarcerated person is confined to a cell for 22 or more hours per day. HB 851 includes an exception for individuals who are an immediate and ongoing threat of imminent harm to themselves or others. But even in those situations, the individual may only be kept in restrictive housing for no more than 15 days, and daily wellness checks must be conducted to include determining whether the individual continues to present an immediate and ongoing threat. And I will note that some individuals have been in restrictive housing for months and some even for years. And you can just imagine what this does to a person with serious mental illness. Limiting restrictive housing does not cause an increase in infractions. In fact, other states and jurisdictions that have limited or prohibited restrictive housing have either found no change or seen a reduction in violent incidents. So House Bill 851 also includes a definition of serious mental illness, because the definition that's currently used by DPSCS is inadequate. And one of my witnesses is going to address that a little bit more. But the definition that they are using is clearly undercounting persons with serious mental illness, because the numbers that we have compared to other states are extremely low. And it's just not reasonable to assume that we have fewer people with serious mental illness than other states do. And so I would also ask you to look in the written testimony if you want to learn more about some of the details. And also I'd call out written testimony from Andre Travers and Chris X, both of whom are inside people with serious mental illness in restrictive housing, so you can read their stories directly. And with that, I ask for a favorable report. Thank you.
Thank you, Delegate Ruth, so much. So for the panel, including Delegate Ruth, we're going to call now next Kimberly Haven will be on it, Munib Farashbi, Janine Trayora, Daryl Frazier, and Julie Major. So is Kimberly in?
I am. Thank you so much, Delegate.
Perfect. Thank you.
Thank you so much.
2 minutes, please.
It's great to see everybody. Thank you so much, members of the committee. My name is Kimberly Haven, and for the record, I am here on behalf as the legislative liaison for Interfaith Action for Human Rights. This bill last year was brought before this committee and passed. We had strong support. Many of you were actually co-sponsors on this bill. What is imperative about this bill is that a phrase that I've kind of coined over the last couple of years is what we do to, what we don't do for or with the people that we incarcerate is what they're going to bring back to the community. We do have a serious mental illness issue within our prisons. This legislation would provide a means for us to not further the harm that is currently being done. We know that anything over 15 days is considered torture. And we have, as the delegate said, people that are serving weeks and months and years, and the damage that is being done to their mental health, their physical health, their emotional health, their spiritual health is becoming incalculable. And so this is strong legislation that not only defines what serious mental illness is, because currently the department does underreport. They use a very generic definition. This would tighten that up. It would also be very clear. It would also give us clear understanding of what's going on behind the fence. This way we could treat. We know that what is happening behind the fence is coming home to the community. This bill is strong legislation. We've introduced it before. And for that reason, I urge this committee's favorable report of House Bill 851. And I'm free to answer any questions that this committee may have. Thank you, Delegate Crutchfield.
Thank you very much. Next, we will hear from Manib Lohreshbi, and hopefully I pronounced that somewhat correctly.
It's in the ballpark. Thank you, Madam Chair. I appreciate that.
Thank you.
My name is Manib Lohreshbi. I'm a decriminalization and human rights attorney with Disability Rights Maryland. You'll hear plenty about the harm of restrictive housing, and I would refer you to DRM's written testimony for the overwhelming consensus of organizations that recognize this harm and have put in recommendations supporting these measures. But I do want to spend some time talking about the specifics of this bill. Delegate Ruth mentioned that the SMI definition would change. Currently, DPSCS just uses the Maryland Department of Health's community-based definition. Without commenting on the strength of that definition in a vacuum in the community, it's simply inapplicable in prisons. It requires a finding of significant functional impairment, and there are 5 listed criteria for that. 2 of the 5 are inability to maintain independent employment and inability to procure financial assistance to support living in the community. So 2 of them straight off the bat do not apply in a correctional setting. And in order to have a finding of significant functional impairment, you need to hit 3 out of the 5 factors, right? So already we've significantly narrowed the scope of who could even be considered to be SMI, right? And that's backed up by the numbers, as Delegate Ruth mentioned. The department does provide the percentage of folks who are SMI. National averages for state, because this is state by state, is between 15 and 20%. Maryland 10 years ago in 2011 reported 1.2%. 1.2% of their incarcerated population is SMI. That number increased about 5 years ago to roughly 8%, and in fiscal year 2019 was bumped up to roughly 10%. I'm giving you the 2019 numbers because the department's annual restrictive housing report, which is due in January to the legislature, still has not been submitted for the 2020. So I have to use 2019. This is also backed up by DRM's work in prisons. We've met with several people who just visually and just facially appear to be very unwell. But then we go to their records and there's no SMI diagnosis noted, and they're not receiving any services other than medication management, sometimes for years at a time. So not being identified does result in less services for folks who desperately need it. It doesn't mean that those folks don't exist. The other thing that we hear from DPSCS is how they prefer the American Correctional Association standards, but it's right there in the name, right?
It's time to wrap it up. So
I will wrap it up. So DRM urges a favorable report for this bill and would be happy to answer any questions in the back end.
thank you so much for your testimony. Next, we're going to hear from Janine Trayor. Let's see, is Janine here? Trayor. Okay, let's go with Major.
Hi, good afternoon, Delegate Crutchfield. It's
Thank
nice
you.
to see you. And members of the committee, my name is Julie Majors. I'm the director of the Prisoners' Rights Coalition. Thank you for allowing me to testify today in support of HB 851. There's absolutely no doubt that we, for years as advocates, have proven the dire concern around the overuse and inhumane nature of restrictive housing and the extreme damage that it causes for people with a mental illness. This damage is far more extreme. I want to reiterate that due to the inadequate definition of SMI that the department is currently using, and one that isn't fully appropriate to someone in a prison setting, people are constantly being overlooked. We receive constant reports of individuals who out in the community have a condition that qualifies as an SMI, but they are still not being identified by the department. So in turn, they're not receiving proper care. This is irresponsible. It's a rights violation. And at the end of the day, it's the department's responsibility to fully and adequately identify people. Mental illness is not a corrections issue. It is a healthcare issue. Absolutely no one with SMI should be held in restrictive housing without health checks by a licensed healthcare provider. No hospital that I know of would send an unqualified individual to monitor a patient in their hospital. That would be absurd. We receive reports of individuals with SMI being held for weeks, months in restrictive housing and have yet to see a healthcare provider. So they're languishing in their illness, untreated, and causing damage that cannot be repaired. This isn't effective. While the department is claiming that they're isolating individuals that are a threat to themselves or others, this should be done effectively. And people should also not be punished severely just because they have an illness. For these reasons and so many others that I don't have 2 minutes for, we are asking for a favorable report on HB 851. Thank you.
Thank you so much. And our last panelist will be Daryl Frazier. And is that Daryl? Mr. Frazier, are you there? Okay, seems like he's not there. So let's go ahead with questions for this panel committee. This is our favorable panel. Anyone have questions? Let's see, and I don't see any questions.
Wait, Delegate Crutchfield,
Oh,
there are a couple of us that have
okay.
questions. Sorry.
Like I said, I'm just, yes. Thank you, Delegate Shetty. Okay, let's go ahead and start with you, Delegate Shetty.
Oh, okay. Thank you, Madam Chair. I appreciate you. You're doing an awesome job. Thank you so much. Delegate Roos, thank you so much for bringing this important bill forward. This question is for Munib, please. So I'd love for you to address in our bill file, we received some unfavorable testimony that caught my attention. It's from the Maryland Psychiatric Society. And they have some concerns that they've expressed that the bill could potentially lower the standard of care for individuals. And I'm just wondering if you could, share a little bit of insight, if you've seen the letter or if you have any additional thoughts. Specifically, it says that incarcerated individuals in restrictive housing are already monitored regularly and that psychotic individuals are under continuous monitoring. So any specific feedback you have on that is welcome. Thank you.
Thank you for the question, Delegate Shetty. And the answer is fairly nuanced. Restrictive housing, refers to several different units. So in terms of observation, one of those units is suicide observation housing. When folks attempt suicide or express suicidal ideations, they're taken to a restrictive housing unit that is true solitary confinement. You don't get any clothing, no furniture, no programming whatsoever, and actually get out of cell less than you do in disciplinary seg. But in those units, you do get an observation aide who does observe you 24/7. That observation aide is another incarcerated person, no training. While we would prefer someone licensed, I do understand that some observation is better than no observation. However, in segregation, which is the large majority of these placements, right, both administrative and disciplinary segregation, there is no observation aid. There are weekly mental health rounds, but from what we understand, those are just like knocks on your door. Are you doing okay? That's about it. When folks say that they are not okay and want to be seen, they're simply directed to submit a written request. So there's no observation there. The care by every account we've gotten is far lower. And I do believe so anyone that has somatic physical issues can be sent to the infirmary, which I believe was referred to, but that's not to address mental health issues. Mental health is different. Folks are either sent to restrictive housing units or to the Patuxent Institution. I am not here to say anything negative about the infirmaries, but that's simply not where folks with mental health issues are sent and not what this bill is meant to address. So I hope that answers your question.
It does. Thank you so much.
Madam Chair, could I add to that?
Yes, you may.
Thank you so much. And I appreciate the letter from MPS. They raised some important points, but I think, the theory of what happens inside as they describe it and the reality sometimes are different. And I can't say I speak from personal experience, but I know Disability Rights Maryland has done a lot of research on that I've read their research. But I did also want to read just one sentence from Mr. Travers' testimony. He says, I've been asking for help, but no one have experience with people with mental illness. It's no one to talk to at all, no self-help programs or no therapist to help with my issues. I'd be in the cell all day, 24/7, 365 with my only thoughts. And so while in theory, it sounds very good that they have, you know, that they say they have this care. The fact is that there's not enough care, and we should be providing care and not warehousing people. And, you know, that providing that care is not only the humane thing to do, it's good for public safety because helping people with mental health issues helps reduce recidivism and helps to improve public safety. So thank you so much for the question.
Thank you, Delegate Ruth. Delegate Cox, you have the next question.
Thank you, Madam Chair, and you're doing a fantastic job. And thank you to Delegate Ruth and members of the panel. Real quick, Ms. Major, do you happen to be a constituent of District 4?
Of your constituent?
Yes.
Or like, am I your constituent? Yes, I am.
You okay? I thought I recognized you.
Yeah.
I have a quick question.
Sure.
Mako sent in testimony saying that they didn't think that any of the local jails could live up to this high standard of a certified healthcare doctor or staff, certified healthcare staff, to be able to do this daily routine check. Do you have any, or anyone else have any information on that that issue that Mako raised and how that might be addressed?
The only comment I would have as far as living up to the standards is that the Constitution protects their right to health care, and it's their responsibility to be doing this. So the department puts somebody into a cell saying that they're a threat to harm or to themselves or others, and then they don't come back. There's nobody monitoring that. So it's kind of a catch-22, right? You're saying that this person's harmful to themselves, which is the majority of them, but yet you don't monitor them. It's still their responsibility. It's a responsibility to find the staff and the qualified staff to do that. At the end of the day, as I always say, it is their responsibility, and it's the individual's right to have that care. And all you're going to do is cause further damage, which is going to cost more and more, not just to those people, but to our community. So it's worth putting that proper staff into. And I say this for everything, not just restrictive housing, but today we're here about restrictive housing. So if somebody has a serious mental illness and they're not receiving that care and they're locked in that cell, what do we think that ultimate outcome is going to be? It's a responsibility of our state and of our department to make sure that those people are getting that proper care.
And I would just add, Delegate Cox, oh, I'm sorry.
I was just going to ask a real quick follow-up. Thank you for that. And I just am curious to meet the financial requirement. Is that going to be the county that pays or the state? I was a little confused on how that would work.
So Delegate Cox, if I may just cut in there first on the financial question, it's going to be whichever entity is operating the facility, right? So for prisons, it would be DPSCS, the state, and if a facility is operated locally, it would be their responsibility. However, I just wanted to note very quickly that there is a built-in loophole into all of this, right? This all only applies to restrictive housing, 22 hours or more per day. If this is a burden that's too much for any local facility or any facility in general, you can just let folks out for 2.5 hours per day, right? An hour in the morning, hour and a half in the evening, none of this applies. So it's this very simple loophole that frankly, we hope that DPSCS and others take advantage of. But if we're going to insist on subjecting folks to a practice that we know to be harmful, then we just do want some basic protections.
Thank you all very much.
Thank you.
Thank you. Delegate Fisher.
Thank you, Madam Chair. I'm going to direct this question to Delegate Ruth, and then if she wants to direct it to one of her panelists, that'd be great. In the fiscal note, I wanted you to address DC PCS says that they would need to hire 9 professional counselors, 7 social workers, 28 additional correction officers, and they estimate, I guess, like $2 million or $2.3 million. What do you say in response to the financial and the personnel projection that they feel on your bill.
Delegate, thank you so much for that question. And, you know, there's no question that regardless of this bill, DCPCS needs to hire additional counselors and additional social workers. That's clear. That's not contingent on this bill, that there's just not adequate healthcare, you know, in the system. I believe that the 28 correctional officers is a complete misreading and misunderstanding of the bill. You know, what that's based on is that the bill allows for somebody who is an immediate and ongoing threat to themselves or others, it does allow restrictive housing for 15 days, but there has to be a wellness check every day by a healthcare professional and not just knocking on the door and saying, are you okay? And so they're saying they need 28 correctional officers to escort the incarcerated people to these healthcare wellness checks. The problem is this 15-day exception is just that, it's an exception. It's to only be used in extraordinary circumstances. And so there shouldn't be a lot of people with serious mental illness at any one time in restrictive housing if they're following the letter of this bill. But you know, there's no question that they do need additional mental health. And sorry, I didn't know what that was. And you know, we have a systemic issue here that goes much beyond this particular thing of how we deal with people with serious mental illness. And somebody mentioned MACO. I just want to read a sentence from their letter. MACO was in opposition, but MACO says, the goals of fair and humane treatment of affected inmates would be best served by developing proper facilities where restrictive housing can be replaced by medically supervised, fully appropriate care. I couldn't agree more. We need that. We need, you know, medically supervised, fully appropriate care, but that's going to be a lot more money to do that. And personally, I think that it would be money well spent, but the amount that's needed to address this bill, first of all, is nowhere near the 2.3 million for correctional officers that they've said. And, you know, and it's just a small, this bill only addresses one small piece of what's a much larger systemic issue. Thank you so much.
Thank you.
Thank you. Any other questions? I don't see any more hands raised. Let me just double check. Any more questions from the committee? Okay. Seeing none, let's move on to the next panel. And that is, we're going to bring in Evelyn Burton, Thomas Reese, and also Michael Sanderson. Okay, and we'll start with Ms. Burton, who is a favorable with amendments. Ms. Burton. Do we have Ms. Burton? No. Ms. Burton, if you can start, you'll need to show your video, please.
Oh.
Ms. Burton? Perfect. Thank you so much. You have 2 minutes, please.
Okay, thank you. Good afternoon. I'm Evelyn Burton. I'm the advocacy. Can you hear me? Hello, can you hear me?
You need to, yes. Do you have on, Burton, if you can start, you'll need to show your you have something in the background. Do you have the Zoom on as well?
Oh, yeah, I do.
Okay, you need to turn that off, please.
Zoom.
Yeah, you need to turn that off.
Okay. This is
All
the
right.
first time I've done this on the
No
video.
problem. You've got 2 minutes. Thank you.
Thank you. Good afternoon. I'm Evelyn Burton. I'm the advocacy chair for the Maryland chapter of Schizophrenia and Related Disorders Alliance of America, and we strongly support HB 851. However, what the bill does not address is the fact that medication is usually the only effective treatment for violent and suicidal behavior caused by psychotic illnesses, such as schizophrenia and bipolar disorder. Restricted housing only worsens the illness. If because of psychotic thinking, the inmate refuses medication, the jails and prisons are prohibited by law to administer medication over objection. This can only be done in a hospital. Therefore, we believe it is extremely important that HB 851 be amended to require that inmates with a mental illness be evaluated within 24 hours of the onset of behaviors defined in paragraphs 8, 3, and 4 of the bill to determine if they meet statutory standards for involuntary hospital admission. According to testimony submitted last year on HB 742, Mrs. Logan's son, who was diagnosed with schizophrenia, became violent and psychotic and refused medication while incarcerated. He was held in restricted housing for several months in a county jail, over 1 month at Patuxent Institute, and over 2 months at North Branch Correctional Institution, rather than ever being sent to a state hospital to get back on medication. Such denial of the constitutional right to appropriate treatment is unacceptable and needs to change. It not only causes permanent brain damage due to untreated psychosis, it puts the inmate, fellow inmates, and staff at serious risk of harm. So we ask you to please consider our proposed amendment and support HB 851 with that amendment. Thank you.
Thank you very much, Ms. Burton. Let's go to Mr. Reese next for an unfavorable testimony.
Yes, good afternoon. Good afternoon, Delegate Crutchfield and members of the Judiciary Committee. I'm Major T.D. Reese, the administrator of the Calvert County Detention Center and the current president of the Maryland Correctional Administrators Association. And I'm here this afternoon to speak in opposition of House Bill 851. The MCAA is really, we're in favor of a majority of the bill. We take issue, we don't take any issue at all with the welfare checks, the vital checks, the required documentation. However, we just need the committee to understand that not all local jails in Maryland have full-time mental health staff. There are some that have mental health staff around the clock, some that have mental health staff available Monday through Friday during the business hours. However, there are others that have 1, maybe 2, 3 days a week for maybe 1 or 2 hours through that time frame where somebody will stop in as needed to see the inmates that are required at their jail. The coverage is very different across all 23 of the local jurisdictions in Maryland. And no one can predict the nature of the crime, the circumstances around the crime, or any part of any situation that ultimately could fall on a local jail administrator's responsibility on any given day. Our main problem with the bill is the 15-day stipulation. Now, the Maryland Behavioral Health has come a long way in getting people placed in the state hospitals within the 14-day, the 2-week time frame. However, the time frame doesn't start until they're committed to the facility. Getting the person through the legal process could take 3, 4, 5 days, getting them committed to the jail, at which point then the process starts of getting to the hospital. The 15-day is going to be tough, and it's going to create undue liability on the local detention centers facility, because these people are not stable when they arrive at the jail. They're in serious need of help. Like I said, we do the welfare checks, we do the vital checks, but.
Thank you very much, Mr. Reese. We need you to wrap.
Oh, okay. I just want to say, until such time as Maryland develops some emergency diversionary hospitals for the serious mental ill, receiving people off the street in all different types of situations is going to be tough. Local jails are not the best place to house inmates with serious mental illness.
Thank you very much, Mr. Reese.
We're the only place.
Thank you very much. Mr. Sanderson, you're next, please, for 2 minutes.
Thank you very much, Madam Chair and committee members. I'm Michael Sanderson with the Maryland Association of Counties. Flattered by the committee's earlier references to MACO's testimony and comments, including the sponsors. And I think you've already heard from Major Reese. I think the bill is focused on a real problem and it's one that's absolutely worthy of solving. I think our issues are really nuts and bolts. I think we can almost all agree individuals who are seriously mentally ill really shouldn't be in our local jails. That the early conversation has been about prisons, and we want them in an appropriate psychiatric facility when they can get the kind of care and the kind of attention that they need and deserve, including the screening to determine when they should get out of that increased level of care. The problem is, all too often, there simply doesn't exist a state bed to receive somebody who is unfortunately in our local jail that's not equipped to give them proper care. And that's that. I mean, you've heard the phrase catch-22 earlier in testimony. That's our current catch-22. The state simply doesn't have a bed to take somebody that we all agree needs one. The fix, I don't think the fix is to develop 23 jails up into mini psychiatric facilities, but rather let's find the capacity to take that overflow on an emergency basis, like Major Reese said. So attach myself very much to the comments from Major Reese and the correctional administrators. We know there's a real problem here. Building up and holding the jails to those standards is probably right church, wrong pew, so to speak. Thank you, Madam Chair.
Thank you very much. Are there any questions for this panel from the committee? Okay, I don't see any hands raised. Let me just make sure. Okay. All right, well then that will conclude the testimony on this bill. Thank you very much.
Thank you.
And we're going to move on to HB 847 and Delegate Cox's bill.
Thank you, Madam Chair and members of the committee, my friends. Madam Chair, if it's possible, Amanda Long and Andrew Palera are also on my panel. If they can be let in, if they're able to be.
Yes,
fantastic.
they will be let in.
Okay, thank you. For the record, Delegate Cox for House Bill 847, Registered Sex Offenders Residency Restrictions. And honorable members of the committee, this bill is a simple approach to protect our children, the most vulnerable among us, when it comes to ensuring their safety around registered adult sex offenders. Right now, adult sex offenders are not permitted to enter school property because of that need to protect children. However, currently they can live next to a playground. They can live next to a daycare center. They can move in next to a place where children gather for the bus stop every day. And on their front porch, they can point a camera for security purposes and catch children in the camera feed playing on the playground. Sadly, this is exactly the case of my constituency in Frederick County. You're going to hear from individuals from Thurmont who this has been brought to their attention, but the real issue here is protecting our children. There are 40 states in the United States that have similar legislation. So this is not a new thing. We're actually in the very extreme minority for not having protection around our playgrounds. And this bill is prospective only, so it won't impact prior offenders who have already registered and are living somewhere. So it's my hope that you'll look favorably on this, and I ask you to provide a report out with a favorable report. Thanks so much.
Thank you so much, Delegate Cox. And we will hear from Andrew Palera.
Yes, thank you, Madam
and
Chair.
Mr. Palera, you will need to put on your video, okay?
Yeah,
please.
sorry.
Thank you.
Okay. Thank you, Madam Chair, members of the committee, Delegate Cox. I'd like to take this opportunity to request a favorable report for this bill. I am a resident of, my family and I are residents of Frederick County. We've been here for over 17 years now and really have enjoyed being in Maryland. Maryland statute 11722 does restrict registered sex offenders from the property of public or private elementary or secondary schools, as well as multiple types of childcare facilities. This bill will really just help extend that border to protect those schools. We're requesting 1,000 feet residency restriction for those locations. Maryland is unfortunately ranked number 10th on a list of states with the most child sex abuse victims per 100,000 children. So we really recognize the need for this to do more to protect our children. The Maryland laws do require, registered sex offenders to provide their information as far as where they're going to live, and all the information surrounding their conviction. Their website even states it's very important for people to use their website as a tool to help protect their children. There's lots of information out there in regards to the damage that is caused by sexual abuse to children. So this bill will help us to recognize, to protect our children, to provide a better boundary for them. As Delegate Cox had mentioned, this is very commonly used throughout the United States. There are the states all around us all have various levels of residency restrictions already. So Maryland is the only state around in this area that does not provide any type of restriction. And one other thing, that there are some studies out there that will indicate that the residency restrictions are negatively impacting or do not help negatively impacting the registered sex offenders, as well as there's no benefit to it. In October of 2020, the Federal Research Division within the Library of Congress had produced a report basically refuting that and stating that their conclusion was indeterminate. They found prevalence of shortcomings in their research and the way that they conducted these researches, asking the inmates themselves or the registered sex offenders, if they were the ones providing the information. They were not doing any type of controlled studies within their research. So once again, would request a favorable report for this bill to help protect our children throughout the state of Maryland. Thank you.
Thank you very much. And next we'll hear testimony from Amanda Long, please.
Hi, can you hear me?
Yes, thank you.
Thank you. Thank you for your time today. I'm here in support of this bill, and I approach this issue from the perspective of a parent, but also a survivor of child sexual abuse and sexual assault myself, and for the past year, the neighbor of a repeat child sex offender. My neighbor lives within 400 feet of a community park, within walking distance of several schools, and directly next door to a daycare. I've provided a lot of statistical data that I believe supports this bill within my written testimony, but with limited time here today, I'll focus on just a few points. Maryland is one of very few states with no residency restrictions for sex offenders. Our state ranks number 10 in the rate of child sexual abuse. 7 of the states with no residency restrictions, so out of that 10, are among the top 20 states for child sexual abuse cases. I'm not advocating that we cut sex offenders off from community resources, and that's not what this bill proposes. I'm asking that we protect children from known predators by limiting access those predators have to children. According to a 9-year study conducted by the Bureau of Justice Statistics, sex offenders account for 9% of prison releases, but 16% of sexual assaults following their release. The same study found that 50% of sex offenders released from prison had subsequent convictions. My local sheriff's website states that residency restrictions do not prevent sexual offenses because the victims in most cases know the perpetrator, and that having ready access to victims is how sex offenders thrive. By allowing offenders to live within close proximity of where children congregate, we're allowing them to become known to victims and giving them ready access to those victims. In fact, in 59% of cases, perpetrators are only acquaintances of their victims. Take, for example, the case that led to Megan's Law. Megan was a 7-year-old girl in New Jersey who was lured into her neighbor's home where she was raped and murdered. Her neighbor was a registered sex offender. Megan's family then fought for the nationwide sex offender registry. My neighbor, along with countless others, made the choice to sexually exploit children. The damage done by these predators can never be undone. There are many people who advocate for the rights of sex offenders and defend these individuals. I'm simply asking that all of you be advocates for Maryland's children. Thank you.
Thank you very much. And before we go on with questions, I just want to remind the committee and those who are listening live stream that we will take a break after this bill for 1 hour. So committee, are there any questions for this panel? Okay, I don't see any hands raised. So we will move on to the unfavorable testimony on this, and we'll bring in Brenda Jones first. Oh, sorry. Didn't see you there. Thank you. Okay, Delegate McComas, go ahead with your question.
Madam Chair, I'm so sorry. I just wanted to ask a question and maybe have the sponsor think about this, but we had an incident in Harford County where there were the girls, either soccer team or lacrosse team, were playing on a field that was more than 1,000 feet away. And it was at the Bel Air High School, okay, on one of their fields adjacent to the high school. And the guy was on the roof, and he was a sex offender. I don't know what level he was, but he had one of these giant telescopes, and he was looking at the kids play. And I mean, that's kind of, I don't think it's a crime, but it was kind of creepy. And in other words, I guess what I want to say is that I think these folks have a real problem, and they're very inventive. And it's just, you try to close one loophole and then they figure out another one. So I wondered if anyone had thought about that. It's like trying to trap water in your hands.
Well, thank you, Delegate. And actually, that is one of the reasons for my bringing the bill, is because this particular situation in Frederick County incurred this similar kind of surveillance with a video by this registered sex offender of the playground. And he was within the 1,000 foot, and there was nothing that the police or sheriff could do because, he was simply a resident and was not, using his video cameras other than just for surveillance. And so, but it was very creepy, and obviously, the parents involved, including my constituents here, were quite alarmed that there wasn't a concern. And I think it does a disservice to the bringing back of individuals who've done their time into society to to have no barriers to to children every day like that, in a way that would not provide appropriate contact or interaction.
Thank you, Delegate Cox. Any other questions from the committee? Okay, so we'll go ahead and move to our unfavorable testimony. I believe Ms. Jones is not in the room, so let's go ahead with Mr. Smith, David Smith, if you'll go ahead and provide your testimony for 2 minutes.
Maybe I'll try that again. Thank you.
Thank you,
Madam Chair. My name is David Smith. I'm a resident of Washington County and a member of Families Advocating Intelligent Registries. HB 847 would prohibit registered persons from residing within 1,000 feet of many, many places. Think about that. What would that look like in your neighborhood? Where is every designated school bus stop? They change frequently as kids grow up and families move in and out, and they're rarely marked. Where's every childcare facility, especially home daycare centers? They are rarely marked. And I guess above all, what's a place where children regularly congregate? Is that a Chuck E. Cheese or McDonald's or a storefront dance studio, movie theater, library? Or these days, even a favorite sledding hill in someone's yard or on a public street. So the first challenge with this bill really is its vague language, and that will open it to wide interpretation. And that leads to a second issue in enforcement because of the vague language. If enacted, there eventually will be thousands of registrants who cannot live in these somewhat fluid areas, even if they return to the same residence they may have occupied for years prior to conviction, law enforcement would invest lots of resources on maintaining a list of off-limit sites and making that available. A 2006 law prohibiting residents near bus stops was struck down in Georgia because it was impossible to enforce. And there are a number of states, I don't have a list right now, who have had to modify their residency restrictions because of vagueness. HB 847 is also redundant. Supervision restrictions are already tailored to the actual crime, restricting people from their victims or from children in general, or as pointed out, to specific schools and places of worship as well. These tailored supervision restrictions and conditions provide a much more targeted, efficient, and managed environment than overly broad, vague language. For citizens lucky enough to be returning to supportive families or communities and finding a job, this bill may actually unintentionally undermine the very best chance they have for rehabilitation and reentry into society. Madam Chair, for these reasons, I respectfully urge an unfavorable report on this bill, and I'd be happy to answer any questions.
Thank you very much, Mr. Smith. And Mr. Smith is the only person on this panel. And do we have any questions? I see Delegate Carton's hand up. Go ahead.
Thank you, Madam Chair. It's nice to say that to you. And thank you very much, Mr. Smith, for your testimony. My concern with the bill, and maybe you can elaborate on this, I think if you interpret this bill as widely as possible, if you have a county that wants to interpret this as widely as possible, there's essentially nowhere where one of these people can actually reside in the entire county. Maybe in a commercial or an industrial complex of some sort, but it would seem to me that we're trying to, in a certain sense, rid ourselves of these people, and we can't. I don't know how you do that. And it also, it doesn't allow us to work on the rehabilitation and reentry concepts that should be invested in, because you're basically saying people aren't welcomed in our communities. I'm wondering if you can comment on that.
Thank you for your question, and I would be happy to. In the written testimony submitted by Brenda Jones, who was planning to be here but apparently is not, the executive director of Families Advocating Intelligent Registries, you will find two maps. One is an area in West Baltimore, and one is Cecilton in Cecil County. And they show, just on a quick first look at schools and parks in a 1,000-foot radius, what those prohibited areas would look like. So I hope you do have that written testimony. I am unable to share a screen, but it does basically, to go to your question, Delegate Cardin, there are not many places in Baltimore City where a person could live. And in Cecilton, there aren't any places. So it goes from the big city to small towns. And that basically has the effect of driving people somewhere else or undercover, and it makes it more difficult to track. I mean, as was mentioned, one of the features of the registry is addresses. You know where these folks are. If you drive them into homelessness, it's much harder to track them. And that creates other issues of maintaining safety and monitoring them. So I appreciate your question, and it does create additional law enforcement problems, monitoring problems, as well as impacting people who, most of them, the overwhelming majority, trying to come back, be rehabilitated and reentry. So thank you for your question, sir.
Are there any other questions? Oh, yes. Delegate Cox, come on.
Thank you, Madam Chair. Real quick, Mr. Smith, just want to follow up on your comments. Is there any state of the 40 states that have these laws in place? Is there any bill or prototype that you would agree with?
Thank you, sir. That's a very good question. I am not well enough informed to answer that. The issues I often hear of are those that have, if you will, overreached and become impractical for enforcement, or a constitutional issue. So I can't do that. I can't answer your question. I would say, however, the current registry system has information on where every registrant resides and works. And in that respect, the system already has a way to track these folks where they are most of their awake and sleep time.
Do you believe in the registry system, real quick?
I should maybe ask you, do I believe in it? I have reservations in its effectiveness on reducing sexual offenses. Data in our own Department of Correctional Services and Public Safety have indicated that registry restrictions would not reduce sexual offenses hardly at all, because 97% of offenses are perpetrated by people who know their victims and the victims know them, almost all of that in our own homes. And to that extent, if the registry did work, we still have a huge number of offenses in our state by people who are not on the registry and never were.
Thanks for clarifying that. And we just, experienced a pretty horrific crime in Maryland, and the legislature is looking at banning or somehow limiting access to student sex offenders to schools. Obviously, that's a different issue because those are students, but we do have a law that says that adult sex offenders are not allowed on school property. Do you agree with that?
I think that's excellent in most cases. I think the only thing is when they have one of their children attend that school, it seems that might be not appropriate in all cases.
So where would you, this bill is patterned after that. So if you have any amendments or considerations for protecting playgrounds, just like schools, I'm all ears for that. So thanks for your time. Thank you, Madam Chair.
No problem. Okay, committee, I don't see any more hands up. So I would, okay, let's just confirming that. Okay, well, I think that ends the testimony on HB 847. And committee, we will now go ahead and move forward with our break. And we will come back at 6:30. Just a reminder, please make sure that you mute yourselves and also you turn off the video. Thank you very much. See you after the break.
All right, everybody, we're going to begin here in a moment. We need Delegate Wells. I am live here, and we're waiting for Delegate Wells so that we can, there's Delegate Wells. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. We have 12, so we can begin again. Good evening. This is part 2 of the House Judiciary Committee, or maybe part 3 actually, of the House Judiciary Committee meeting today. This is going to be the beginning of the testimony on 3 bills. House Bill 238 is what we're going to do now. And to testify on House Bill 238, we'll have Delegate Wells for 3 minutes, then Karen York, Mary Denise Davis, Nicole Hansen-Mundell, Billy Murphy, and David Schlussel. They will be testifying in favor. They will each get 2 minutes after Delegate Wells' 3. So with that, we will begin with Delegate Wells. And whenever you're ready for 3 minutes.
All right, thank you, Chair Clippinger, Vice Chair Atterbury, members of the committee. For the record, my name is Delegate Melissa Wells, and I'm here today to testify on HB 238, which is going to be the beginning records when charges do not result in conviction. 3 hours, just 3 hours, according to the judiciary, is the average amount of time it would take most complicated district court cases to be expunged. 5 hours in their testimony is the average amount of time it would take the most complicated circuit court case to be expunged. The hours are basically what is standing between an innocent person and a clean record that would allow them to seek higher educational opportunities, better paying jobs, and an increased quality of life. And I think it's quite sincerely the bare minimum of justice that we can provide to innocent people. If we could agree that that time is worthy of their ability to fully participate in society. I do recognize the fiscal impact of this bill. In a conversation about justice and equity, money should not be the sole reason we cannot provide equity and justice to people who are already seen as innocent in the eyes of the court. Background checks are necessary for many career and educational opportunities. Employers that run background checks are likely to turn someone down who has charges on the record compared to another candidate that has a clean record. Educational institutions may decide not to accept or provide financial aid to potential students that have criminal records as well. Criminal records, we know they hinder the ability of people to afford the same privileges that those with nothing on their record currently have. And why are we not asking ourselves about the money and quality of life that's lost here for those individuals impacted by these records? Over time, the cost of criminal records builds up. This includes loss of potential salaries, educational opportunities, access to social services over many years. These losses make it hard, especially for low-income workers, to be financially successful and able to care for their families. This bill specifically focuses on expunging the records of those who were not charged with a crime. Again, they were not charged with a crime. The saying innocent until proven guilty is not apparent here. Guilty, even if proven innocent, is a better fit for the current law that we have on the books. The current law affects many low-income workers, especially Maryland's Black community, and many Black Americans are more likely to also have encounters with the police in which these records could be used to profile against them. So while this single issue does not give all people the same opportunities for success, it does rid us of a barrier that is unjust and keeps innocent people from reaching their full potential. For these reasons, I ask the committee offer a favorable report on this bill. Thank you.
All right, for 2 minutes, Karen York, please.
Thank you. Good evening, Mr. Chairman and members of the committee. For the record, I'm Karen York, CEO of the Job Opportunities Task Force, speaking in strong support of House Bill 238, which would provide for the automatic expungement of charges that do not result in a conviction. For over 10 years, JOTF and partners have stalkingly come before the Maryland General Assembly to urge passage of legislation that would allow for the automatic expungement of these charges. For JOTF, automatic expungement and the repeal of the unit rule is key to ensuring low-income workers with a criminal background can obtain the very opportunities they are prevented from accessing due to their record. Yet a criminal record can be both the cause and consequence of poverty, and the effect is most pronounced for Black workers. Low-income workers and job seekers are routinely denied employment and educational opportunities because of a record. Worse yet, many don't realize they have the record until they are rejected for the job opportunity. And as such, many do not move to seek expungement because they were advised that their charges were dropped, dismissed, or they were found not guilty, so they think they don't have a record. So thousands of workers in Maryland are stuck with dated records, many of which are non-convictions that hinder their ability to secure employment. Recently, the General Assembly moved to eliminate the cost barrier for expungement of non-convictions, recognizing the financial barrier that expungement can serve for those attempting to move past those experiences. The last remaining barrier is the petition. If the state recognizes that you shouldn't have to pay a fee to expunge charges that didn't result in a conviction, this should also extend to having to petition the courts to expunge those charges. A host of states have moved to provide for automatic expungement of non-convictions, and Maryland's own MVA provides for automatic expungement of certain driving records. In 2021, we should be able to figure this out, even if figuring it out is within a work group recently formed to address partial expungement. And so House Bill 238 again seeks to provide relief to Marylanders seeking to move past those charges that did not result in a conviction, but do result in missed job opportunities, denied housing, and higher scrutiny in occupational licensing, higher education, and more. We urge a favorable report. Thank you, Mr. Chairman.
Thank you. Mary Denise Davis, please.
Good evening, this is Mary Denise with the Office of the Public Defender. I'm here today to testify in favor of House Bill 238. Thank you, Delegate Wells, for introducing this bill and all the delegates for moving expungement laws forward for the benefit of Maryland citizens. The purpose and intent of this bill has been part of other recent bills in past sessions, but unfortunately, automatic expungement for favorable dispositions have just not become the law yet. I think it's time to have automatic expungement in Maryland. There should be no more excuses why this cannot be done. First, this bill is prospective. It's not asking court clerks to search and determine eligible cases from years and years in the past for automatic expungement. This bill has an opt-out clause to address any concerns that the defendant may have. This bill prevents the complete obliteration of records for 3 years, addressing concerns regarding potential lawsuits against the police or other law enforcement. This bill allows for service providers, attorneys, and pro se litigants to focus on the more time-consuming expungement petitions that require a hearing and litigation. Let's take the easy expungement eligible cases off everyone's plate. It's important for everyone to recognize that anytime someone says, oh, where there's smoke, there's fire, or something to that extent, what they're really saying is that this non-pros, acquittal, not dismissal isn't really a favorable disposition because they're giving it a taint of guilt to that, however minor that is. And that needs to change. Innocent until proven guilty is words that every American knows and lives by. And automatic expungement is a small step in making that credo a reality in the 21st century of mass information and the ease in which that information can be found. It's time also that we look at the process of an expungement proceeding itself. I provided an overview of the steps of the laws that have changed in the recent years. We really need to look at the process and see how we can make that easier for individuals filing for expungement. And that
Ms.
bill,
Davis?
this bill will do it. Thank you.
Thank you very much. We'll go now to William Murphy, who is muted and needs to unmute himself.
Hello, everybody.
Go ahead.
I appreciate all the hard work and dedication that anybody who watches the committee proceeding is immediately struck by, and that is that you all work your butts off. So I'll be brief in recognition of how valuable everybody's time is. One of the problems with people's criminal records not being expunged is that, and I'll try not to repeat anything anybody said, is that it really keeps you from getting decent housing. It can impair your credit. It can prevent you from getting loans and credit cards and mortgages, and it can affect your insurance rates or whether you get insurance at all, whether it be health insurance or car insurance, just to name a few things that get really totally sideways when you have a record. You're always having to explain it. And even when you're not asked about it, you can bet your sweet bippy that people have enough computer savvy these days to know what your background is anyway. And so this is more than a nuisance. It's a real burden on the citizens of this country who have to constantly be deprived of things the rest of us take for granted. And to make things worse, algorithms now factor in all of these things to a greater extent than ever before. And for those of you who are not computer savvy, an algorithm is a computer program that makes judgments about people and makes determinations about their eligibility instead of a real live human being doing that. And so all of these kinds of things make job opportunities, housing, insurance, credit, a very, very difficult thing for people who have any level of a criminal record that did not result in conviction. And so this is an idea that I think we can all agree is way past due. So why don't we have it? Well, my view is that the judiciary is simply recalcitrant about it. They unfortunately haven't noticed that the traffic in our courtrooms is dramatically decreased, particularly in Baltimore City and Prince George's County. And people are not working full time in the courts like they used to pre-COVID. Now, COVID has, of course, changed everything, but just imagine what it's like to be able to have to apply for a job in these troubled times, multiplied by 5 over what would happen under normal times. And
Mr.
so
Murphy,
we've got to,
Judge, I'm sorry.
I got one last sentence.
Okay.
We have got to make the judiciary do this. We can't wait for their indecision. We can't be persuaded that it's too expensive. It's too important for so many thousands of people of Maryland. And so unless you pass a bill requiring them to do it, they're going to have an excuse every year and it'll never get done.
All right. Thank you very much. We'll hear now from David Schlussel.
Good evening. Thank you, Mr. Chair, Madam Vice Chair. My name is David Schlussel. I'm Deputy Director of the Collateral Consequences Resource Center. We conduct national research about laws providing for restoration of rights and opportunities for people with a criminal record. Our resources and reports address how jurisdictions across the country are responding to issues like expungement, voting rights, and laws limiting the consideration of criminal records in employment and licensing. I wanted to give a brief overview of the national landscape concerning automatic expungement of non-convictions, the issue addressed by HB 238. We've identified 16 states with laws providing for automatic sealing or expungement of non-conviction records to a large extent. 10 were enacted in the last 5 years. Your neighbors, New Jersey and Pennsylvania, enacted automatic expungement in 2019 and 2018, respectively. DC and Virginia are also considering it this session. Another 7 states have an expedited process at the disposition or through an administrative request. 27 states like Maryland require a traditional court petition, although Maryland, you have included automatic expungement of uncharged arrests several years ago. Research has shown that in petition-based processes, typically only a small percentage of eligible individuals obtain relief. In 2019, we put together a model law on non-conviction records with a large advisory group of prosecutors, judges, defense attorneys, state lawmakers, advocates, and other participants. And the group came to a consensus in the resulting model law, which recommends automatic expungement of non-convictions and addresses many of the technical legal issues that arise in thinking through this issue. I'd be happy to answer questions you have about national trends and how other states have addressed this issue.
Okay. Thank you very much. I think that'll conclude the first panel. I don't believe that Nicole Hansen-Mundell has been able to join us this evening so far, but we'll keep the door open just in case she is able to join us. All right, are there questions for this panel? There are no questions for this panel, so thank you all very much for presenting here today. We're going to move on to the second panel here, which will include Deborah Gardner, Ann Seacott, Jason Wright, Tim Darby, Christopher Stevenson, and let's also bring in Christopher Dews, also from JOTF, and Reverend Kobe Little. let's bring in basically the rest of the favorable witnesses, please. Do we have Deborah Gardner by any chance? I see Ann Seacott. So we'll start with Ann Seacott and then we'll make our way through the rest of that list. So Ann Seacott, please.
Thank you very much, Mr. Chairman, Madam Vice Chair, members of the committee, and thank you, Delegate Wells, for sponsoring this bill. I'm Ann Seacott, and I'm here today on behalf of the Maryland chapter of the National Council on Alcoholism and Drug Dependence, and we strongly support House Bill 238. We have advocated for many years for policies that help people who become involved with the criminal justice system, help them avoid the collateral damage caused by our failed drug policies. For people who have started their journey of recovery from substance use disorders, criminal records can create insurmountable barriers to employment and housing. Without a place to live or reliable income, it becomes incredibly difficult for people to survive, which often leads to someone reoffending or returning to alcohol and drug use. For people whose records contain non-convictions, it's simply unfair for them to struggle as they do. Making sure that non-convictions are easily removed from records will help in reducing the discrimination that follows those who have been incarcerated or been arrested and not convicted and not incarcerated. These kinds of policy changes are a necessary component to significantly improving the inequities that exist in our communities. Removing some of the barriers to success will also help people with substance use disorders maintain their recovery. We urge you to give a favorable report to House Bill 238.
Let's go to Jason Wright, please.
Chairman and distinguished members of the committee, thank you for the opportunity to testify in support of House Bill 238. My name is Jason Wright, and I'm the Workforce Development Project Paralegal at Maryland Volunteer Lawyers Service. Now, in our program, we partner with job training sites offering employment skills to those who would have otherwise not had the opportunity. And we contribute by offering legal services in addition to those other wraparound services that trainees are already receiving. As most of our clients have had some interaction with the criminal justice system, we spend the majority of our time on expungement. So it's an issue that we're well familiar with. Now, when this bill came up, I was immediately brought back to Deborah, a client of ours from Caroline Center. Caroline Center offers job skills training in the medical field, but you need a totally clean record in order to become licensed by the nursing board. Ultimately, we did a fair bit of work and got Deborah's record entirely expunged, and she was extremely grateful for our efforts. She was so grateful for the efforts that she sent me a thank you letter. It's on the board behind my desk in my office right now. I was really touched by it. But then, just as when this bill came up, I was struck by the sensation that she should not have needed to thank me. She should not have been so completely overwhelmed by this process. But instead that those charges should have been cleared automatically, as she was never even convicted in the first place. And while some may say that there's too great of a cost in order to implement this law, that cost will always be less than what Deborah had to go through in order to enroll in her program and coordinate with us throughout just to get those charges removed. And it's certainly less than the burden placed on the countless others who have not had the good luck required to interact with a program like ours, thereby losing out on that one job or that one apartment that could have been the turning point in their lives. And that's why I'm asking for you all to support House Bill 238 for automatic expungement. Thank you.
Thank you very much. Right, we'll hear now from Tim Darby.
Thank you, Chairman Clippinger and members of the committee. My name is Tim Darby, and I'm a staff attorney at Maryland Legal Aid with the Community Lawyering Initiative. We bring legal services into communities to ensure that even our most marginalized citizens have access to advocacy within our justice system. Through programs like Lawyer in the Library, Lawyer in the Schools, expungement clinics, and online Know Your Rights seminars, we reach Marylanders statewide and assist them with obtaining criminal record expungements, along with serving their other legal needs. Since 2016, we've represented over 10,000 expungement clients and filed over 50,000 expungement petitions. Marylanders who have never been convicted of a crime carry their case records as a scarlet letter, impacting the most critical aspects of their lives. We've served clients whose criminal records have damaged their abilities to obtain and keep housing and employment, despite having never been duly convicted in a court of law. Individual citizens currently have the burden of filing petitions for expungement. We regularly meet with Marylanders who have never even heard of the expungement process, much less know how to navigate it. This bill will ensure that all people will receive expungements for which they are eligible, regardless of their legal knowledge or access to an attorney. Moreover, this bill would allow low-income Marylanders to receive more free legal services from legal aid and other nonprofits. This bill will allow nonprofits to refocus more of their resources toward emerging legal issues in the wake of the COVID-19 pandemic. These critical services are needed now more than ever as we're facing looming foreclosure and eviction crises. I hope this committee will give House Bill 238 a favorable report. Thank you, Mr. Chair and members of the committee.
Thank you very much. Christopher Stevenson, please.
Thank you, Mr. Chair and members of the Judiciary Committee. My name is Christopher Stevenson, and I'm the Senior Policy Analyst with 1199 SEIU, the largest healthcare union in the nation, where we represent over 10,000 healthcare workers in Maryland. Given the amount of difficulty that Marylanders have to undergo when a police record is assigned, we support HB 238 in the attempt to provide more job opportunities and the right to live a life with dignity for residents across the state. One mistake should never automatically determine anyone's future, but for thousands of Marylanders, this is the sad reality. This reality occurs when an arrest is made and a record is mandated to follow, no matter if the person arrested is found to be innocent. Due to this, many workers are automatically turned down for job opportunities and job growth, mainly attributed to questions on job applications that relate to past legal offenses. These records are left on Maryland's case search, where many employers visit as a last step before hiring a potential employee. For this reason, we find that this bill creates a solution to this problem by automatically expunging various police records, particularly where an individual is found innocent. For our members, this legislation is of great significance because some of our members who have had past records are not able to evolve within their careers. This means they stay stagnant in their work with no opportunity to improve their lives and consequently the lives of their families. Some of our members include doctors and nurses in hospitals that have saved the lives of COVID-19 patients, as well as our staff members that work in long-term care facilities who you entrust to take care of our seniors. As we have seen before and all throughout this pandemic, our healthcare system currently faces a shortfall of workers as well as applicants, and as such, we believe that the passing of this legislation would help remedy this circumstance. For these reasons, we believe that this legislation will create the necessary structure in place to improve the overall workforce and economic equity in Maryland, and we ask respectfully for you to support HB 238.
Thank you very much. Reverend Little, Reverend Kobe Little, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. I'm Reverend Kobe Little. I represent the Maryland State Conference of the NAACP, and we're here today to ask a favorable report on House Bill 238. I want today to share a personal experience with you about why automatic expungement is important. When I was in college, a student at Johns Hopkins University, I witnessed about 10 police officers beating a man on the corner in front of a convenience store near the campus. Along with several other classmates, we stood our distance and observed. This was during the height of the Rodney King beating, and we stood our distance to observe and to let the police officers know that citizens were watching. A police officer came up to me, cussed me out, called me names, and told me to leave or he was going to arrest me. I looked to another officer and said, "Excuse me, officer, can I ask you a question?" The officer said, "Yes." And then the original officer came and said, "Boy, I'm going to show you what happens when you don't obey me." And he called the wagon around, handcuffed me, and put me in that wagon. Took me to the police station. And when I got there, the desk sergeant was regaling stories from the Vietnam War, and using racial epithets to describe a number of different nationalities. I spent the night in that jail, and when my day came for court, the assistant state's attorney found me in the lobby and tried to get me to plead guilty and to participate in a program, and told me if I didn't, otherwise I would be convicted and I would go to jail and have to serve time. I knew my rights. I knew I'd done nothing wrong. I had a lawyer. And when the case was called, when the clerk of the court called the case, you should know that that same state's attorney who attempted to have me plead guilty said, Your Honor, we have no intention of prosecuting this case. And the case was dismissed. Subsequent to that, I filed a complaint with what was then the Internal Affairs Division. And I also filed to have my record expunged. I never heard anything from the Internal Affairs Division. And to this day, my record has not been expunged. And for my personal reason, but also for the fact that this happens to thousands of people in Maryland all the time. We are over-policed, and because we're over-policed, we are over-arrested, and unfortunately, sometimes we're over-convicted, but so many people who are never convicted still have the stain of an arrest on their record. And so I urge the committee to not delay, but to take forthright action to pass this legislation favorably out of committee so that it may be passed by the full House and the Senate. Thank you and good evening.
Thank you, Reverend Little. Thank you. Are there questions for this panel? Seeing none. Thank you all very much for testifying this evening. We're now going to go to the opponents of the legislation. Steve Kroll, Joe Riley, Scott Schellenberger. Mr. Schellenberger, if you'd like to begin for 2 minutes, please. He's still connecting. We'll go to Steve or to Scott Schellenberger. All right, Mr. Schellenberger for 2 minutes, please.
Thank you so much. Ladies and gentlemen, Scott Schellenberger, State's Attorney for Baltimore County. Appreciate your time. First, let me address Reverend Kobe Little. I'm very sorry for that situation, what happened. And what I would say to Reverend Little is, I do not disagree with him that on a null pros, an acquittal, and a dismissal, those charges should be automatically expunged. And as regard to the fiscal note, that actually will lower the fiscal note tremendously, because the null pros, but particularly the dismissal and the acquittal, will happen at a relatively early stage of the proceedings, and therefore the fiscal note will be exceedingly less. The place where I have a problem is, interestingly enough, the place where Ms. Davis from the Public Defender's Office didn't say anything. When she addressed you, she said, shouldn't a null pros, dismissal, and acquittal be automatically expunged? She left out my objection, and that's the PBJ, probation before judgment. And this is exactly what I talked about the other day when we were here on House Bill 754, or actually it was earlier today, with Delegate Pippy. So the PBJ is different. There you've been found guilty, unless you pass the other one, but you've been found guilty, there's sufficient facts, and a judge has extended you the option to get probation before judgment. If you only get 1 year probation and then you expunge that immediately after the year automatically, if you get a felony charge, the felony judge, when he convicts you, will not even know about the prior assault conviction that you got the PBJ on. So I think this automatic expungement factor, while maybe appropriate in certain kinds of cases, and I still worry about the fiscal note, when you look at the issue of PBJ, you just need to cross those 3 words out, and 238 extends to Reverend Little what he needs and what people like him need, and I think it'll also be cheaper. And I see the chairman has clicked his mute off, so I will stop.
Somebody finally picked up on that. That's great. Joe Riley, please.
Thank you, Chairman Clippinger, Madam Vice Chair, distinguished members of the committee. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland State's Attorneys Association. We are asking for an unfavorable report on House Bill 238. If you heard most of the colleagues who are testifying in favor of this bill is centered around employment opportunities. Quite simply, this can all be managed by taking care of it in case search. No employer has ever called my office, or I'm not aware of any state attorney's office that has ever been called about an applicant for a job. It simply isn't in the state's attorney's purview. We are included in this bill because we are a law enforcement unit as defined in the statute in 10-101, but it's simply not something that the state's attorneys need to be doing. Pennsylvania and New Jersey were discussed in the proponents. Please look at those bills. Pennsylvania, it only applies to not guilties. And in New Jersey, state's attorneys are county attorneys, and as they're defined in New Jersey, are informational only. The court says, should this person be eligible for automatic expungement? And the state's attorney or county attorney in New Jersey says yes or no. It's the requirements that we are required to do as a state's attorney's office, still within 60 days, greatly expanding the number of cases it would apply to. It is cost prohibitive, and we simply do not have the personnel to achieve what this bill wants.
Thank you very much. We'll go now to Steve Kroll, please.
Mr. Chairman, members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association. Been prosecuting cases since 1984. For 9 years, I did expungements in Baltimore County. A couple concerns I have with the bill. Number one, it says instead it is going to be expunged if there's restitution to victim, and we are victim first oriented. Repeat, victim first oriented will not get their restitution, whether it's a STED or a PBJ. Second, there is no right to appeal from the state. So somebody who works in the clerk system is going to make a decision on automatic expungement, and we can't appeal. Once it's expunged, it's gone. No right to appeal whatsoever. And there are mistakes that are made due to the volume and the numbers that are there, and we have no right to appeal whatsoever. 882 that we talked about beforehand, that's House Bill 82, is Delegate Barron's bill. There's no reason why this bill can't be associated with Delegate Barron's bill for a summer session, task force, whatever you want to call it, in order to do it from there, and this can be included with it. And I would recommend that also. But those are just some simple things I just pointed out of the many that are in there. The judiciary has pointed out while we're asking for an unfavorable report as to House Bill 238. Thank you.
Thank you very much. Are there questions for this panel? Are there questions for this panel? Delegate Kurt Anderson, then Davis, then Conaway. Delegate Kurt Anderson.
Yeah, thank you, Mr. Chairman. First thing, I think, Mr. Riley, you testified something to the effect that no one has ever called the office of the state's attorney, but I don't think that's what our point is. Our point is that when people are looking for jobs, employers do look at records, and these records will include cases that could have been expunged had the person been aware of it, like a not guilty finding, like a dismissal, like a null pros. And in some cases, employers ask the person to bring their record with them, their CGI record with them. So why wouldn't we want to pass this bill for those folks?
Well, thank you for the question, Delegate. I'm not aware of how a civilian can get their CGIS record. You have to have a particular license to get a CGIS record. If you're talking about their printout from Maryland Case Search, as I said, this seems to be a problem with Maryland Case Search. That if you fix Maryland Case Search, so not guilties, null process, all of those things don't show up on what is publicly accessible, that seems to be what solves the problem from the proponent's point of view. It is not the state's attorneys that are getting called.
If a person goes to court and goes to a jury trial, found not guilty, or if he goes to district court and has a district case where the judge finds him not guilty, why shouldn't that be off his record that day?
As I said, I think you fix it on Case Search. And
No. My question is, why shouldn't it be off his record that day? He should have no record.
In 60 days, you are requiring the state, you're having expanding the multitude of cases by 100-fold, and you're asking us to do it in 60 days. I'm not saying it shouldn't be done. I'm just saying you cannot expect us to do it in the same amount of time that you have. Expungements have to be done within 60 days. You're not giving us any more time. You're not allowing us to hire any more personnel, and we simply cannot get it done. I agree with you that it can be, that it should be done, but we personnel, we don't have the funds. I would have to have a person dedicated to this just in Caroline County. I can only imagine what Baltimore County and Baltimore City would have to do.
And the personnel would be.
Mr. Schellenberger says five new staff totally dedicated to expunging.
And the expungement dedication in this case would be the cases that have been null prossed by the state's attorney.
Right.
So I don't think any mistake was made there, right?
Right. I'm not
Person was
saying
found-
that shouldn't be done.
person
I'm
was-
just saying
person
you
was
want it
found
done in
not
60
guilty.
days. You want it done in 60 days and at the same cost. They can't be done.
Well, what is the cost if, in fact, all of these situations, whether it's a null pros by the state's attorney, a not guilty finding by the judge, a dismissal, where does the cost come in for these things that should be automatically expunged?
Because we have to delete the entire records. We have to delete all the police reports. We have to destroy all that information.
So Delegate Anderson, if I could help, when someone's arrested, say in Baltimore County, you not only have the Baltimore County Police report that shows the arrest, but that goes out to various law enforcement officers and communities to show what the record is. So it goes to CJIS, might go to a lot of different things. On a PBJ, it's going to go to parole and probation. In my office, it's not only going to be a physical file, but it's also going to be entered into our PBK system. The judiciary is going to have it in MDEC. They're also going to have it in their Maryland Judiciary Case Search. So I think what Mr. Riley's trying to say is when you're looking at things like null pros, acquittal, and dismissal, while philosophically we agree with your concept, we just want you to understand that there are going to need to be people who are getting rid of this stuff, whether it's in a computer or whether it's a physical file, police report, or wherever it's gone. There are going to need to be people to get rid of it. So that's why I was narrowing our scope down to some smaller numbers, because the PBJ is a big number. That's going to be a bigger place where things are going to be located.
Well, I look, I appreciate your argument, and I think it's logical from your point of view. But I'll just have to say honestly to you, I think that state's attorneys' offices around the state can bear this cost a lot easier than the individuals who don't have jobs, who don't have housing, who can't get into school, which creates a much larger number, a larger fiscal number on society than the couple $100,000 that you're talking about to bring in some folks in your offices.
I would just simply say that the state's attorney's record isn't the barrier.
Right. See, that's what State's Attorney Riley is focused in on. Nobody's calling us. If my file is sitting there, that's not the problem. The problem is, sitting in the employer's office and putting that person's name in, Scott Schellenberger, into Maryland Judiciary Case Search. So that's where the effort needs to go and where the funds need to go. My office, if somebody called me and said, was Scott Schellenberger convicted and got a PBJ last week, we wouldn't answer them. So, and Delegate Anderson, we're not arguing. I'm just providing information.
Oh, no. I think if we've had arguments, and this is not really close to one of them.
I agree.
But thank you.
Delegate Deborah Davis.
Thank you, Mr. Chair. I know it's getting late, but Mr. Crawl said something I couldn't just let go. I'm with my U.S. Constitution, as I always have to do when these guys are in front of me, because they seem to read a different one than I do. And I have a question about victims first. You said it twice, Mr. Crawl. Where is that in the law? I thought we were trying to assert justice here.
We're going to balance justice with the victim's rights. Victims have rights to the Maryland Constitution. We can pull that out. I can show you where that is, Delegate Davis, if you like. That's in the Maryland Constitution, your victim rights. And when it comes to restitution, I'm going to back the victim all the time. I believe in victims' rights. I strongly believe in victims' rights.
No need to get defensive, sir.
I'm not.
No need to get defensive. I'm not. There should be a balance of justice, and that includes the person who was wrongfully arrested, who now has a record, a stain on their record, and they can't get a job. I mean, do you not see any right for the person that came before you that you did not convict?
I see their rights, and I see the rights of victims for no reason of their own have been out financially and mentally due to the result of someone's conduct. We have to balance both of those, Delegate Deborah Davis, and I encourage all of us to do that.
if you did not convict them, why are they, what does this person have to do with the victim if you didn't convict them?
No, well, my testimony was about Stetson and PBJs. If we didn't convict them, they're not guilty. My testimony was about Stetson, PBJs, and restitution.
Okay, one last question, sir, Mr. Chair. So you're balancing victims' rights with citizens' rights?
Citizens or defendants?
They are citizens.
Okay, my concern as a prosecutor is victims' rights first.
Okay.
But Delegate Davis, again, we're focusing on the PBJ and the possible stet. And with the stet, you all have made an exception that it can stay on there longer if there's drug treatment. We're merely saying you should also add in that sentence that if there's restitution, that's all. And that balances the victim's rights. On the PBJ, it's the same thing. You've actually been found guilty and there could be restitution ordered. We just want to make sure the victim is whole before the expungement. On the issue of null pros, acquittal, and dismissal, while it's a burden to the courts and us, we do not disagree with you philosophically, because you are right. They were found not guilty. So there's a line there.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in. Mr. Schellenberger, I just have a real quick question. So you said this 2 times. When a person gets a PBJ, they actually have a guilty judgment?
No, sir.
You said that 2 times, though.
No,
but you said,
I said there was a guilty finding. So
Oh,
what
this is
happens in a courtroom is I will read a statement of facts.
Delegate Anderson, would you please turn off your television? That's better.
So Delegate Conway, I may have misspoke, but let me make sure I'm clear. When we go on, say, a statement of facts in our district court, we will read the facts into evidence. The judge will say, based on those facts, I find you guilty. Now, defense counsel, tell me about this person. And then the person could be a first-time offender, could be a very minor case. And the judge will say, well, I found you guilty. I strike the finding of guilt and enter a judgment of probation before judgment. That's why it's called PBJ, because he's saying, get rid of that guilty and go back to PBJ. And that's why I'm drawing the distinction between not guilty, acquittal, dismissal, and a little bit on the stet, because in a PBJ, the judge has actually said the word guilty, but then taken it back. And I think that's an entirely appropriate thing. I'm just trying to say that's where I draw the line.
yes, I understand. I appreciate you explaining that to me. Do you think with all of your experience, the average person really understands the guilty finding, but taking it back?
Oh, absolutely. Because
Really?
the judge actually tells them in court, you may tell a job or anywhere you go that you do not have a conviction. I have heard that tens of thousands of times. They actually say to the person, and the lawyer will tell them outside, you can tell people on a job application that you don't have a conviction, because you don't in Maryland. It's PBJ. And remember, under existing law, you can get that PBJ expunged. You just got to be a good person for 3 years after the probation ends. So that's all I'm saying. We give you, if you've been a good boy and girl for 3 years, then that PBJ can be expunged. I just don't think it should be automatic as soon as the probation is over, because there could be restitution issues. And frankly, because you've been convicted, but it's been taken aback, prove to me that you're a good person.
Okay.
That's
thank
all.
you.
Yep,
Thank you so very much.
Great. Always enjoy it.
Delegate McComas.
Thank you, Mr. Chair. Just a real quick question for the prosecutors here. How soon that an activity goes on case search? Let's say I get a DWI and I get charged. Does it go on pretty much the next day?
You've been served. You've been served the charges.
Okay, so I go into court and they say, oh, McComas, I got acquitted, okay? So then how soon does that go on case search that there was an acquittal?
I haven't timed that, but I would imagine 24 to 48 hours, depending on if it was a weekend or not.
Well, I guess maybe what would be best is that there's a delay before all this stuff goes on case search. I mean, personally, I think the only reason that you need case search is if you're the lawyers and you have a special code and you get into it. So you don't have to run all over to the different courts and look at somebody's records or how many times they've had divorces or protective orders or whatever. I mean,
Delaware does that.
I mean, the thing is that's and if the employer wants it, they can hire a business that does that.
Well, that's why case search got invented, because they got tired of driving to 24 counties looking for a person's conviction, let alone if you go somewhere and move out of state. The other thing that I think would be difficult is it's fairly automated now. As soon as the commissioner starts entering this information in the internal computers that then come over to my computers that then go to the other computers. I mean, it's all very, very automated now. And honestly, Delegate McComas, people love it. I mean, I hear from people all the time about how much they love judiciary case search. So I think you'd have a pretty big backlash if somehow we, started futzing with it.
Thanks.
All right. Are there any final questions for this panel? Seeing none, we thank you all very much. And that concludes the testimony on Delegate Wells' bill, House Bill 238. We're now going to the final two bills of the evening, both of them roughly similar. House Bill 336, well, somewhat similar. House Bill 336 is what we're going to start with Delegate Ivey, and then we'll go to House Bill 1284. Delegate Ivey is going to begin with himself for 3 minutes. Colin Bilyeu, Toby Ditz, Zachary Berger, and Hannah Pfeiffer. They'll each get 2 minutes after Delegate Ivey. I'm sorry, 1 moment, please. Oh, wait. Okay, I'm being corrected by staff. Delegate Ivey, I apologize. It's going to be Delegate Acevero first, not Delegate Ivey. We'll do Delegate Acevero first. So scratch that. We're having a completely perfect day so far. All right, let's try that again. So now Delegate Acevero for 3 minutes. Francois Furstenberg, Malcolm Lizappi, Andrea Frazier, Abigail Koch. Those will be the people who will testify first. And everybody other than Delegate Acevero will get 2 minutes. So now we need Delegate Acevero, who is not yet here. In any case, we don't have either sponsor, so we need Delegate Acevero. Well, we do have some other people, and I want to keep people moving, so we're going to go ahead, and I know that if I start to say the first name, that Delegate Acevero will magically appear. So if I say Francois Furstenberg, you can go ahead and testify for 2 minutes. Well, then I guess we have to do that. We're going to go ahead and hear from Francois Furstenberg, please, for 2 minutes. Okay. Go ahead. Take yourself. There you go.
Okay. Hi. Thank you for having me tonight. So my name is Francois Furstenberg, and I'm a professor of history at Johns Hopkins University. I live in Baltimore. I live in Butchers Hill. I live right in Delegate Clippinger's district, in fact. And I'm here to testify in support of this bill. And there are lots of reasons to support this bill, but there's one that I would like to focus on right here tonight, and given the limited amount of time I have, and that's to ask, who Johns Hopkins has been speaking for when they have made this push. I know they've thrown all their political muscle behind this bill, and you know they're the largest employer in the state, and they have lots of muscle. But I must ask on whose behalf they're pushing this. It's not on behalf of the students who staged a sit-in to oppose the bill, to oppose the Johns Hopkins Police Department. It's not on behalf of the faculty. The faculty senates across the university have overwhelmingly opposed and voted against this bill, the Johns Hopkins Police Department. It's not on behalf of the staff. It's not on behalf of the local neighborhoods or on behalf of those who will be policed by the new police force. The decision came from on high. It came from the president and the board of trustees, and it was made long before there was any consultation with anybody, including the delegates or any neighborhood people or anyone in the university. So I want to ask who this decision represents and what the constituency is for this decision. The president of the university has served more than 10 years. That's a long time for a university president. He's well past his expiration date and he'll soon be gone. I feel confident in saying that. He and his wife recently bought a $5.2 million house in Santa Barbara, California, and they'll leave Baltimore, I'm fairly confident, the second that he's no longer president of Johns Hopkins. The board of trustees is composed of 36 people, and as far as I can tell, only 6 of them live in Baltimore. One of them lives in Bethesda. Most of those people on the board of trustees live in New York City, in California, in London, and they know nothing about Maryland or about Baltimore. Their only constituency is global capital. Michael Bloomberg is the largest and most prominent alumnus of Johns Hopkins, and he was in the State House in Annapolis lobbying for the bill. He's best known for his stop and frisk policies as mayor of New York City, policies that were unconstitutional and that violated the civil rights of millions of New Yorkers. So I have to wonder.
Mr. Furstenberg, please, if you'd please wrap up.
Okay. So they want this, not Baltimoreans, and not the communities that will be policed. So I hope that I speak as somebody who will actually be in Baltimore long after the president and the board of trustees have rotated off. And take it from me, you'll be doing a favor to Johns Hopkins University if you vote for this bill. Thank you very much.
All right. Thank you very much. We're going to give Delegate Acevedo exactly, I think, about 5 to 10 seconds to catch his breath as he is coming into the room. There he is. That's fine. We will now give him his 3 minutes. We've only had one witness testify, so you should be fine. All right, Delegate Acevedo for 3 minutes, please.
Thank you, Mr. Chair, members of the House Judiciary Committee. For the record, Delegate Gabriel Acevedo here to present House Bill 1284, which repeals the Johns Hopkins University Police Department. For the benefit of this committee, this is a piece of legislation that the General Assembly passed a couple of sessions ago that I voted against for a number of reasons, but really at the heart of it, what this bill and what we would be doing by repealing the Johns Hopkins Police Department or private police force is affirming the belief that policing is a public function and that there is absolutely no advantage in privatizing an inherently public function as policing. As we know that Black communities across the United States are the most over-policed communities in America. And when we talk about institutions that have a really checkered history, not just with the community, but particularly with Black folks, and really providing a private institution with the ability to police and to have its own private police force, in addition to having special privileges for this private police force under the LEOBR, with little accountability, that we're really setting a dangerous precedent that I don't think we should be allowing as a General Assembly. And I indicated some of those concerns when the bill had been introduced a couple of sessions ago. And really what this is indicating is that we want to ensure that policing not only remains a public function, but that communities have oversight and they have a say in the way public safety is administered in their communities. And so while Hopkins has moved forward with its plans to create the police department, I know that there are some members of the community who have expressed their opposition and stand against it. And so we as legislators have an opportunity to not just ensure that we're creating a greater accountability and community oversight, but we can also set up a really positive precedent, one that doesn't say to private institutions that it is okay for you to have a private police force with little accountability that will be policing communities, that will have the special privileges and procedural protections afforded under the Law Enforcement Officers' Bill of Rights, but very little accountability. And this bill calls for the repeal of that police force, and that it is neither needed nor wanted, but it also calls for us to affirm that policing is a public function, and that there's no reason for us to privatize and to create an unaccountable system that the public has already expressed concerns about. Given what we know about the relationship between race and policing, bringing more police to an already heavily policed and patrol area serves no substantive safety benefit, and it only further places marginalized members of the community in an uncomfortable position at best and an unsafe position at worst. So for these reasons, colleagues, I urge a favorable report on House Bill 1284 that ensures that we aren't over-policing communities, because what we know, particularly
Delegate
in Black and
Acevedo.
brown communities, that whenever we over-police, that leads to over-criminalization. Thank you, Mr. Chair.
Thank you, Delegate Acevedo. We'll go now back to 2 minutes. Malcolm Lizapi. Mr. Lizapi is connecting to audio. Well, Andrea Frazier appears to be available. We'll go to Dr. Andrea Frazier, please. There you go, 2 minutes.
Hello to everyone watching. Many of us have met before. If not, it's nice to meet you. My name is Dr. Andrea Fraser. I have a PhD in public health and engineering from Johns Hopkins University. I'm a resident of District 43 myself, and generationally, many generations of my family have lived here in Baltimore City. I'm currently providing immediate pandemic and crisis relief in Baltimore City and the surrounding area. I've already submitted logical public health and engineering arguments on the last Johns Hopkins bills and the dangers of Hopkins policing, specifically referencing the American Public Health Association's statement on police violence as a public health crisis. Many of you went against that and voted for the JHU private police bill with amendments. My testimony today is a formal request for official numbers and calls and emails on this current bill and all previous JHU police force bills, the previous 2 times and these 2 included, to be sent to jhusitin2019@gmail.com. That's JHUSITIN 2019@gmail.com. This request is directed at the chair and the entire committee. We've also sent an email to the committee and individual emails with a report of violent officers, a video of an officer assaulting a student, numerous posts on social media about running over crowds of people posted by Hopkins security officers, numerous other offensive comments. These were reported to Hopkins with no sufficient answer. And we would like a response from the committee as we send the email, as well as a record of the calls and reports in favor or support of previous bills. In addition to the documents requested, I want to bring up a comment from Delegate McComas on a previous hearing saying that the blood of lives lost would be on our hands for delaying the JHUPD. Well, Hopkins is now calling for a 2-year delay. They refuse to hold public meetings on the current security and upcoming JHU.
Dr. Frazier? Dr. Frazier? Her time was nearly up anyway. Hopefully she will be back in time to take questions. We go now, I understand Abigail Cock is not there. I think that is the first panel. So, oh, I'm sorry. No, that's right. That's the first panel. All right, let's go ahead and take questions for the first panel. Are there questions for the panel? Delegate Arakan.
Thank you, Mr. Chair, and thank you, Delegate Acevedo. Always good to see you in our committee at a late hour. Smiling as always. So the first question I have a couple, but the first one I have is for you. It was a super big comprehensive bill. It had like the police force in it. It had a bunch of like like monetary things for the community organizations. It's such a complicated bill, and there's so much like repeal stuff in it. Is it repealing the entire bill, or are we leaving parts of it in there? Is the money part still in there? What are we doing with that?
So this is a repeal of the Johns Hopkins University Police Department. It is a straight repeal, and that is pretty much what the bill accomplishes. It ensures that this institution doesn't have not only the police force, but the authority to police neighboring environs. And I'll also add just, the danger of that being when I say a precedent is that Johns Hopkins University has campuses and offices, as we know, across our state and across the world. And it's just a matter of amending the bill and adding a jurisdiction in order for us to see just an expansion of this private policing. And so that just does a full repeal.
Okay, but there's nothing in here about the appropriations piece of it that's repealed. So that's still going to go forward with the mandated spending from Johns Hopkins?
Well, as I know right now, it's on pause. So I don't think anything's going forward.
I don't think, was the money tied to the police force actually being enacted? I don't think so. I think it was just a straight mandate for spending for some community organizations, right? I think I don't think that they had to actually become active in their police force for the money part to start rolling. I'm pretty sure that ball is already rolling. So this bill doesn't touch on that. It only touches on the police force.
This has to do with the police department, and I wouldn't want to comment on the monetary piece of it. What we address specifically with this bill is the private police force and the authority in order to police certain communities and environs.
Okay, because that was that took us a long time to craft that, and it was a bunch of community people coming together, and money was involved and supporting community groups. So it's a little odd to have the money piece still going that they had agreed to, but then being like, just kidding, rug out. You know what I mean? It's a little weird, but okay. And I have another question. I don't know. Was Dr. Frazier able to come back?
I'm here. Hello.
Yeah. Hi, doctor. So you mentioned that you had videos of police officers hurting people on campus already, but the police force has not even been constituted yet. So it can't be the ones that we authorized. It has to be something else. Certainly it's not the ones that were involved in our bill.
So what we're describing here is the same Hopkins security entity is already having significant concerns, significant problems with officers being abusive. There's the video that I believe was sent to you. You can watch of an officer raising his hand and literally punching a student for filming him. And there's just numerous concerns here. So I understand it's not the authority that you gave them, but these are the people that you're giving authority to. And there's already a clear concern because there are no community meetings at all. Whenever we ask for, as students, to bring community members into meetings with administrators, they completely deny the meeting. So they are actually refusing to engage with the people most affected by this bill. So, so what would that look like with an armed police force? And where are there going to be community meetings that would start then in 2 years? Why don't they have community meetings now? Why is there such a disregard for specifically community members' opinions, let alone the students and faculty that have already spoken out against this?
Okay, well, that's the community meetings. I think, I'm not sure that I think they probably thought they were connected to the actual police force, which they don't have yet. But you do understand that the people right now that are policing you would just be the same people in perpetuity? You wouldn't, if this bill is repealed, you're not getting a new crop of people. You're actually keeping the ones right now that you're saying that is a problem.
Right.
So you're not really changing anything.
That's correct. And we're also drawing to your attention that we've been requesting to engage with the current situations, the current concerns we have, and we've been disregarded completely. So that's only worse evidence for what's about to happen.
Okay. And Mr. Furstenberg, can I just touch on some of your comments for a moment if you're still here? I don't know if you're here. Oh, there you are. Yeah. Hi there, Professor. So I think that you mentioned that you're not sure who was really behind this, and I haven't gotten a full picture from Hopkins. I haven't really reached out to them to ask them this, but I have talked to my friends who work in the hospitals, and they are overwhelmingly in support of this. It is unbelievable. Now, I've also talked to my friends who are professors who are not. So I think there is certainly two different camps, and I don't know if you have talked to some of the people that are, the nursing staff and some of the clinical specialists there. And I've also talked to patients, and I was a patient, and I'm not a patient anymore because I don't feel safe going there. So I know there are people that really want to feel safe going to Hopkins and that don't, and that want this. So I'm not sure if maybe you guys on the university side just didn't have an opportunity to connect with those people. Has there been any sort of communication that you've had with other people who may have wanted to have this police force happen? Have you talked to anybody?
I think those are a series of very legitimate points and very legitimate questions, and there are divided opinions about the police force. I mean, my sense is that there are severe, like real security concerns along the lines of the ones you're describing. Some by patients and some by staff who work in the hospital. I think that the question that I've always puzzled over is whether a police force, whether an armed police force, which is sort of accountable to Johns Hopkins University, is the best way to address those security concerns. I mean, the thing that I've never quite been able to understand is this force will be limited to 100 police officers spread out across 3 campuses, Homewood and the hospital and the Peabody School. And that's 24 hours a day, 7 days a week. I mean, you just do the math and you're talking about a tiny handful of armed officers. And, as a response to, security concerns, that strikes me as not a very serious response. So what is it fundamentally about? I've wondered for a long time, what is this fundamentally about? And when you ask the university administration, they don't really have an answer. They say, well, our peers do this, like University of Pennsylvania has one, Harvard has one, we should have one too. And I think there are many other ways to address the security concerns that staff have and that patients have that would be quite responsive. And actually, you were asking earlier about the money that's going to these community groups. I mean, actually, that money is much better spent addressing security concerns than one that's going forward. In fact, I would be quite happy if you stripped the right of an armed police department, but asked Hopkins to pay money to address these security concerns through other much more productive ways. That you would get a lot more bang for your buck in those ways. And we have some of the world's foremost experts on public health measures, on addressing security issues as public health measures that are much more effective, that have much better outcomes than arming police officers. And in response to the questions you were asking, Dr. Fraser, I mean, I think the concern is not that we're going to be stuck with the same people and we'd like to upgrade somehow or something like that. It's that you already have these very fraught encounters, right? And you already hear a lot of reports of African-American faculty, African-American students, African-American staff being, having really uncomfortable and unpleasant and scary encounters with unarmed officers. And I think the question becomes, how does that change their experience when those officers are now armed? And that's a very scary prospect for many people. So there are some people who will, I think, feel more comfortable by the presence, the sort of symbolic presence of a handful of armed officers around the campus. But I think there are many other people who will feel quite scared by that. And the question is, are the security concerns that would be appeased by the people who would feel more comfortable, do they outweigh the genuine security concerns of people, mostly African-American people, who would feel quite scared and less safe by the presence of armed police officers on their campuses and on their workplaces? And so I think those are some of the balances you have to sort of weigh.
We did hear this, the last test, the last bill, when we worked this bill before, we did hear very similar things. But the bill itself and this bill itself doesn't impact armed police officers being on campus, because what they do instead, if they don't have their own force, is they simply have Baltimore City police officers armed, and they already have that. When I go to Hopkins, when I used to go there for my child, I walked in and there's always armed police officers. So maybe they don't have that all the time in your face on the university side, But at the hospital side, where it's desperately needed, they already have that. And this bill, win or lose, isn't going to change that. And the funding piece, I'm not sure if I was clear. The funding piece wasn't funding the police force. That was totally separate. What the legislature told Hopkins was that if you'd like to have a police force, we're fine with that, but you have to invest in the community. And so we meandered it. They spent millions and millions of dollars on the community so that they could both have the police force and they could have an investment in the community. So we're now saying under this bill, nope, you can't have the police force. Yep, go ahead, and we're now still going to mandate you to spend millions and millions and millions of dollars that you agreed to. That is the funding piece that I think I was concerned about. But
I understand that completely, and I mean that would feel like that would seem like a bait and switch, in a sense.
Very much so, yes.
But I guess my point was I think that what you're going to find is that community funding will have a much better security payoff than an armed police force, and it will be a lot cheaper too. An armed police force will cost hundreds of millions of dollars.
Well, y'all are sitting on a lot of money over there. So
yes, we are. Yes, we are.
Thank you very much, guys.
Can I just respond to your question about the Baltimore City police officers? I mean, I think
very,
you're right,
very quickly, if you'd like to respond to that.
Delegate Erica makes a really good point. I mean, there will be Baltimore City police officers, and there will always be a requirement. I mean, I hope. I mean, unfortunately, sadly, there will always be a requirement for recourse to armed police officers, right? The question is, when there's a fraught encounter with one of those police officers, who are they accountable to, right? Who are you as a citizen going to go to? Are you going to go to the employer who employs those police officers? Or are you going to go to the Baltimore City Police Department, to the Maryland State Legislature that oversees a publicly funded public police department versus a private? Do you see the difference? I think that's a really meaningful difference for a lot of people.
I see the theoretical difference, but we actually crafted the bill so we could address exactly that concern. That's why we included so many pieces about community oversight committees and all the things that we're literally crafting right now for our statewide police reform bill were beta tested in our JHU bill. They have everything that we're considering putting into our statewide policy. So I'm curious. I mean, I maybe people haven't really read the bill. They just were so emotionally reactive to the concept of it that they actually didn't read what was in it, because it's like the beta test for what we're trying to take statewide now. So I think that maybe that part was just sort of skipped over, but the chairman's indulged me too much. Thank you, Mr. Chair.
May I just?
I'm sorry. There are two more people who want to ask questions now. I want to get to those questions and I want to keep moving.
Okay, well, I'd like to call
Delegate Griffith. We'll go to Delegate Griffith and then we'll go to Delegate McComas. Delegate Griffith.
Thank you, Mr. Chair. And I have a question for each person on the panel. I'd like to start with Mr. Furstenberg, and thank you for being here today. And if I have a little noise with my kids in the background, I apologize. It's that time of night. One of the points that was made during the testimony was the issue with over-policing. However, you made a point that this would be a very small police force, 24 hours a day, only 100 individuals. So I guess my question is this over-policing, or is this a very small police force for the campus?
I think that the university sees this as a foot in the door. I think they see this as an opportunity to begin.
Oh, no, I'm sorry, sir. With all due respect, I'd like to know what you think about it, please. I know you don't university. I'm curious what your opinion is.
I think this is going to be a massively expensive police force that's going to provide very little security benefit. I think there are many cheaper ways of getting much more security benefit relative to the proposal that's on the table. And it's never been clear to me. I mean, I think it's never been clear to me why they've gone this route versus a whole series of other routes that have much better research behind them.
Why do you think this would not provide much security benefit specifically?
Well, because as I say, I mean, I think if there were actually some incident, I mean, I think the idea is that, having armed police officers patrolling is somehow going to reduce the incidence of muggings or something else like that. But, you call police officers after something happens, not before. And, you're going to end up with armed police officers showing up to a mugging after it's happened or something like that. I mean,
so you don't believe in the history of law enforcement and best practices in policing that patrol and presence creates deterrence?
Yeah, I think those issues are under heated debate right now, sort of nationally, and the question of whether policing as the kind of aggressive policing that I think you might be referring to is in fact a deterrent to crime, or whether it actually does more violation of civil rights than.
I didn't say aggressive policing. I just said presence. I didn't say investigation or even proactive policing. I was just saying presence.
Yeah, well, I mean, I have nothing against the presence of unarmed security officers. I think it becomes really quite dangerous when you're talking about armed police officers.
Sure. Thank you very much. I don't mean to cut you off. I just have a couple more questions. I know I want to respect everybody's time. So for Dr. Frazier, you had discussed talking about the current incidents that you're speaking to with the current security force that's in place. Do you feel that having properly trained officers who are held accountable at a higher level with proper training and having go through the academy, et cetera, would provide a better experience than security guards?
Thank you for your question. So as Delegate Erickson stated, there are numerous levels of police officers already on campus in the hospital, whether it's Hopkins security, they have paid neighborhood security from some of the benefits districts. There's off-duty police officers that are already in uniform, driving around in the cars. So my question is, what level of training are they not able to access that it currently exists? So it's also been discussed or in a more public health sense that the number of trainings wearing body-worn cameras, if you refer to the American Public Health Association's statement on police violence as a public health concern, it's not about more trainings. It's about, first of all, the fact that public safety and security needs to be driven by communities, has to be driven by the people that are being.
I don't mean to interrupt. Can I ask one question? You mentioned something that caught my ear.
Sure.
You said there's local communities, neighborhoods have their own security, paid security.
So currently, there's something called the Charleston Village Benefits District. They have something called Wolf Security. If you go down over east by the hospital, there's another.
So if the communities don't want more security, why are they paying for it themselves?
Because neighborhood associations.
Part of the testimony was local communities don't want more security, yet they're already paying for it.
It's not that people don't want more security. It's the fact that there's already, in my neighborhood, there's almost an unarmed security officer on almost every block. So now during at nighttime, the security officers that they're paying are already armed. The ones in the daytime wanted to be armed, and we just voted to say that we don't think that's necessary. So there's lots of levels to that. And then
Mr. Furstenberg just testified that having more presence wasn't necessarily going to provide better security. So
right.
You're testifying to the fact that in direct opposition to what has been testified to, that the local communities don't want more security, but local communities are paying for more security. You had mentioned about having, Mr. Furstenberg had mentioned about the presence wouldn't be a deterrent. You're saying it is a deterrent. So I'm just confused on, is it a deterrent, is it not a deterrent? Security, do we not want security? If the local communities are paying for security, it feels like the community does want security.
So we want to get away from what we're feeling and stick to evaluation, you know what I mean? So let's evaluate how effective Hopkins current security is, not only on crime, but also on how the community feels. Let's evaluate how all the numerous other security methods that are in place are working for the community. And if and there's this Charles Village Benefit District that I mentioned is currently looking for a new head of security that basically delegates for the neighborhood. And it's very contentious in the neighborhood now because half the neighborhood wants someone that is more trained in mental health, public health, community oriented things. And I wouldn't even say half, excuse me, but there is discussion going on now if this person should be a trained police officer or not. So what I'm mentioning is that there's many levels to this. I think that Hopkins is getting a lot more say in what's going on in the community than a lot of these other places.
And sorry, just one more question. I'm trying to speed through this, so I'm very sorry. I don't mean to rush you, Dr. Frazier. You mentioned about the effectiveness of the security at Johns Hopkins providing security. Can you define that for me? You feel they're not effective?
So if you look at they're required by the Clery Act to put out reports on, the number of interactions they're having, number of reports, et cetera. You could see that the reported sexual assaults and underage drinking are very, very high. They're some of the highest reported crimes to security. From, as I mentioned, the former head of the Charles Village Benefits District, that his name is Tony. He would always come to the neighborhood associations and report on crimes in the neighborhood. His reports have consistently detailed that violent offenses are going down in our neighborhood. And that was when Hopkins was putting out lobbying for the bill last time. So since that time, from my understanding, the trends have been going down with the current force. Again, the highest crimes are sexual assault and underage drinking. And with the current coronavirus pandemic, it's only getting worse in our neighborhood because there are tons of reported parties that are going unstopped, unchecked. And the current outbreak on campus is like over 900 people at Hopkins. So it's
what I feel like is the security. The police force hasn't been rolled out yet, but you have security in place, you have local security in place, you have a greater presence, and things are progressing from what you're saying. So
it's correlated, but I don't think that.
I just don't see how giving. And talk about one of the neighborhoods already trying to upgrade and invest in better, more qualified personnel. I just don't see how having more qualified law enforcement in the community that's clearly wanted by the community couldn't be of benefit. And we've already established this testimony that the neighborhoods want it. The neighborhoods are paying for it for themselves.
The neighborhood associations, that's a little bit different.
Right. And there's one last question. And thank you, Mr. Chairman, for being so gracious. One last question for Delegate Acevedo, I'm sorry. Sorry, it's late.
Delegate is returned.
my question for you, Delegate, is it kind of followed up to Delegate Erickson's question regarding the money committed by the Johns Hopkins University to the community. I know the bill just focuses on repealing the law enforcement, but do you think it's important to consider the unintended consequences to the community at large of the support by repealing this?
I think what we do is we throw around this term reimagining public safety a lot. And what it must mean is transparency, community oversight, and control over the way public safety is administered in any community. And that's not a radical idea. In fact, HOAs do it. And I think when we look at the idea of Johns Hopkins University and this private police force, it flies in the face of transparency. It flies in the face of real community oversight and control over the way public safety is administered. I know there was some discussion about over-policing, and I would invite folks to take a look at the data, not just nationally, but right here in Maryland. And the very area that we are discussing, Johns Hopkins having the authority to police, is already over-policed itself. So by adding additional personnel, what we know, and you know, this is not according to me, but we could just look at the history of over-policing in America. When we have over-policing, what comes with that is over-criminalization. And the people who are going to be over-criminalized look certainly like myself. And what that means then is that the very issue, the trust that we're trying to build, we won't be able to accomplish that because people will literally be feeling as if they're being over-policed. And I think there are ways that we could accomplish public safety through investment. And if Johns Hopkins University is interested in that, and we appreciate that interest, then we could invest in the evidence-based solutions, right? And that money can be used to ensure that we are building safe neighborhoods. But safety doesn't always require having armed police present and patrolling neighborhoods.
Sure. Well, I mean, just thank you for answering the question, but the specific question I asked was, if you repeal this, it ties to that. This bill doesn't change what they're going to do. This bill repeals it altogether and therefore repeals that funding. So shouldn't you consider that before considering an outright repeal?
I think we should have discussions about the funding, but I think the funding that you all are talking about, the commitment that JHU has made to the community, that has to be an ongoing commitment. Johns Hopkins University has a very checkered history with the city of Baltimore and with Black Baltimoreans.
Sure.
So I mean that the commitment.
But once again, that's not my question. My question is very specific. Should we consider, before we consider a blanket repeal, consider the impact of potentially losing that funding for the communities in the area? Shouldn't we maybe take a step back and, if we want to make some improvements on this, should we just throw the baby out with the bathwater, or should we, be a little more deliberate with this?
I think we should be listening to the community and what they would like to see. If Johns Hopkins is making that investment, and if they're serious about investing in the community, regardless of whether they have their own private police force or not, that commitment and that kind of a money should still be there. But we should be listening to the community and impacted folks more than anyone else. And I think what we've heard this evening, not just from faculty, not just from activists from the community, is that they don't want this and they'd like other safety models. And for me, and I've said this on the floor, when this came to the floor, I think it is a dangerous precedent because Johns Hopkins does have campuses, universities, et cetera, across our state and country, across our state and country. And what this allows for, again, is the expansion of private policing to other areas. I know that the bill doesn't deal with that, but it's the precedent. And I think everyone should keep that in mind.
All right, thank you, Delegate Griffith. Committee, there are a lot of questions. There are a lot of people who have questions. I've hesitated before setting a clock for committee members to kind of wrap up your questions, but I'm going to start nudging you at about 5 minutes in and stopping you not too much longer after there. So I'd like the questions to be pointed and addressed to specific people, please. Delegate McComas, then the vice chair, then Grammer. Delegate McComas.
Thank you, Mr. Chair. It used to be that Gilman Hall was open till midnight. Is it open 24 hours now? Gilman Hall?
Probably, even though it's a pandemic.
Reading room?
Probably, even though it's a pandemic.
Okay, but before the pandemic, was it open 24 hours or 20 or?
Probably still open, even though it's a pandemic.
Okay, and the library, Eisenhower Library, was open till 12 midnight or longer?
It's possible.
Yes.
It's possible.
Okay, and is it also possible that you have the chemistry department, the biology department, and then you have the earth and planetary sciences also on the Homewood campus? Is that fair to say?
Yes.
Okay, and so probably there's a lot of lab work, at least in the chemistry and the biology department. And then I guess you've got your mechanical engineering too. They've got lab work. And is it not fair to say that a lot of people don't get going with their labs until like late at night?
Yep, that's definitely true.
So you've got people walking around at all hours of the night. And so it's a very porous campus, right? Anybody from the street can walk onto the campus. Like if I wanted to go there and walk a dog or whatever, and I don't even live there, I could go ahead and do that, correct? In other words, I don't have to there's no gate, there's nobody that monitors, there's no like, what do I want to say? There's no wall. There's nothing that insulates the campus, and you can get into that campus on all kinds of different sidewalks, roads, and so it's really easy to get onto the campus. So my question is wouldn't students and wouldn't the faculty feel much safer if you've got officers that kind of know the students, that know the campus, that are familiar with it? If there's a problem on the campus, then if you have to get somebody from the northern precinct or something to come onto the campus because there's a major problem and they don't know Gilman Hall, they don't know, let's say, Clark House, or they don't know where the mess hall is to eat. Isn't that fair to say that it would be better having people that are very familiar with the campus and that work there all the time and kind of have a feel for the community and a feel for the campus and the students, so that if there is something wrong intuitively, they would know it was wrong? Is that fair to say?
it may or may not be fair to say, but this bill is a lot further than that, I think. And also, if you want to talk about what the students in fact would want, I think we've already spoken on that. And this feels like a bit of more of like a, to be honest, like academic, what would or wouldn't work when the community has already spoken. So there's already off-duty police officers intermixed in the security. There's county sheriffs, there's all sorts of people intermixed. I don't think that it would make much of a difference. What we're talking about is that, do these officers have guns? And are they
Intermixed, though, is not somebody that this is their main job and they really get to know the campus.
And we've already said we would not feel safer or comfortable with that. I think
well,
75%
you're not but the point is that students usually are only there for 4 years and then they move on elsewhere. Yeah. They're going to go to California, or they're going to go to New York, or they're going to go to Italy, or they're going to go elsewhere to finish off their education, right? So they're just passing through.
It depends, but continue.
Yeah, well, yeah. Okay, thank you. Thank you, Mr. Chair.
Thank you. The Vice Chair.
Thank you, Mr. Chair. My first couple of questions are for Delegate Acevero and then for the professor. Delegate Acevero. Is he here? Okay. My first question is, did you run this past the city delegation? Because the city delegation requested this legislation. I recall the late Congressman Cummings testifying in front of the delegation requesting this legislation. So does the city support repealing this legislation?
So this bill is a bill that we worked on, as I said, with advocates and impacted communities. And whenever we
does the delegation support withdrawing it?
Whenever it's an issue of public safety, it's impacted communities.
Delegate Acevero, does the city delegation support withdrawing this piece of legislation?
I can't speak to that, but I know impacted communities certainly support the bill.
Okay, so usually this was a huge issue. Everyone who was here knows that. And it took up a significant amount of time, and the delegation asked for it, which is why it was before us. So I would imagine if they wanted to repeal it, we would have a letter from them. My next question is, what would happen so the bill states that for fiscal years 2021, 22, 23, and 24, there will be $3.5 million for the local management board for Baltimore City for the Baltimore Children and Youth Fund, $1 million for the Baltimore City Youth Works Summer Jobs Program, and that's in addition to monies that they already received. So is that part being repealed as well? So there will be no money for the Baltimore Children and Youth Fund, no money for the City Youth Works Program. Is that being repealed under this piece of legislation?
As I've said earlier, this bill deals with Johns Hopkins University private police force and the police.
Does your bill repeal the entirety of what we passed? And what we passed, this money was tied to that. So you're repealing this money as well.
The bill repeals the Johns Hopkins Private Police Department. Yes.
Okay, so we can ask our council then if this money is being repealed as well, because I think it is, and the committee deserves to know that, which is why this would have to go before the city delegation, because we are essentially taking $3.5 million from Baltimore Children and Youth, $1 million from their City Youth Works program, we would be taking away from them. Are you aware that this also repeals the cadet program, the cadet apprenticeship program, which requires recruitment of young people in the community to work with the police, to be recruited so that folks have a great relationship with the police. They want to work for the police and police their own communities in Baltimore, stay, live, and work there. So that would be repealed as well under your legislation. Isn't that correct?
As I've said, the bill deals with Johns Hopkins private police force.
But this was all in the bill, so that would be repealed as well. The members who weren't here need to get a full understanding, because this legislation passed 94-42 and in the Senate 43-2. So we need to have a clear picture of everything that's going on. My next question is for Professor Furstenberg. are you aware that this legislation included an accountability board? So essentially a citizen oversight board, which I think someone mentioned already. We've been going through police reform here in the General Assembly. And I've had the honor of chairing that work group. And one of the main things we're doing to create transparency are citizen participations, like on this accountability board. Are you aware that that would be repealed as well? And so you would have no citizen oversight or accountability. You would be left with what you have right now. Were you aware of that?
Yeah, I mean, in my opinion, we would no longer need an accountability board if we remove the Johns Hopkins Police Department, because we'd just be dealing with.
So in the state of Maryland, along with the entire country, we are going through police reform and accountability. And so a huge piece of that Delegate Acevedo already mentioned is transparency. And to create that transparency, part of the legislation that's being proposed that hopefully will be shepherded through includes civilian participation at every levels, which is not happening right now. And so if this is repealed, it will not happen in the Johns Hopkins community at all. So I wanted to know if you were aware of that.
So Delegate Atterbury, if I can.
I was asking Professor Furstenberg a question.
Yes. So as I say, I think someone earlier referred to this as a sort of beta testing of and the university president has called this. He said that this would be a model police force for the nation. And I mean, while I don't doubt his sincerity, I think it's a little bit illusory to imagine that Johns Hopkins University, which does a lot of other things, is going to be able to create a model police department for the nation. I think that
so
the
my
major
question
problem
was, I just really only asked if you knew that there was an accountability board.
I did. The accountability board was toothless. It was the entirety, the virtual entirety of that staff, with a handful of exceptions. The vast majority was appointed by the university itself. In other words, the university appointed the members of its own accountability board, and that is not a model we want to roll out for the nation. You're the state legislature. You can roll out much better models.
So one of the things.
Wait. We're going to do one at a time. This line of questioning has been going on for three or 4 minutes. If we could, a couple more questions, and then we're going to move on. The Vice Chair.
Thanks. I'm trying not to be as long as Delegate Griffith was. One of the things that that in the reform, which I would imagine if the Johns Hopkins police and all the monies and the cadet program and the community policing component of this, if that was kept, and they had an MOU with the police department, I would imagine they would be subject to all of the same reforms that we are poised to pass this General Assembly, which would change how they make up those policing, how they appoint members to the accountability board. So I disagree with that. My last question is, are you aware, and this is because there's been a lot of talk of the community has spoken, the community has spoken, the community has spoken. We had a lot of community members who wanted this, who came out in support of this. Not only the Baltimore City delegation came out and supported this, we had a lot of letters written, we had a lot of emails, calls and stuff. So, and folks come testify. So were you aware of that? Professor?
I think that you're asking me. I mean, I live in the community. You're gonna get diverse voices from the community, right? I live in the community. I live in one of the communities that would be policed by this
right, but
force,
I'm saying, were you aware that there were people that came out to support it? Because
yes, of course.
Okay, because you all are testifying the community has spoken. You guys are testifying that the community has spoken as if they spoke in one voice, and that's not the case. There was a debate.
Yeah.
That's all.
No, I apologize. I didn't mean to suggest there was unanimity of opinion on this question.
Okay. Thank you. Thank you, Mr. Chair.
Thank you. The chat is something that we effectively have a rule that we try to not have witnesses talk over to each other, and that would include the chat being used during witness testimony. So we're going to disengage the chat at this point for that reason. We're going to go to Delegate Grammer, then Delegate Anderson. Delegate Grammer.
Thank you, Mr. Chair. Delegate Acevedo, everybody, good to see you. I hope you're doing well. I'm also not going to take as long as Delegate Griffith. Delegate Acevedo, you said we should listen to impacted communities, and I agree with that. Gonzalez did a poll in 2019 in Baltimore City, and 83% of the respondents said they were dissatisfied with Baltimore City's attempts to reduce crime. I mean, we're all aware we've got massive issues there. And in the last election, there was an exit poll, the presidential, there was an exit poll given to voters in the city, and the #1 issue was crime and public safety. So if your argument here is that we should listen to the community, do you feel you speak for the community surrounding Johns Hopkins, who, like the vice chair said, did support this bill? Do you think you speak for them in saying we want to repeal this police force?
So I think we really need to examine what safety means. As I said earlier, if safety means an armed person patrolling your community, then that's your definition of that. But there are communities that have different definitions of safety. And yes, crime is a concern, and folks have concerns about that. But that doesn't necessarily mean or correlate with more people wanting more police on their streets or to be over-policed. There are a number of studies that have been put out there, body of work, as I'm sure you know, Delegate Graham, about how we can reduce crime. That doesn't necessarily include having armed police or more police or over-policing of communities. As I said, there's a direct correlation between over-policing and over-criminalization. And so I just don't think that will get us to safety. But also when we talk about accountability, because people talk about accountability boards, this accountability board, as we've seen, whether it's a board appointed by, Johns Hopkins, or even if it means having civilians on that board, it doesn't necessarily mean that there will be transparency or control. Baltimore City has a civilian review board right now. That doesn't necessarily mean that they have subpoena powers. That doesn't necessarily mean that they have control over how public safety is administered. So having a police accountability board doesn't necessarily equate with that. But in terms of safety, I just don't think armed police is always the answer to that. If safety is a concern, then we really need to address the root causes of that.
I think you got some good points there, but I'll reassert the question. Do you think you speak for the surrounding communities when you say they want this repealed?
I think I speak for Black communities that are over-policed in America. That data continues to show is a serious problem, and over-policing leads to over-criminalization, which is also a serious issue in communities that are predominantly Black.
And that leads me to my next question. Great segue. You talk about over-policing. And I think Martin O'Malley really did a terrible job and a terrible disservice to the entire city. He was basically snatching people off street corners. With that said, there is an absolute shortage of police everywhere. In my precinct where I live, I have 17 police during the day and 21 during the night for like several hundred square mile area. And that's the county. The city is massively understaffed. And we hear in the news every month, especially during the summer when it gets busy, that police are basically hopping from the most violent issue to the most violent issue. And you even have violent issues which won't get a police response for hours. So you have a valid point there in over-policing, and I think there's some questions of what we do there. But if we're barely able to handle the most violent crimes, let alone everything else, and we're hours between our service calls, don't we have a legitimate shortage of police here that we really need to address?
I think it's a good point around the issue of serious violent crime. Data continues to show that we would love police to focus on serious violent crime, and that's where I'd love police to focus on.
They can't focus on anything. They can't even respond.
Right, but it really brings into question what police are responding to. And if we're asking them to respond to, let's say, nonviolent things that other folks can be handling, then that allows them to focus on serious violent crime. And I think that's what we should be doing. We should be freeing law enforcement up of responsibility so that they can focus on serious violent crime and aren't necessarily responding to nonviolent issues like mental health, a crisis, et cetera. That plays into police response time. That plays into police availability. So if we're really concerned about police availability and police response time, then we will invest more in mental health and crisis and all these things that distract law enforcement from the real responsibility and their real focus as charged by the community, which is serious violent crime. And I think Baltimore City is no different as any other jurisdiction in our state.
Well, I don't think those things are a distraction to the people who are calling 911. And I just ask, we all watch the news when it gets busy and the police can't respond, and we need to be really careful about what we're doing here. But I appreciate the answers.
Delegate
Thank you,
Anderson, Delegate Anderson. Delegate Anderson, you got to unmute yourself. Oops, I think we lost Delegate Anderson.
Okay.
There he is.
I'm unmuted. I just wanted to say to Delegate Acevero, I appreciate his enthusiasm on this subject as well as many, many others. I think he's one of the examples of these young, bright legislators coming up who will be the leaders of the future. But I was concerned about something that you said with regard to impacted communities. You initially said that when asked, did the city delegation support this bill? You said the bill was supported by impacted communities. And then a second ago, when asked somewhat the same question, you said it was supported by African-American communities impacted around the country. What can you clarify that a little bit for me, please?
Yeah, sure. So what I was speaking about was the issue of over policing nationally. Black communities
so it wasn't
nationally
just
is what I was talking about.
Okay, so did you actually talk to any impacted communities?
So when I said over policing and Black communities, I'm talking about nationally as it relates to Baltimore City. There are folks who are impacted by this bill. You've heard some from constituents. You've heard from some folks with from advocacy groups who will be impacted from this.
In preparing this bill, did you actually talk to any of the community organizations that surround Hopkins or that would be impacted by this bill, either at the university or at the hospital?
Correct. Constituents, people who live in where Johns Hopkins would have the authority to police. You've heard from some of them this evening, Delegate, including advocacy groups that are in the city and
I guess I was trying to find out, did these impacted communities contact you about the bill? I mean, can you give me, because it's my district. Let me preface my remarks by saying that Johns Hopkins University is in my district, and I sponsored this bill 2 years in a row. The first year we sponsored it was 2018, I guess, and there was that argument that the communities had not been involved. And I suggested to the president, Ron Daniels, to withdraw the bill and spend an entire year putting this bill before community organizations. I know for a fact, because I went with him on a couple of them, that he went to like Greater Homewood or the ABLE Association. He went to, they went to 20 or 30 different community groups in my district alone to deal with this. And yeah, not all people in every community group agreed with it, but as Delegate Atterbury stated earlier, there was a great deal of support from community organizations in the district. That's why I'm asking you, which community organizations specifically did you talk to that felt that this bill needed to be repealed?
Yeah, so you've heard from some of the folks who live in the district that Johns Hopkins would have the authority in order to police, but also this is a sister legislation to Senate Bill 276 by Senator Jill P. Carter, also from Baltimore City. And when this bill was introduced, as you know, I voted against it, and I stated the reasons for that was the issue of over-policing, particularly in Black communities. But afterwards, being able to meet not just with advocacy group, but constituents, folks who live in this area and these communities. And so that was legislation that I decided to work on with Senator Jill P. Carter from Baltimore City on in collaboration with these advocacy groups and constituents.
Okay, to the other advocates that were here today, I got to ask you this question. I mean, we passed this bill, but as you know, as everybody listening to this broadcast knows Hopkins has not instituted the police department yet. So my basic fundamental question is, what has changed since 2 years ago that would make us want to go back on what we did? Either Dr. Furstenberg or Dr. Frazier could answer that.
Yeah, so I can speak to this a little bit because you were talking about the process by which the bill was passed and the engagement. And I teach at Hopkins, and I'm an expert on how they run things. They have an idea that they want to do. It doesn't work, and they say, we're going to listen. And so they go around, they do a listening tour. They listen to lots of complaints and criticisms, and then they ignore them and they go ahead with their idea. And they say, we've listened. This is not, I think what's changed since this happened is the national context, right? This was an ill-advised idea from the beginning, and now it's become really quite apparent politically that this is ill-advised now, and it's only getting worse. And, you know, with the Baltimore, there's been a lot of talk about the Baltimore City delegation. I mean, this bill barely squeaked through the Baltimore City delegation, with Hopkins putting all of its considerable political muscle behind it. And this is what I was talking about in my opening comments. You know, this was heavily supported by the president of the university, by the board of trustees who are behind it. But, you know, these guys are going to be gone, and you guys are going to be left holding the bag for an ill-advised idea long after they've gone. And the blowback is going to come back to you. And I think you would be doing the university a favor. Quite frankly, I think they would like to get out of the pickle they're in. They can't turn around right now. They can't lose face after putting so much investment behind this. I think you would be doing them a real favor by making it impossible for them to go forward. I think they're trying to find a way out of the pickle they're in. They can't go forward. They're stuck. They've invested all of this time and energy and capital behind it, and they would welcome, I suspect, an opportunity to get out of this mistake. It was a mistake.
I haven't heard from anybody from Hopkins saying that they wanted to get out of it. And it's ill-advised. Again, I mean, we went over this bill for 2 years, and we actually convinced Hopkins not to do it the first year because they hadn't talked to a majority of the community organizations that I thought they needed to talk to. And they listened to us. They listened to us and withdrew the bill, and then went through an entire year going to places like the Able Street Fair and the Better Waverly Community, Brewers Hill, Charles Village. I got a list of 25, 30 places where they went. Yeah, they listened.
Favorable when they went.
Delegate Anderson, if we could have a question, please. You're at your 5 minutes. Do you have a further question?
Are you being mean to me, Mr. Chairman?
I am being gently mean to you. I am also going to give Dr. Frazier, since you directed your last question to both.
Okay, I'll start
and
now.
Dr. Frazier, I'll give Dr. Frazier an opportunity to answer.
All right, but Dr. Furstenberg, thank you so much.
Yeah, I would just say, I mean, if I could just say
let
1 second.
Dr. Frazier go ahead, sir.
We'll let Dr. Frazier go ahead, please.
Okay, thanks, man.
Frazier.
So to keep it brief, 3 things that have changed. First of all, the groups you mentioned that were reached out to, it's recorded. It's recorded on their public safety website, how unfavorable all of their proposals were. And every single one of those public meetings, it was actually astounding how unfavorable it was. 3 additional things that have changed. 1, the university decided that they'd rather arrest students and community members than holding a public open meeting. That happened this past May as a result of peaceful protest, which we were invited to do by the university. Next, there was a link in the chat. I apologize, we're not supposed to use the chat, but you can see someone has already resigned from the Hopkins Police Accountability Board because it's ineffective. They also completely canceled the Student Accountability Board for police. After we were demanding that they engage community members. It's not fair that you have a student accountability board when we asked to bring community members to address the Hopkins security, that you completely shut down the accountability board. So that's incredibly concerning. Where's the accountability in that? Those are 3 things that have changed since the bill has passed, and we still don't have any accountability measures for the current security.
All right.
It must be frustrating that they can waste this much of your time on a bad idea, and the issue's not going away.
Thank you very much. We're going to go. I don't see any further questions for this panel. I don't see any further questions. Thank you for speaking with us tonight. We're to the next panel. That includes Zachary Berger, Toby Ditz, Mihir Chaudhry, Hannah Pfeiffer, and Rachel Strodel. Everybody will get 2 minutes. And we'll start. First person I see. Mr. Ditz. I'm sorry, Toby Ditz.
Yes, hi.
Miss Ditz, I apologize. Miss Ditz.
Yeah, that's fine. But I'm a Baltimore resident, been faculty at JHU for 36 years, strong supporter of HB 1284. I really do believe that the JHU Police Department is in conflict with most of the major goals that we've been working on police reform that the legislature has been working on this year. And I do think the climate has changed enormously since 2018. Baltimoreans are by every quantitative measure already over-policed, whether you measure that in terms of money expended on police per capita, compared to comparable cities, whether you talk about it, police officers per capita per 10,000 population. We are already over-policed. You know that what reformers want is to reduce the footprint of policing in favor of other routes to public safety. And many of us, will I say a majority? No, but many of us feel very strongly that we want to reduce the footprint of police in favor of other routes. And that a JHU police force really does not do that. And it does heighten the already deep distrust of JHU among many East Baltimoreans and other city residents. And if you look at the June petition signed by 6,000 people, affiliates of JHU and city residents will hold aside the alumni who might not live in Baltimore, and signed by 40 organizations, some of whom are neighborhood organizations, others of whom are campus organizations. They all want repeal, because 2020, yet you didn't really hear the full gamut of opinion in 2018, and now opinion has changed. As for accountability, so we do not think more police are going to make residents any safer, particularly Black residents, either on or off campus. As for accountability, the JHU Police Department, I believe, takes us in the wrong direction, as does any police department whose daily operations are run by a private institutions. City residents can, after all, we can vote out, we as a city group can vote out a mayor who appoints an ineffective or corrupt police chief, but neither employees or neighbors can remove a private university president, or for that matter, a corporate CEO. And despite the labor, I know the labor you put in, and I have read that bill. Okay, at some point I knew almost every line of that bill. The accountability board still gives us as residents, only indirect and weak control over the police.
Ms. Ditz, I need you to please wrap up.
Okay, all right. So I'm thinking, since we have not implemented, JHU has made little headway on implementation, let's fix our mistake before there are boots on the ground, and I urge a favorable report.
Thank you very much. Dr. Chaudhry, please.
Thank you, Chair, delegates. My name is Mihir Chaudhry. I'm a physician and public health researcher, as well as alumni of Johns Hopkins School of Public Health. I speak to you today in support of HB 1284 as a Baltimore resident, and I want to give you 3 interrelated reasons that we must repeal Hopkins' authority to establish a police force, all based on evidence. 1, it will worsen community-university relations. 2, it has the potential to hasten gentrification and displacement, particularly in East Baltimore. And 3, we know that it has the potential to inflict racialized trauma. We were speaking just moments ago on the community's position on Johns Hopkins Police. Multiple neighborhood associations near Hopkins Homewood campus, the Able Improvement Association, Greater Remington Improvement Association, Harwood Community Association, opposed near unanimously the proposal to establish a Hopkins police force from the outset. The East Baltimore campus, where Hopkins police would initially patrol, has also seen organized resistance from Douglas Homes residents. Students, faculty have repeatedly, time and again, voted to reject the idea of a Hopkins private police force, most recently garnering over 6,000 signatures from students and faculty to reject the police force. Pushing past this strong community opposition will only further alienate those living around Hopkins campuses. And further, just a reminder of history for everyone, 9 senior Hopkins officials contributed $16,000 on a single day to then Baltimore Mayor Catherine Pugh to introduce this bill, a total of $581,000 in total lobbying costs to get this bill passed, the third largest lobbying spending by any organization during that legislative cycle. This is clearly money pushing past the people's will. A police force will also has the potential to hasten gentrification in neighborhoods surrounding Hopkins. The Hopkins-led EBDI has already displaced 740 families. Studies, particularly large longitudinal studies from New York City, demonstrate the key role of policing in the early stages of gentrification in the form of order maintenance and proactive arrests, facilitating the forced removal of residents. Finally, we know all too well that police are responsible for racialized trauma.
Dr. Chaudhry, if you would please begin to wrap up.
Absolutely. This is the last point. Every marker of policing disparity, whether the daily traffic stop, arrest, non-fatal, fatal injury, is disproportionately borne by Black communities. As a violence researcher, it's really concerning that a university private police force with a lack of transparency and accountability can come into existence. Therefore, I urge you to please consider
Thank you very much.
And urge a favorable report. Thank you.
Thank you very much. Rachel Strodel.
Chair, Vice Chair, and members of the committee, my name is Rachel Strodel, and I'm a medical student at Hopkins, here to urge you favorable report for HB 1284. Hopkins says that they should have a private police because they will be more accountable than other police departments. On their website, they claim that they will lend their, quote, intellectual and moral leadership to the debate on reimagining public safety. Yet the behavior of the institution in both past and present has lacked any kind of morals or leadership. Let's start at the beginning. Johns Hopkins, the university's founder, was a slave owner while claiming to be an abolitionist. In the 1900s, Henrietta Lacks cells were taken from her body for scientific research without consent, and the university has, to this day, failed to compensate her family. In the early 2000s, Hopkins and Baltimore City forcibly displaced over 700 majority Black households in order to build a biotech park that never materialized. And let me quote a resident talking about the impact of this. They said they were tearing down houses all around us and they didn't give us any warnings. It's no mystery why the medical campus is called the plantation by residents today. The private police would only perpetuate this plantational relationship between Hopkins and East Baltimore. Today, the university hasn't listened to those who are against having a private police, including, again, those 6,000 constituents. Hopkins disbanded the accountability board meant to hold the private police to a higher standard, citing the 2-year pause. And it's confusing to many of us as to why Hopkins is using this 2-year pause as also a pause on receiving feedback. There have been no avenues for community members to share their opinions besides an online contact form, yet despite claiming this 2-year pause, conversations about the JHUPD are still happening, as evidenced by the VP of Security appearing before the General Assembly to testify against the repeal. Do you really trust an institution like this to be accountable once they have an armed police force? I certainly don't. Please repeal this bill. Thank you.
Okay. That concludes the testimony. Are there any questions for this panel? Delegate Erican.
Thank you, Mr. Chair. My question's for Dr. I can't see your whole name, Chaudhry. You had mentioned the lobbying money, and I know that there has been comments, at least on the JHU sit-in, that insinuate that some money has come to me and other people of this group. I just want you to know, none of us received a penny. I certainly did not during the last lobbying effort, not since then, and not on this bill, not a single penny. So are you aware of that? Did you actually look into who got money?
Well, I can share, the article with you. Is a lot of great investigative journalism that demonstrated that total amount being spent. I don't know exactly who the individuals receiving that money is, but I can offline share that information with you.
Well, I would love to see it because it didn't come to us. Thank you very much, Mr. Chair.
Are there further questions for this panel? Seeing none, thank you very much. Now hear those in opposition to the bill. Kevin Cleary, Scott Connor, Regina Gale Malloy, May Mendoza, Samuel Red, and Dolores Sanchez. Now hear those in opposition to the bill. See Mr. Cleary. And Mr. Cleary, you have 2 minutes to testify, 2 minutes. But you have to unmute yourself first. Kevin Cleary. You got to unmute yourself, Kevin Cleary. There we go.
Thank you.
2 minutes. 2 minutes to testify. And you have to turn off your.
Just did, sir.
All right.
Mr. Chair, Madam Vice Chair, members of the Judiciary Committee, thank you for allowing me to testify. My name is Kevin Cleary, and I live 1 block from the Hopkins Homewood campus. I'm testifying in opposition to House Bill 1284 and 336. I know from firsthand experience, both professional and personal, how unsafe the neighborhoods are around the university's campus. This is a problem that cries out for a community-first solution. This is exactly the approach that Hopkins has taken by including the community in extensive deliberations about the police department for several years. I recognize as a country, we are now in a moment of unique and long overdue reflection about the role of police and the efficacy of law enforcement to combat crime. Those conversations are important, and I am very supportive of any effort to bring greater accountability, transparency, and rigor to our law enforcement agencies. I know that officers and community members can work together in the fight against crime. Our city can be safer if we allow officers and residents to build the bonds that will help strengthen our neighborhoods. That's why I oppose these bills. They would throw out the entire police department before it even has a chance to get started. They would eliminate years of hard work and prematurely prevent the university from creating a model police department that could serve as an example of what is possible. In the authorizing legislation, the state would require a 10-year sunset provision, after which the university's police department would be reviewed and the legislature would need to vote to authorize the extension of the department. That is the time to review the department, not now. Give it a chance to succeed. I urge you to vote no on House Bill 336 and House Bill 1284. Thank you.
All right, we'll go to Scott Connor, or Connor Scott. It is Connor Scott. I'm sorry, I transposed it. Connor Scott.
No problem. Good evening, Mr. Chairman, Madam Vice Chair, members of the committee. I do have formal testimony, but I'll actually save that for House Bill 336. I wanted to take this opportunity just to respond to some of the things that we heard today. First of all, I appreciate and share many of the concerns with those on the panel. And there certainly are legitimate concerns with policing as it currently exists in our country. And of course, those are being addressed heavily in this session. But as you know, and we've talked about, all of these concerns were mitigated as much as possible through the Community Safety and Strengthening Act. And the facts around that are pretty clear. We've heard about police oversight, but what the legislation created is a situation where any future Johns Hopkins Police Department would actually have more oversight than any public police department, certainly those operating in Baltimore City. Dozens of police departments operate in Baltimore every day from the local, state, and federal level. The JHPD would be accountable to the Baltimore City Civilian Review Board. Of course, we've heard about the Accountability Board, which is very much unique. We would be beholden to the MPIA, which is essentially unheard of for police departments funded by private institutions. The JHPD also does not have state immunity protections that apply to state municipal police departments in Maryland. So we would be responsible for all costs that come out of, basically we own all liability surrounding incidents involving our officers. And we, of course, have paused the creation of the police department to observe what passes in terms of police reform. In terms of community meetings, absolutely. I know that we went to 28 different communities, some of them multiple times. And I meet every day with stakeholders across Baltimore. I'm the current interim vice president for security, and I'll always engage in conversations around public safety. We have, for the most part, really completely paused meetings on the police department just because we have halted that work at this time, but I'll absolutely engage on any meeting around public safety. And of course, I've met with Dr. Frazier many times. Dr. Frazier, if you're still watching, congratulations on the PhD. I don't know that we've met since you earned your degree. But yeah, over 125 meetings with community, students, faculty, staff, and that list is available online. And certainly people are mixed. There are hundreds who are opposed to it, but you have to keep in mind, we have between
Mr.
4,000 and
Scott,
5,000. members. Yes, sir.
Mr.
I'll wrap
Scott, I
up
need you
here.
to wrap up, please.
Yeah, absolutely. And then just in terms of the community funding, we would never walk away from that. Even after this bill was written, we dedicated $6 million additional dollars towards community public safety initiatives. And we also serve as a founding member of the Greater Baltimore Region Integrated Crisis System, which is a $45 million investment in expanding behavioral health crisis services. So that's not a concern. And then just to mention that—
Mr. Scott, you've got to wrap up, please.
Thank you.
Thank you very much. All right, go to Regina Gale Malloy, please, for 2 minutes.
Good evening, everyone. My name is Regina Gale Malloy, and I work at the Johns Hopkins Hospital in East Baltimore, but also live in downtown Baltimore, just 3 blocks away from Lexington Market. And I'm speaking this evening to express my opposition to both House Bill 336 and House Bill 1284 that would eliminate the Johns Hopkins Police Department. As a single woman who lives under the threat of crime every day, living in Baltimore City and working in East Baltimore, I have to voice my strong opposition to this bill that would repeal the Johns Hopkins Police Department. I have witnessed firsthand how community policing can be done right. I live it every day. My home is within the jurisdiction of the University of Maryland, Baltimore Police Department. And in 2018, I attended their 6-week Community Engagement Academy. Participating in that academy completely changed the way I see the police. Since that time, I have become an advocate for community policing because I know that policing can be done right. I have seen it, I live it, and I will continue to advocate for it. Crime in East Baltimore is a real concern. When I'm leaving the East Baltimore campus in the evenings, I have to be hypervigilant due to regular robberies that occur. And when I speak with my colleagues about this, they agree with me that the problem is real and it requires a comprehensive solution. To repeal the Johns Hopkins Police Department before it's even allowed to form is not just a mistake, it's a step backwards in addressing crime in East Baltimore. Opponents of the police department argue that we don't need more police. However, I would argue that we need the right police. Allow Johns Hopkins the opportunity to develop a police department that works for our entire community. I urge this committee to oppose House Bill 336 and House Bill 1284 and issue an unfavorable report. Thank you.
Thank you very much. We're going to go now to May Mendoza, please, for 2 minutes. Oh, wait, May Mendoza is not in the waiting room. We'll go to the next person. Samuel Redd.
Good evening, Mr. Chairman and Madam Vice Chair and Honorable Committee. My name is Samuel Redd, and I am here this evening to strongly oppose this bill of repealing 336 and 1284. For all of my life, I've been a resident of Baltimore City, working in Baltimore City in many ways, but in the last 25 plus years, working as the director of Operation Pulse, which is a faith-based crime prevention program in the East Baltimore community. Also a business owner in Baltimore City with my family for many 50 some years. I've seen how crime can affect and hurt people in Baltimore City in many ways. Johns Hopkins having a police force and with all the work that's gone into this bill with Johns Hopkins would only be an added tool to help our community be safer. I heard someone earlier talk about over-policing. Well, we're being overwhelmed with crime in Baltimore City. And I hear people talk about the fact that taking funding, well, things like the PAL centers and the working in the community, especially community policing, all these things are completely necessary in keeping crime down in our city and making our city a safer place. We work hard every day, and we worked hard, and I went to many community meetings. And I think it's an insult to those people who worked and went with Johns Hopkins and from the community, from all other entities, to go to spend a lot of time in community meetings, hearing things on both sides, getting beat up on budding and seeing our city delegation support this, and then all of a sudden hearing and seeing someone try to take this from us. I heard Delegate McComas say earlier about students who will come here for 4 years or so and then leave. Well, we're here. This is our city. We're not going anywhere. This is our city, and we want our city safe. So I oppose this bill, and I ask that you look favorable upon opposing this bill also. Thank you.
Thank you very much. Dolores Sanchez, please.
Good evening, Mr. Chairman and members of the committee. Can you hear me okay?
Yes.
Okay, great. For the record, Dolores Sanchez of Ficalche with Cornerstone Government Affairs, representing Johns Hopkins in opposition to House Bill 1284. After thousands of hours of legislative and community debate, discussion, and deliberation, in 2019, this body passed legislation to provide Johns Hopkins authorization to create a small police force. I will point out that the committees of jurisdiction spent hours in bill hearings listening to testimony. The bill was extensively debated on the floor of both chambers. The components of the bill were amended and vetted. It was passed with only 2 nay votes in the Senate and an overwhelming majority in the House. When the law was passed, the legislature had the foresight to include a sunset provision. This provision requires that the Legislative Policy Committee review the effectiveness of the law prior to 2027. If it's deemed undesirable in any way, there are mechanisms in place to modify the law or eliminate it entirely. Our opposition to this bill is straightforward. We ask this committee to stick to the course that it's set. The university has not yet had the opportunity to implement some of the very well thought out and vetted components of the legislation that was passed just 2 years ago. Legislation that aimed to create the most progressive police department in the country, embodying many of the reforms that are now being held up nationally as gold standards for policing, with bold commitments to transparency, accountability, oversight, and community engagement. For this reason, we ask the members of the committee to vote unfavorably on House Bill 1284. Thank you.
Thank you. Are there questions for the panel? Delegate Griffith.
Thank you, Mr. Chair. I'll be very brief. And this is for the 3 community members on the panel, whoever wants to answer this question. The supporters of this bill have stated that there's not a great deal of community support for this, and I'm sure we're going to hear that on the next bill. Could any one of you speak to what you've experienced as the level of community support for this?
I believe I can. I live in a condominium building 1 block from Hopkins Homewood campus, and the majority of my neighbors are strongly in support of a Hopkins Police Department. They were pleased to hear that I was testifying in opposition to the bills that would repeal it. I know that there are many community association members around Hopkins that are not in support, but the people that I've spoken with, the people that I know in Charles Village, are strongly in support of a Hopkins Police Department, which means they are opposed to the bills in front of us tonight.
All right, thank you very much. Delegate Grammer.
Thank you, Mr. Chair. I'll also be brief. Question, or I just wanted to solicit a comment from Ms. Gale, Mr. Red, and Mr. Cleary. So in Baltimore County, I don't care what, I have 20 or 30 community associations in my district, and they all operate from a community policing based model. And, you know, in places like Dundalk and Edgemere and Essex, we really support police, but these meetings are not necessarily the most pretty unicorns and rainbows. You know, it's tough. Police are coming and they're talking about the crime in our area. Sometimes it's violent. You're soliciting feedback from people. Sometimes it's just speeding. Sometimes it's break-ins. Sometimes it's emotional. And sometimes people are angry. And frankly, sometimes people are angry at the cops. And they're saying, what are you going to do to fix this? So it's not always this pretty thing, and we get that, but that's the nature of community policing. I wanted to see if I could ask you, because I rarely get an opportunity to talk to folks from the city in my official capacity. You know, do you want to have, the question I have for you is, do you want to have the staff of police that is sufficient to not only attend your local meetings, but to actually respond and take action on these crimes? Because what we continually hear is that the people of Baltimore City, they don't want more police. They want to defund the police. And I just want you to, like, let's get at the core here and let's hear from you. What do you want?
I would say that we definitely want the police at the meetings. We want to hear from the police. We want more police. We want as many police as we can get to keep our community safe. But we also want professional police that go back, take our concerns, listen to what we have to say, and address them in a proper manner. Don't just write it down at a meeting, say we heard it and it's done. We want to see where and bring it back with results. That's what we want to see and hear, not just talk and listen, but results.
And if I could add to something that Delegate McComas said earlier, when a call from Hopkins comes out, it's 3400 North Charles. We need officers that know where to go exactly on the campus and not find their way around. And then also something that was brought out earlier, I worked for the Washington-Baltimore high-intensity drug trafficking area from 2003 to 2007. I went to hundreds and hundreds of community meetings all across Baltimore, white neighborhoods, black neighborhoods. People want public safety. And right now, we need more officers in this city that are well-trained and properly supervised. So as Ms. Regina said, people don't feel safe as they're going about doing their jobs. They should be. We owe that to ourselves as residents of Baltimore to have a safer community. And we think the Hopkins Police Department will move us in that direction.
And if I could just briefly add to what Kevin said, we want to know our police. And that's what I have where I live, to get to know who they are and for them to get to know who we are. That's community policing. That when the police shows up, we know, oh, there's Sergeant Johnson, or there's Lieutenant James. And that's where we have the sense of community, not just coming in and out of a meeting and to give a report, but when we see them walking their beat, we know them and we can speak to one another. That is possible. You have already passed the bill to have the police department form. Allow it to form so that we can have this to work. We need it.
I think there's a lot of value in what you're saying, particularly what Miss Gale said. And I sympathize a lot with that. You know, our community liaison, every community gets one. I have the number for my guy in my phone. Do police attend your community meetings? You sound as if you don't know who your guy is. They do.
In the Seton Hill community, I'm a part of the Seton Hill Community Association. Yes.
Okay. All right, thank you very much. I really appreciate the comments. I think there's a lot of value there.
All right, thank you very much. Seeing no further questions for those in opposition, that completes the testimony for House Bill 1284. We're going to move now to House Bill 336 with Delegate Ivey. Delegate Ivey will have 3 minutes to testify, followed by Colin Bilyeu, Toby Ditz, Zachary Berger, Hannah Pfeiffer. We'll hear from them, and then we will go through the remaining people who are here to testify in favor of Delegate Ivey's bill. I see Delegate Ivey, and we'll begin with him, and 3 minutes, Delegate Ivey. Go ahead.
Thank you, Mr. Chair, and to the entire committee for all the work that you all do. Colleagues, for the record, Delegate Julian Ivey here presenting House Bill 336. This legislation would repeal the law passed in 2019, authorizing Johns Hopkins to form their own privatized police department. We've heard from dozens of members of the Hopkins community in written testimony, and full individuals who testified orally as well, who opposed their campus from having a privatized police department. I'm proud to stand with them, Delegate Acevero and Senator Carter, and the other individuals who also oppose this police department. But this legislation goes one step further by also proactively prohibiting private higher education institutions across the state from establishing their own private police departments. Aside from Johns Hopkins, there are 19 other accredited private institutions of higher education in Maryland. Amidst national and local conversations about police reform, we must take the necessary steps to restore the public's trust with the already established police departments that we do have across the state, rather than allowing for privatized police departments to be established at these private higher education institutions. Today, I'm joined by a sponsor panel that will speak directly in opposition to JHU's authority to establish their own private police force. These citizens will voice their concerns about police accountability and reform more broadly, but their testimony will also speak to the power dynamic and the lack of transparency between these private institutions and the residents of those overlapping communities. And I ask for a favorable report on House Bill 336. Thank you, Mr. Chair.
Thank you very much. Thank you, Delegate Ivey. I'd like to kind of expound on something that Delegate Ivey said. These two bills have some similarities. I encourage witnesses on this legislation to talk. We've heard the testimony specific to Johns Hopkins. I'd like to hear more specific testimony about this and the difference between this and that bill. So with that gentle admonishment, and happy to hear from you in any case, Colin Bilyeu, we'll start with you.
Hello all, my name is Colin Bilyeu and I'm an undergraduate at Johns Hopkins University. Myself and the Coalition Against Policing by Hopkins are here today to ask that you stand by the principles for which you claim and return a favorable report for Bill HB 336. The predominantly Black communities surrounding Hopkins and the Black members of its student body will face the primary effects of the violence of policing. The summer has made clear that increasing the police presence in those communities is the opposite of desired, as evidenced by the petition which garnered over 6,000 signatures alongside countless surveys of Hopkins affiliates, and bound to increase the already present racial disparities, as evidenced by a plethora of studies on the impacts of policing. If Hopkins is truly a good neighbor, it would follow the clear directives and petitions of those living where it occupies and abandon completely its efforts to institute a presence which will inevitably harm its neighbors. Universities haven't and won't, so now the onus lies on you to carry out your constituents' will and ensure their safety. We shouldn't have to plan for when Hopkins or other universities and their police commit murder, but should this bill fail, it will only be a matter of time, and the slaughter's blood will be on your hands too. Hopkins may claim reforms will make police safe and effective, but history and the study conducted by Warden McLean show us that reform and accountability amount to no change. Body camera reforms were instituted in 2006, and nearly a decade later, the ACLU unveiled that 109 human beings in Maryland died at the hands of police wearing those very cameras in a mere 4-year span. In that group, there are more than 10 unarmed people and nearly 20 Black people murdered each and every year. Tyrone Must was murdered in 2013, in part by a university police officer under reform measures. There is no version of a private police that does not end up in disproportionate violence and death for those residing near the campus or the campus of Hopkins. They already face extreme policing. There's no need to exacerbate the issue. However, this violence will not be limited to Black and brown community members surrounding the universities. This summer, Hopkins security called BPD on a student having a mental health crisis on campus. Thankfully, the student had calmed down by the time police arrived. Should Hopkins have had a police force, they would have responded with potentially deadly force before the student had calmed down. Yet, with no police present, de-escalation by Hopkins' already existing security resolved the situation safely. Clearly, the presence of those police makes us all less safe, simply to varying degrees. The police will make nothing safe but universities' property and image. Your report on this bill will show which you prioritize, property and image or the lives of your constituents. Policing and its severing of ties and economic opportunity clearly does not beget safety. More cops don't reduce crime. Violent reduction programs like Safe Streets and removing financial preconditions for crime does. Hopkins has already promised. Programs like the Minority Inclusion Agreement, which Hopkins promised in 2002 and is yet to fulfill, would solve preconditions for crime and create the very safety that universities claim they desire through destabilizing police force. They haven't attempted nonviolent safety strategies. In the meantime, it is on you to prevent violence being enacted in the name of safety.
Thank you very much. All right, I see Toby Ditz. We'll go there.
Yes, I'm not going to repeat my testimony from last time. I did run long. I apologize. And if I sounded a little temperamental, it was only because there was a little bit of an implication that those of us who support HB 336 and the other bill hadn't taken seriously the history of this legislation and don't interact with communities. We do. And I've actually worked quite hard on police reform through the consent decree and other processes. All right. So I only am going to make one point over again, which is that I think that if what we want to achieve is greater accountability in a city as complex and big as Baltimore, that multiplying the sheer number of police departments of any kind in the hands of the day-to-day operations, in the hands of private institutions or other forms of special police force within a city like Baltimore makes it much more difficult to exert effective oversight and accountability. And I would rather put my eggs in the basket that includes a mayor, a reformed Baltimore police force with all the apparatus of the consent decree and a watchful city council and everything else. That's where I feel we need to put our energy to create constitutional policing plus alternatives to police. When you multiply the number of police forces, it just physically and in every other way makes the job more difficult. I can talk about what it means to have to work as a resident with 2 accountability boards or 3 rather than 1, and with several different players rather than 1. And that's all I want to say. I really want the city to be better. I'm very sympathetic with what some of the opponents to the bill said about feelings of safety and residential integrity. I am sympathetic with that, but I support the repeal of the JHU police force before there are boots on the ground. Thank you.
All right, some of the people I recognized before are not in the waiting room. So we're going to go to some of the next people, at least who are on my list. We'll go to Abigail Koch, who actually testified on an earlier bill. It's possible she's back here for this one. Rachel Strodel, Sean Hare, Dr. Furstenberg, Francois Furstenberg. Let's go ahead and bring them in, and we'll hear from them as well, and then we'll take questions. Abigail Koch. I see you, Dr. Strodel. We'll go with Rachel Strodel first, and then we'll go from there. 2 minutes, Rachel Strodel.
Sure, I'm not quite doctor yet, but I'll take it.
It's a matter of time. It's a matter of time.
All right, my name is Rachel again, and I am a second-year medical student and resident of the 46th District, here to urge favorable support for HB 336. I'd like to say that I'm also here on behalf of members of the Baltimore Redevelopment Action Coalition for Empowerment, or BRACE, which is a longstanding organization in East Baltimore that I've been connected to since last spring. Hopkins often points to its peer institutions like Yale and Penn that have private police forces and say, why shouldn't they? Well, as an undergrad, I attended Yale University, where I saw how unsafe private police forces are. During my freshman year, a Black student was held at gunpoint by a Yale police officer and ordered to the ground. After the student was released, a suspect was arrested. The university and police acknowledged that the student who was detained endured a deeply troubling experience, yet an internal investigation by the university did not find that the officer did anything wrong. A year after I graduated, local police and Yale police fired 16 shots at Paul Witherspoon and Stephanie Washington, 2 unarmed Black community members, for, quote, exiting a vehicle in an abrupt manner. The New Haven Police Department officers were also present. The Yale police officer was never charged. In just 4 years, the Yale police gave me plenty of examples for why private police are a dangerous idea, especially in Baltimore, which is one of, again, the most over-policed cities in the country. And do I really need to remind you that in our own state, Tyrone West was choked to death by a Morgan State police officer just 8 years ago? Private police forces are dangerous, and Hopkins has done nothing to prove its own force will be any different. A recent report on racist and violent behavior by JHU security officers that has not been addressed by the university does not inspire confidence that their police will act any differently. I'm demanding that you repeal the JHU private police authority and all private police authorities in Maryland, lest the blood of future victims of police violence be on your hands. Thank you.
All right, thank you very much. We'll go now, I believe Francois Furstenberg is here, so we'll go ahead and hear from him.
Hi again to everyone. Thank you for having me back. I won't repeat the testimony that I made a few minutes ago. I've been listening to what people have been saying, and you passed this bill in 2019. That was initially proposed a year earlier. That was 3 years ago, and now it's on a 2-year pause. And so I guess I would just ask, if this is such a great idea, if it's such a model for the nation, why hasn't it started? And I think I know why. I think the reason is that it's crumbling under the weight of its own contradictions. A private university simply cannot create a model police department. It's not the job of a university. Universities do other things. They teach history, they develop vaccines. Creating a model police department is the job of city and state governments. I really sympathize with the situation you're in. I really do. I'm on a number of university committees, and I often find myself in the same exact situation. There's a bad idea that's been pushed through with sheer political muscle, and it just wastes an enormous amount of other people's times. people want public safety. That's clear from hearing what people have been saying. They want officers walking the beat, but they want officers who are accountable to them as citizens, not to a private university's board of trustees that doesn't even live in the city or the state. If this was the right answer, it would be happening already. The accountability board would be in existence, it would be robust, and instead it's frozen with its members having quit. The whole thing is in shambles, and so I think it's time to put it out of its misery. I respectfully ask the committee for a favorable report on HB 336.
Thank you very much. Are there questions for this panel? Seeing none. Delegate Williams, Delegate Nicole Williams.
Sorry. Sorry,
No,
Mr.
don't be sorry. It's all right. Delegate Nicole
Late on the
Williams.
draw there. So just really quick question, because I was going through all of the written testimony we received on this. A lot of it is from, I think, folks in Baltimore, students at Johns Hopkins, faculty members at Johns Hopkins. I guess my question is for Delegate Ivey, but this bill, will this bill also apply to all of the universities, say University of Maryland, College Park, Salisbury University, Bowie State, Frostburg? Will this bill apply across the board? And did you receive any comments from folks from any of those other institutions in support of the bill? Because I didn't see any, and from what I could tell in the written testimony that was filed.
Sure. Thank you for the question, Delegate Williams. This piece of legislation, House Bill 336, specifically focuses on private institutions. And as for why there is not more support coming from other institutions, it's a hypothetical, it's a theoretical discussion.
Got it. Because College Park's a state school, Frostburg's a state. Okay. Understood.
Well, more so the private institutions that don't have their own privatized police department that's been authorized by the state. You don't have a group of students that have been working around this issue already because it hasn't come to their campus yet. Just to answer your question.
Okay. All right. Thank you.
Thank you.
All right. Thank you very much. Delegate Cardin now.
Thank you, Mr. Chairman, and very briefly to Ms. Strodel, the med student, or the soon-to-be doctor.
Sure.
Thank you for your testimony and for the late time that you guys have spent on this. You'd said that in your testimony that you didn't think Hopkins demonstrated any signs of policing or showing that they're going to police or not over police, and that they haven't learned. I don't know exactly what you said. I was going to write it down, but I didn't have a chance to.
Mm-hmm.
But in their MOU and in the legislation that passed, they're required to basically set up best practices based on proper policing from around the country. And they have to put together all these different types of demonstrations that they're doing everything that can model good policing to the entire country, be used as a model for everywhere else.
Mm-hmm.
How you can say that they haven't done it when we haven't even given them a chance to prove that they're going to actually be a model for what we're trying to accomplish across the country?
Sure, that's a fantastic question. I think where I am hesitant to even give them the opportunity to do that is when I look at, first of all, how they have behaved in not holding their own security officers accountable for enacting violence against students. How they have, when we look at the accountability board, that's a fantastic example. So the accountability was set up and they held one meeting, and then the university ended that particular accountability board, given this 2-year pause that they're claiming on the private police force. Now, I understand that there's a 2-year pause on the private police force, but I don't exactly understand why there should be a 2-year pause on accountability. Does that make sense? And I also think that there's also kind of some discrepancies that we've seen from university leadership regarding what is actually happening with this private police bill. So we've heard testimony from other community members and students who have tried to reach out to university administrators to give feedback regarding the status of the private police, and students have been told that there are no conversations happening about the private police, and yet Vice President Connor Scott is showing up to these legislative sessions to testify against the repeal. And so there seems to be a discrepancy between what the university is telling us regarding where things are with these conversations, and what we are kind of seeing with the university's actions. And so for us, that does not inspire confidence that a private police force would be transparent and accountable to the community. And you can imagine that, if we're talking about an armed police force, why we might not even want to give them the opportunity to not be transparent or accountable. Does that make sense?
I mean, I understand where you're coming from. I just sincerely disagree that if we're trying to figure out how to reform our policing in our state and across the country, and we're being given a model by one of the top academic and intellectual institutions in the world to say we want to try and be the place that's going to prove that we can show you guys how to do this right. And we said, okay, we're going to give you a chance. And now you're saying, well, we don't want to give them a chance now that, we want to take it away before we even have an opportunity to see what they're going to propose. They have not done one thing wrong yet. I understand that you want better communication. That's a different issue than getting rid of legislation that took us a lot of time and money to pass 2 years ago.
I hear you.
Better communication. Maybe we ought to start with let's use our ability to communicate through the legislature to make sure that you're getting the proper information you need, but not penalize them for doing what we think could be the best thing in the world.
Mm-hmm. Could I ask, are you familiar with what was happening with the Minneapolis Police Department prior to George Floyd's murder?
I hate to break in here, but sadly the questions are one-sided.
I see. Okay.
That's the questions. And I apologize for that. And I understand that this is part of a back and forth, we try very hard not to do that. So I apologize for that. I think Delegate Cardin is finished. Delegate Conaway now has a question.
Mr. Chairman, thank you everyone for coming in. Ms. Strodo, can you tell me what was happening shortly before George Floyd's murder in whatever's Minneapolis?
Fine. Totally fine.
Certainly can. So it's my understanding that the Minneapolis Police Department had undergone a effort to reform its police department, and that those efforts did not prevent the murder of George Floyd. And so that is all I wanted to add to that. And so I think as it relates to Johns Hopkins, I think I personally, as a medical student, we learned to kind of look pretty deeply at the literature, and I have not seen evidence that that there are any police reforms that have a very strong evidence base for changing policing fundamentally to not be a public health threat. I would love it if someone.
Thank you very much.
Thank you, Delegate Conaway. Are there further questions for this panel? Seeing none, thank you all very much for speaking with us this evening, and thank you very, very much for sticking with us this evening. We're going to hear from the final people who are in the waiting room to speak in favor of the bill. Andrea Frazier, Dr. Mihir Chaudhry, Lydia Pecker, and Bethany Hung. So we'll hear from those four people, and then we'll move to the opposition. So Dr. Frazier, please, for 2 minutes. Are you here?
Thank you for your time. Delegate Cardin, you mentioned time and money. Correct me if I'm wrong, but didn't you actually pay BPD to fake raid your boat for a wedding proposal? Correct me if I'm wrong. And also in regards to the late Elijah Cummings coming before the delegation to call on people to support this bill. In that statement, he called people in the hospital at 4 a.m. riffraff, and you can run the tape back to confirm this. And that
what I'm not going to do.
I'm sorry, wait a minute. No. We're going to stop right here. We're going to stop right here.
Congressman Cummings, who is passed away. That's unacceptable for everything that he has done for the city and for this country.
Madam Vice Chair, please. I'm going to ask Dr. Frazier that you speak to the bill. You can speak to
the bill because late Delegate Cummings endorsed the bill on the grounds that we needed it for riffraff in the hospital at 4 a.m. And my point is that That's exactly the mentality that leads to violent policing and what we don't want. What about anything we've detailed about Hopkins or any other private institution would make you think that the officers will be well trained and supervised by Hopkins? That's already not what's happening. Why isn't community policing already happening with Hopkins Care and Security? That's what we're calling attention to. Regina Gale, who just spoke in opposition to the previous bill, actually works for the president of Hopkins Hospital and did not disclose that in her testimony. So that's incredibly disingenuous not to disclose that you directly work for the president of the hospital. And I think anyone testifying on these bills or in this committee should be disclosing the funds that they've received. It should not be on us to uncover this information. We know that the head lobbyist of Hopkins is married to the Department of Legislative Services, so there's a lot going on here. They have yet to honor the minority inclusion agreement that we've discussed and has severely damaged people in Middle East Baltimore and East Baltimore community. They've been obligated to pay this fund and they haven't. You're talking about state funds that would be removed if we repeal this legislation. That's your job to make sure that the funds still get there as it's state money. So it's not on us to come up with amendments. I think it's y'all's job to make that happen. Connor Scott, yes, we have met since I got my degree. And that was the first meeting that you allowed for community members to be present at. And even you stated in that meeting that you hope that there's no JHU police in 2 years because we want to see a world that's better than that. I think a lot of people can hope for a world that's better than policing, to be honest with you. So we're already looking at an ineffective model. It's insulting to us that people can have the record of recorded many times community meetings of significant opposition where people are saying we want community driven safety and you are hearing that we want community policing, we want community driven safety. So I see I'm about to get cut off here and those are my comments. We would again are looking for the reports of the numbers of emails and calls that you've received on these bills and any disclosures.
Thank you, Dr. Frazier.
And thank you.
Thank you very much. All right, we'll hear now from Dr. Chaudhry, then Ms. Pecker and Ms. Hung.
Thank you, Chair, delegates. Again, my name is Mihir Chaudhry. I'm a physician as well as a violence researcher and a Johns Hopkins Public Health alum, Baltimore resident. So I want to speak a little bit about evidence. We all want evidence-based policy, right? So let's look at the evidence that shows how policing is responsible for racialized trauma, and it's an institution that has its historical roots in slave patrols, right? So large-scale epidemiological studies demonstrate that Black men have a 1 in 1,000 chance of being killed by police over their life course. That's probably an underestimate because police aren't required to report publicly fatal shootings. That's a number 2.5 times greater than for white men, right? And the contention that university campus police are trained differently, this is not borne out in experience, right? As they receive the same training as city police. Further, according to the Bureau of Justice Statistics, 81% of colleges have patrol and arrest jurisdictions in neighborhoods adjacent to college campuses, with 70% having agreements with local authorities to police beyond campus. What does this result in? Let's look at Maryland's history alone, right? These are just public institutions. We're not even extending this to private institutions yet. Rachel already mentioned July 2013, Morgan State officers involved in the death of Tyrone West, an unarmed Black man. June 2015, University of Maryland, Baltimore officers involved in a fatal shooting. December 2016, Coppin State officers fatally kill a civilian. January 2017, a Morgan State University officer involved in a non-fatal shooting, right? These incidents span campuses, campus police across Maryland, right? This is why we don't want boots on the ground. We don't want this getting worse, and we don't want it getting worse in a non-accountable fashion. Finally, this point, according to Justice Department data, and this is really important, required by the Clery Act, between 2004 and 2011, between these school year, this time span, college campus violent crime went down 27%. College campus property crimes decreased by 35%. It was following this decline that we see substantial increases in sworn officers and an increase in equipping these officers with firearms, pepper spray, and military-grade equipment. There's no causal relationship. What there is a causal relationship between based on violence prevention.
Dr. Chaudhry, if you would begin to wrap up, please.
Yeah, just wrapping up here. Well, we see a causal relationship, and this is the evidence, folks. Let's try to follow the evidence in making policy. Violence intervention programs, targeted social services, and public housing policies decrease violent crime and property crimes. Thank you.
Thank you very much. Lydia Pecker, please, for 2 minutes.
Good evening. My name is Dr. Lydia Pecker, and I'm going to read my remarks asking for a favorable report on Committee HBO 336. I'm acutely aware of the safety issues in Baltimore as I live here with my family, and I'm a doctor on the Hopkins faculty. We moved to Butchers Hill to be near the Hopkins Medical Campus, and I walk from our home on East Pratt Street to work, to pick up my daughter on North Chester Street and home again. I opposed the Hopkins police force the first time, and I am mystified that anyone continues to support it. The video captured murders of innocent Black men and women have uncorked an essential reckoning with police violence in America, and I am dismayed that my representatives, Chair Clippinger, Ms. Learman, and Mr. Ferguson, seem to continue to support the Hopkins force even when Hopkins seems to be reconsidering their plan. This problem cannot be swept under the table with a 2-year pause, and the time to end the prospects for an armed Hopkins police force is before someone gets killed. At Hopkins, I care for brave young people with sickle cell disease who are mostly Black. My patients travel to Hopkins for essential care, and I am alarmed by the possibility that they may meet an armed police officer and that this encounter would end as we have seen encounters end like this all over the country. Why are we creating more opportunities for violence? I want a just peace. I do not want private police who are unaccountable to the public. I do not want more guns in our community. Instead of spending resources to outfit and ensure an armed police force, I want spending on creative solutions to the city's profound safety issues. The Hopkins leadership should use the skills and expertise at the School of Public Health to create programs that enhance safety for all. This will require the leadership to work harder, more thoughtfully, and more sustainably to build durable, authentic partnerships with neighboring communities. The Hopkins police force offers a false promise of safety to the privileged few at the expense of the many. We know better as a society, and I believe you also know better as a member of this society than to imagine that an armed private police force will make us all safer. The proposed force is undemocratic, it is threatening, and it should not be allowed to move forward now or in the future. Thank you for your time, and thank you for your service.
Thank you very much. Bethany Hung, please, for 2 minutes.
All right, members of the Judiciary Committee, my name is Bethany Hung. I am a medical student at Hopkins, and I am here today to urge you to support House Bill 336. So let me tell you a story. The Hopkins East Baltimore Medical Campus, where I go to school, is in a Middle East neighborhood where the private police will be deployed. Of Baltimore City's 55 neighborhoods, Middle East has the 10th highest rate of mortality from heart disease, and it's only getting worse. So you might be wondering, why is the cardiovascular mortality rate so high in a neighborhood with a world-famous elite medical institution? Well, research tells us that gentrification and displacement can lead to trauma that contributes to heart disease. 20 years ago, Baltimore City partnered with Hopkins and used eminent domain to seize 3,000 properties for a revitalization project. They would create 8,000 new jobs and transform a blighted neighborhood into somewhere that felt safe and welcoming for its hospital employees. This rhetoric is the same coded language Hopkins has been using to justify its private police. It turns out that revitalization meant displacing and traumatizing 750 mostly Black families, and safer really just meant whiter. As of 2012, only 70 families have been able to return. There is no affordable housing. And as of 2019, they've created 20% of the jobs they promised. House demolition also had direct health sequelae, including asthma, lead poisoning, and heart attacks. This only builds on a legacy of Hopkins' anti-Black violence. There's slave labor, Henrietta Lacks, the experiment where Hopkins non-consensually exposed Black children to lead paint to see what would happen. Yes, Hopkins poisoned children, then 10 years later, tore apart their neighborhood. Hopkins has actively destabilized this community, and this police force will only deepen these wounds. If they truly cared about safety, they would invest into the community. They would give back everything they took and keep taking. We cannot heal through violence. A dear friend and community leader recently told me, Hopkins has displaced, gentrified, and ignored the community. What they've done is displacement while pretending their concern is about the community. So who is this revitalization really for? Who will the private police protect and who will they kill? As a Hopkins medical student, I ask you to stand for your neighbors' health and safety and return a favorable report on 336. Thank you.
All right, thank you very much. Other questions for this panel? Seeing none. Thank you all very much for coming and testifying here this evening. I'm going to hear now for the opponents to the legislation. I'm going to hear now from Kevin Cleary, Connor Scott, Regina Gale-Malloy, Leon Purnell, Samuel Red, Dolores Sanchez, Mendoza, and Christopher Talent. I'm calling all of the witnesses. We're going to see who is still here. It's 9:25, and we'll go ahead and we will go from there. All right, who do we see? All right, Mr. Cleary, I think, is in the room. Mr. Cleary, are you ready?
Yes, I am. I believe I'm off mute.
All right, off you go. 2 minutes.
In the interest of time, I won't reread the letter that I gave in the last hearing, but just want to report that prior to testifying in support of the Community Safety Bill in 2019, I crunched the crime data that's available through Open Baltimore for the police posts that I see Hopkins students that are jogging, working, living around me. And in that 1 year's period, there were more than 1,000 violent crimes in the areas that are frequented by the Hopkins students. That's one reason why I support a Hopkins Police Department. And also my younger son is on campus as a grad student in those areas that come across that could intersect with that violent crime that occurs. So I wish to repeat my opposition to the bill in front of us today and urge that the committee members vote to not support the repeal of the police department for Johns Hopkins. Thank you.
Connor Scott.
Good evening again, Mr. Chairman, Madam Vice Chair, members of the committee. Thank you for the opportunity to testify today, or tonight really, in opposition for House Bill 336. Again, I'm Connor Scott, the Interim Vice President for Security for Johns Hopkins University and Health System. The mission of the security organization is to promote and maintain a safe and secure living, learning, and working environment for our students, faculty, staff, clinicians, patients, and visitors. Sadly, as you know, violent crime remains a persistent threat in the city of Baltimore, and we recognize that we have both the opportunity and responsibility to help our city and community address crime on and around our campuses, which of course does include the Johns Hopkins Hospital, where we serve thousands of patients every day. The process in the Community Safety and Strengthening Act for establishing a small university-based police department is built on a foundation of community involvement, a commitment to the highest levels of accountability and transparency, and very much embraces the principles of 21st century policing. We absolutely plan to go above and beyond following the specifics and spirits of that approach. But above all else, we do agree that it's important to build the department correctly rather than build it quickly. As important as the development of a police department is, it will always be a fraction of our security organization and our overall commitment to public safety in Baltimore. Along those lines, we continue to think of how we can leverage our resources and expertise to support the city leadership's broader public safety agenda.
Mr. Scott, if you would begin to finish your comments, please.
Yes. Blocking the department before it has even begun would abandon years of hard work of community members and legislators, and would continue to overburden the Baltimore Police Department while leaving Johns Hopkins without a viable solution for addressing the very serious threat of violent crime that the city faces every day. On behalf of Johns Hopkins, I do urge the committee to reject House Bill 336. Thank you.
Thank you very much. Regina Gale Malloy, please.
Good evening once again. I'm not going to repeat my testimony, but I did want to ask the committee to please oppose House Bill 336 for very much the same reasons that I stated in the first bill. And if you have any questions, I'm open to receive them.
All right. Dolores Sanchez.
Good evening, Dolores Sanchez Ificalche with Cornerstone Government Affairs, representing Johns Hopkins in opposition to House Bill 336. You've heard my testimony on House Bill 1284, which is generally similar. I will not reiterate all of my testimony as the hour is late. I will note, however, again, that in the original legislation that authorizes the police department, it has a built-in sunset. It would sunset the bill and the authority. So I just wanted to share that once more and request an unfavorable report. Thank you very much.
Thank you. Christopher Talent.
Sorry. So I just want to be clear, I am favorable to the bill. For some reason, I'm on the wrong panel.
All right, well, let's do this. Let's take questions for the unfavorable, and then we'll come back to you.
Thank you so much.
That's totally fine. All right, there were further people to testify. Samuel Red, May Mendoza, Leon Purnell. However, we do not see them signed in anymore. Does anyone have any questions for these people who are testifying today? Could I ask, I'm going to ask Mr. Scott about the community panel. Is there a reason why the community panel, I mean, I understand that the university has decided to stop and to take a pause with regard to the Hopkins police, but isn't this the opportunity at this point to actually engage with the community more? Wouldn't this be a good time to continue the work of the community panel?
Sure, yeah, and we absolutely have not cut off any conversation with the community. We continue to meet with community organizations regularly, as well as students, faculty, and staff. The Accountability Board specifically is statutorily tied to the establishment of the police department. So in terms of the law, it actually would be in conflict if we had continued running the Accountability Board. And it also would have been in conflict with the principles of our pause, where we decided to take a break from developing the department. So while the Accountability Board itself has been put on pause, but will obviously be restarted once any work begins towards the department, the conversations certainly haven't ended.
Personally, I think that the Accountability Board should continue to be engaged during this time, not shut down. That is my feeling. Are there any further comments or questions for this panel? Seeing none, thank you very much. We'll go now to Mr. Talent, who was the last person now to testify. He'll get 2 minutes. He is in support of the legislation and was wrongly labeled. Mr. Talent, go ahead.
Thank you so much. I want to thank the committee and Chairman Clippinger. My name is Chris Talent. I'm a Baltimore City resident and an alumni of Johns Hopkins. I'm here to testify in support of 336. I'm here to stand in solidarity with my Black and brown friends in the city. Johns Hopkins University absolutely should not have the power or authority to have its own private police force. Residents do not trust Hopkins to have more power. Hopkins kicked out nearly 800 families around its medical institute to gentrify the neighborhood. Hopkins has pursued bankrupting medical debt lawsuits against its least well-off neighbors. Now, after an entire national movement against increased policing in the wake of the murder of George Floyd and other victims of police, JHU wants its own private police force. Hopkins seems to think they can just wait out calls for racial justice. I think that is incredibly shameful. Addressing these very legitimate causes of distrust of Hopkins, not talking about the idea of giving Hopkins more unaccountable power, is what we should be talking about. Hopkins is not looking out for the safety or well-being of its neighbors in Baltimore City. It is looking out for its own power. Baltimore residents did not ask Hopkins for a private police force, and Baltimore residents I know do not want a private police force. Hopkins is an increasingly politically toxic institution to be associated with. And in closing, I want to lift up the words of a friend of mine who is an historic resident of the East Baltimore community in Middle East. Here's what he said, quote, "A major concern not only for the historic Middle East community adjacent to Hopkins for the private police, there has never been such a level of disrespect, and not good for the safety of Black people. And not good for the safety of Black people. I urge you to stand with the people of Baltimore City, not Johns Hopkins, its money, its army of lobbyists, and its demand for a private police force, and support HB 336. Thank you so much."
Are there questions for Mr. Talent? Seeing none, that concludes the testimony on House Bill 336. Thanks to everyone who has come to today.
Mr. Chairman.
Committee, we are done for the evening. That's the last piece of legislation that we will hear. We will be back tomorrow on a day which will have over 100 witnesses again tomorrow. If you you can go online and see the bills that we will be addressing tomorrow
Chairman.
online. Delegate,
I know this is way out of order. I really do apologize.
I'm sorry. Is it a question about the bill that the hearings?
No, it's about Elijah Cummings, sir. Say something very briefly.
I think I would rather.
Understood.
It
absolutely.
I think we're going to stop right here.
Thank you, sir.
Thank you very much. I appreciate your sentiment. All right. that concludes the testimony today for the House Judiciary Committee, and we will see you again tomorrow. Thank you very much.